Section 1 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Introduction. In most of the states of the Union, from a very early day, the proceedings of the Courts of Appeal have been reported with great fullness and accuracy. At first this came from private enterprise, but within the last quarter of a century, nearly all the states have themselves taken up the publication of these decisions. But from the beginning the proceedings at the trial have been neglected, and because the trial takes place in the inferior courts, very little is preserved of the case except what goes to the appellate courts, which tribunals devote themselves almost entirely to the consideration of questions of law. The state itself has in no instance published its trials, either civil or criminal, and the only reports of these cases are the work of private persons who have occasionally, in pamphlet form, given to the public the proceedings, the evidence, and the speeches of counsel. Volumes of new reports of appellate decisions are being annually poured out by all of our states with such rapidity that few lawyers can find leisure to read 1/100th, or means to buy 1/10th of them. But they are exclusively for the bar, and deal only with questions of law and the technical working of the case, and little is to be found in them to interest the general reader or to commend them to the great body of the people. And the labours of private law publishers have been bestowed entirely upon law reports, treatises, digests, and commentaries, the circulation of which is limited to the professional reader. No effort has been taken to preserve in a permanent form a faithful and accurate record of the proceedings at the trial before the court and the jury. To supply this deficiency in American legal reporting, this series has been undertaken and will be continued until all the important criminal trials which have taken place in the United States, from the first settlement of the country to the present time, and of which it is possible to obtain a correct and accurate report, have been presented to the profession and the public. The object of the editor and publishers of this important undertaking is to make it a complete record of American state trials, to be contained in 20 volumes. Judicial investigations with a view of discovery and punishment of crime, as they involve the highest interests of society, always excite an attention commensurate with their importance, wherever they are publicly and openly conducted, as they are in this country, in England, and in some of the European states. They exhibit human nature in an infinite variety of positions and show man as he is. Events and transactions more wonderful than anything to be found in works of fiction become realities in the proceedings of criminal tribunals. A criminal trial is a drama of the highest interest and usually crowds the courtroom in which it is held. Reports of criminal trials which occasionally appear in the newspapers are read with eagerness by the public. It is doubtless more thrilling to see the actual trial than to read about it in a newspaper or book. Nevertheless, great trials excite the curiosity and are valuable long after the scenes they profess to describe have passed from the memory of the spectator. And it is possible to supplement the report of the trial and illustrate it by surrounding facts, of which the spectator even would be ignorant. The American state trials will be a welcome addition to the library of every lawyer and judge, for the reason that it will duplicate nothing that is on his shelves, and that it will never get out of date. The value of this series to him will be first in the principles of law laid down by the judge in the particular case, and the rulings on evidence and procedure. Then the arguments of counsel and the orations of the advocate for the prisoner and for the state will give him a mine of eloquence from which to gather material for his own use. Then the investigation of facts is always more interesting and often more important than the investigation of abstract principles, and the bar is required to do quite as much of the former as of the latter. Our most distinguished advocates have earned their highest honours by their addresses to the jury. But to others beside the judge and lawyer this work will have an almost equal value. The writer and the reader of history will find here abundant material for study and investigation. Just as in the state trials of England, the English historian has found a never-failing source of material in writing the history of his country, so the American historian of the future will find in this series a record of the lives, the customs and manners of the American people, which has hitherto been closed to him. The sociologist and the criminologist will likewise find opened before him new phases of human life. Burke long ago spoke of a criminal trial as, quote, exhibiting human nature in a variety of positions, at once most striking, interesting, and affecting. The scientific investigator will note the contrast between the manners and customs of the people and the public opinion of the time, in the days when witches were burned at the stake, and in the days when a woman can scarcely anywhere be convicted of a homicide, even of the grossest character, in the days when a minister of the gospel was indicted and tried for saying in a sermon that slavery is contrary to the Bible, and in the days when a contractor is tried for preventing a Negro from breaking his contract and leaving his service, in the days when men were hanged for burning a house, and the days when the same crime involves no greater punishment than to be, after conviction, paroled on good behavior. There is no better way for one who wishes to familiarize himself with the habits and customs of a particular epoch in the history of his country than to familiarize himself with the judicial trials of the time and place. Lastly, to the general public this series will certainly appeal as the most interesting and instructive work which has been published in this country for many years. The trial of judicial causes has even more charms than biography and history, for it is a drama of real life. We enter the halls of justice, the judges and jurors are before us, the criminal is brought in, we behold him surrounded by an eager and excited populace, the whole scene passing before the mind's eye as a living and moving picture. There is nothing in the Grecian drama that surpasses, in touching pathos, scenes in the trials and prosecutions of these men and women, sometimes innocent and sometimes guilty, but always awaiting with trembling the verdict of the jury, which is to send them back to their families and friends, or to the scaffold or prison. Here are the poor and ignorant confronted with their accusers, but relying upon their advocates. There, the rich and powerful surrounded by a host of counsel and braving even the power of the government to convict them. Sometimes the mere report of the evidence in the case and the verdict gives a complete picture of the crime and criminal, but in most cases the full dramatic effect cannot be shown in a narrative, but stands out broadly and as vividly as the actual trial, when the witnesses, the counsel, the judge, and the prisoners are suffered to speak for themselves. In many cases, the great points of interest are the eloquent arguments at the bar by the advocates, and in this collection will be included all the great forensic efforts which have been made in trials in all the states by the orators and leaders of the American bar from the beginning of American courts down to the present time. When it is considered how prone our people are to litigation, what a vast number of causes are decided every year, how eagerly the public attention is directed to many of them, what an amount of learning and talent are centered in the legal profession, greater perhaps than any other, how fond American people are of attending courts, and especially the magnitude of many causes that are tried, it is extraordinary that there should not have appeared up to this time in the country a series of American state trials. In England, this field has not been neglected. It is covered by that great work, Howell's State Trials, which begins the historical trials of England with the trial of Sir Walter Raleigh for high treason in the Great Hall at Winchester in the first year of James I, 1603, and ends with the trial of the Cato Street conspirators in the first year of George IV, 1820, in 33 volumes. And this series is continued in the State Trials, new series begun in 1830 and published under the direction of the government by the State Trials Committee. France, too, in its great collection Causes Célèbres, as the English nation has done, but in the United States, as has been pointed out, there being no official reports of criminal trials, the profession and the public have known nothing of them except where the case had a local or national interest, and the newspaper of the particular town or city, or the press generally reported the proceedings. Sometimes, where the trial had gained wide attention, private persons reported in pamphlet form the proceedings, and to collect these fugitive pamphlets has been the work of the editor for many years. Most of them have become very rare, and are to be obtained with great difficulty. It is a matter of surprise that there is no American publication entitled to take its place with the State Trials of England and the Causes Célèbres of France. To fill this want, the editor, after years of preparation, investigation, and research, presents the first volume of this series, which is to be known as the American State Trials. Such a work, of course, is possible only after years of investigation, research, and study. For nearly a decade, the editor has been engaged in the collection of works upon criminal law and criminology in all of its phases, one branch of which is the report of criminal trials. He has in this time been able to gather together one of the largest collections in this particular field to be found in the United States, and which is constantly increasing in size and value. This special library was made possible through the generosity of its founder, William Keeney Bixby, will be known as the Lawson Library of Criminal Law and Criminology, and will become the property of the Law School of the University of Missouri. The material for this collection of American state trials comes from the following sources. First, the pamphlet records of cases which in their day excited great interest and which were issued by private individuals, purchased at the time by an interested public, but soon after mislaid, lost, or destroyed. Occasional copies of these get into second-hand bookstores and are eagerly seized by collectors. The Lawson Library is particularly rich in these pamphlets. The only other two libraries in the country which can compare with it in this respect are the Harvard Law School Library and the Congressional Library at Washington. Second, the newspaper reports of the time. Until a few years ago, many of the American newspapers gave very accurate and lengthy accounts of the notable current trials where the public interest was great. This is still done in England, but seems to have disappeared from American journalism, whose custom at the present day is to pick out only the sensational points in a trial and leave out everything else. Third, the records of the trial and the evidence and briefs which are found either in the circuit or appellate courts. The library possesses already many copies of these records which have hitherto been unpublished and inaccessible to the profession and the public, and it will continue to gather them until it shall embrace a complete collection of the great trials of America in both the state and federal courts. The books and pamphlets contained in the Lawson Library, when referred to in this work, are marked with a star. The series will contain not only cases before the ordinary courts of justice, but proceedings before courts-martial, legislative bodies sitting as courts of impeachment, and ecclesiastical tribunals, and it will include also trials where breaches of the law are in issue, though the state is not an actual party, as for example actions for divorce, for assault and battery, for libel and slander and the like. It has not been thought desirable to print the trials in chronological order, as reports of new cases are constantly coming to light. A table of cases in the order of their dates will, however, accompany the last volume of the series. The editor requests the cooperation of members of the bar who may have taken part in criminal trials of importance and interest, or who are in possession of reports of any trials which have not been discovered by him or are not at present in his library. His object being to make this collection as complete as possible, he will be grateful to anyone who will give him information on the subject. Even a partial report of a case or the speeches of counsel would often be available and would be much appreciated. J.D.L., University of Missouri, Columbia, Missouri. End of section 1.
Section 2 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of Levi Weeks for the murder of Gulielma Sands, New York City, 1800, Part 1. The narrative. Elias and Catherine Ring, Quakers, lived in Greenwich Street near Franklin Street, New York City. Their family consisted of Hope Sands, Mrs. Ring's sister, Gulielma, Elma Sands, her cousin, two young men, Russell and Lacey, boarders, Levi Weeks and his apprentice, also boarders, and some other boarders. Weeks was a brother of Ezra Weeks, a respectable and wealthy citizen, who was originally a carpenter. Weeks was very intimate with Gulielma, called Elma by the witnesses, and she had confidentially informed Mrs. Ring and Hope Sands that she and Weeks were to be privately married. On the evening of Sunday, December 22nd, 1799, Elma left the house about 8 o'clock for the purpose, as the two other women understood, of being married, but she never returned. 2 days later, on the 24th of December, a muff which she carried was found by a boy in the Manhattan Well, which was situated in Lisperons Meadow at a point now reached by an alley running from Green Street and not far from Spring Street. Curiously enough, this clue was not followed with any energy until a week later, when the body was recovered on January 2nd, 1800. There were marks indicating that the unfortunate girl might have received rough treatment, but the tears in the dress and the bruises and abrasions were not of a conclusive character. The distance from Ring's house to the well was about half a mile. The body was taken from the well to the ring house and was laid there out for some 3 days, and on one day was exposed to public view in the street, when crowds came for the purpose of looking at it. On January 6, the grand jury brought in a verdict of murder by a person or persons unknown, and 4 days later indicted Levi Weeks, a young builder and carpenter of excellent character and standing, as the murderer. The trial began on March 31st, 1800, in the old City Hall at the corner of Wall and Nassau Streets, afterwards the site of the Sub-Treasury. The court was composed of Chief Justice Lansing, Richard Barrett, the mayor, and Richard Harrison, the recorder of New York. The prosecuting officer was Cadwallader Colden, Assistant Attorney General, but probably no other person tried for a felony at any time or in any part of the country has had such eminent counsel as Weeks had. They were Brockholst Livingston, afterwards a judge of the Supreme Court of the United States, Alexander Hamilton, and Aaron Burr. Mrs. Ring and her sister testified to Elmo leaving the house in the evening. They thought, with Weeks, though neither of them was positive of this, that she was in good spirits when she left, that Levi returned about 10 o'clock looking pale and much agitated, and that, when asked the next day, he denied that he knew anything about her. There was evidence that a sleigh with 2 men and a woman in it was seen near Manhattan Well on the night of December 22nd. Several witnesses were called, whose testimony went to show the probability of Levi's having used his brother's sleigh on the evening of the 22nd. Others stated the hearing of cries of murder in a female voice near the well about 9 o'clock, but nothing very precise or satisfactory was established on those points. The medical testimony was to the effect that the marks on the body of the woman might have been produced by violent means. For the defense, the good character of Levi was shown by a number of witnesses, and there was strong evidence of an alibi. That Weeks could not have been at the well at the time the girl must have been thrown or jumped in. And there was evidence that Elma was pregnant, and that she had declared more than once that she would kill herself. The evidence closed at 2:30 in the morning, and the court having refused an adjournment, the counsel on both sides declined to address the jury, and the Chief Justice, having charged strongly in favor of the prisoner, the jury returned to the court in 5 minutes, with the verdict of not guilty. It is safe to say that up to that period no crime had ever produced in New York such an excitement as the murder of Miss Sands. For many years afterwards, it was a never-ending topic of conversation, and it was more or less talked of even to this day. Theodore Fay's novel, Norman Leslie, published originally about the year 1833, and afterward republished, embodies several of the incidents of the story under fictitious names. The public was not satisfied with the result. Weeks found himself proscribed, and soon after disappeared from New York. One writer describes the crime as a terrible tragedy, and the trial as almost a farce, and criticizes the Chief Justice very strongly for having practically taken the case from the jury and directed an acquittal, while another and later writer says, "To anyone who reads the report, it is obvious that no other verdict was possible." The prosecution failed to show that Weeks had gone out with Elma Sands on the 22nd of December, and the defense proved an alibi for Weeks on that evening, so complete as to put any participation in the murder, on his part, practically beyond the bounds of possibility. 3 actors in this interesting drama, known to the New Yorkers as the Manhattan Well murder, within a few years suffered an unkind fate. Alexander Hamilton was killed in a duel with Aaron Burr, his associate counsel. The act drove Burr from his native land, and he became an exile for many years. And 30 years after the trial, Chief Justice Lansing left his hotel in New York for the Albany steamboat, and was never afterwards heard of. The trial is also remarkable as having produced a curious historical myth which it took nearly a century to explode. The trial. Footnote. Bibliography. Reported the trial of Levi Weeks on an indictment for the murder Gulielma stands on Monday, the 31st day of March and Tuesday, the 1st day of April, 1800. Taken in shorthand by the clerk of the court. New York. Printed by John Freeman and sold at his blank stamp and stationery shop, opposite the City Hall, 1800. This is without doubt the best report of the case. William Coleman, 1766 to 1829, the reporter, does not place his name on the title page but signs the preface. Alexander Hamilton took down the testimony on the trial, and the manuscript, on 54 closely written pages, was in existence 40 years ago and is probably still preserved. See Harper's Magazine, May 1872, page 925. From this manuscript, Coleman's report was largely made, for they were close friends. In 1801, Coleman was selected by Hamilton and other party leaders to conduct a new Federalist daily in New York City, and was its sole editor for 20 years. In 1804, he published a collection of the facts and documents relative to the death of Major General Alexander Hamilton, with comments, together with the various orations, sermons, and eulogies that have been published or written on his life and character, by the editor of the Evening Post, William Coleman, octavo, pages 238. In his preface, the author states, "In the death of Hamilton, I have lost my best earthly friend, my ablest adviser, and my most generous and disinterested friend, and all that is now left me is to pour forth my gratitude in unavailing sorrow and to evince my regard for his memory by defending it against the cruel attacks of those who, not content with having deprived him of his life, seem bent on pursuing him beyond the grave and destroying his fame. This is the fullest and most accurate contemporary account of the famous duel, as well as the events and correspondence which led up to it. It is now very rare. Coleman was for a short time a partner of Burr and a reporter of the Supreme Court of New York. In the preface to his report of the trial, Coleman says, "I cannot help noticing two pamphlets which have already appeared, both pretending to exhibit a correct report of this trial. The first is published by one Longworth, and was in print a few hours after the trial was over. This man has seized with avidity upon the moment, when public curiosity was alive, and if we may credit his own avowal, without regard to anything but remuneration, he has published just such an account as might naturally be expected from a man acting from such motives. I should not have descended to notice this paltry performance here, had he not put it off by the insinuation of a falsehood. It has been trumpeted around the streets as the whole trial of Levi Weeks, taken in shorthand by a gentleman of the bar. Although he may feel a present gratification from the success with which the artifice has been attended, yet it is hoped he will find in the end that the public will not easily forget so gross an imposition. The other appears under the name of James Hardy, and is fairly suffered to find its sale in booksellers' shops, without the aid of imposture. But in his statement of the testimony, he has involved some of the witnesses in positive and material contradictions, where in reality there were none. This may be accounted for from the unfavorable situation in which he sat to take his notes, as well as from some other circumstances not irreconcilable with the most innocent intentions. But surely a conscientious man cannot but feel some degree of uneasiness that he has done a thing in the face of the public, at once so injurious to truth and to the individual who is affected by it. These remarks are made with some reluctance upon the man, who, I am told, has a considerable share of literary merits. Coleman's report is very scarce. There are 2 copies in the Congressional Library, both imperfect, lacking several pages, and one copy in the Harvard Law School library. Longworth's and Hardy's reports are not to be found in any library catalog. And a footnote. In the Court of Oyer and Terminer, New York City, March 1800, Honorable Chief Justice Lansing, 1754 to 1829. Footnote. A member of the New York Assembly and afterwards of Congress, Speaker of the New York Assembly, Mayor of Albany, a member of the Federal Constitutional Convention, not the New York Convention that ratified it. In 1790, he became a Justice of the Supreme Court of New York, and in 1798, Chief Justice, and in 1814, Chancellor of the State. He was the compiler of Lansing's selected cases in Chancery. One day in 1829, he mysteriously disappeared, having left his hotel in New York City to post a letter on the Albany boat. He was supposed to have been either robbed and murdered or drowned. End of footnote. Honorable Richard Varick, Mayor, 1752 to 1831. Footnote. Soldier in the Revolutionary Army and Washington's recording secretary. He was from the evacuation of New York by the British until 1783, recorder of that city. He then became Attorney General and from 1791 to 1801 was Mayor of New York. End of footnote. Honorable Richard Harrison, Recorder, 1758 to 1841. Footnote. Consul at Cadiz, United States Auditor under President Washington and Recorder of the City of New York. End of footnote. Cadwallader D. Colden, Assistant Attorney General for the People, 1769 to 1834. Footnote. Studied law in New York and London, England. Became District Attorney of New York in 1810 and Mayor of New York in 1818. End of footnote. Alexander Hamilton, 1757 to 1804. Footnote. Born in the West Indies and was educated there, and after a short time in a counting house removed to New York in 1772. Was one of the great minds of the Revolution. Washington made him his first Secretary of the Treasury. His brilliant career was ended by the unfortunate duel with Burr. End of footnote. Henry Barcholtz Livingston, 1757 to 1823. Footnote. A graduate of Princeton, served in the Revolutionary War, practiced law in New York from 1783 to 1802, when he was made a judge of the state Supreme Court. In 1807 became an Associate Justice of the United States Supreme Court. End of footnote. Aaron Burr, 1756 to 1836. Footnote. Soldier, lawyer, and statesman, a lieutenant colonel in the Revolutionary War. Afterwards studied law in New Jersey and was admitted to the New York bar in 1782. A leader of the bar with no rival except Alexander Hamilton. In 1791 was elected to the United States Senate, and in 1800 became Vice President of the United States. His duel with Hamilton, in which the latter was killed, took place July 7, 1804. In 1807 he was tried for high treason, and though acquitted, his good name was not restored, and he soon left the country, refused for some time permission to return to the United States. He came home under a false name in 1812. Shunned by society, though with a considerable practice, he lived 23 years longer in New York. End of footnote. Hamilton, Livingston, and Burr for the prisoner. March 31st. Proclamation having been made in the usual form, the prisoner was placed at the bar. 34 jurors answered to their names. The clerk, Levi Weeks, prisoner at the bar, hold up your right hand and hearken to what is said to you. These good men who have been last called and who do now appear are those who are to pass between the people of the state of New York and you upon your trial of life and death. If therefore you will challenge them or either of them, Your time to challenge is as they come to the book to be sworn, and you will be heard. Several Quakers on the jury asked to be excused as they had scruples of conscience in a case of life and death, and they were excused by the court. The prisoner challenged 11 jurors who were set aside. The Assistant Attorney General challenged one but did not persist after he had shown his qualifications. The following jurors were sworn: Garrett Storm, Simon Scherpenhorn, Robert Lilburn, George Greiber, Richard Ellis, James Hunt, John Rathbone, William Wilson, William G. Miller, Samuel Ward, William Walton, and Jasper Ward. The clerk: Gentlemen of the jury, the prisoner at the bar stands indicted for the murder of Gulielma Sands. Footnote: City and County of New York. Multiple sections. The juries of the people of the state of New York, in and for the city and county of New York, on their oath present, that Levi Weeks, late of the 7th Ward of the city of New York, in the county of New York, labor, not having the fear of God before his eyes, but being moved and seduced by the instigation of the devil, on the 22nd of December in the year of our Lord 1799, with force and arms at the ward aforesaid, at the city and county aforesaid, in and upon one Gulielma Sands, in the peace of God, and of the said people then and there being, feloniously, wilfully, and of his malice aforethought, did make an assault, and that the said Levi Weeks, then and there feloniously, wilfully, and of his malice aforethought did take the said Gulielma Sands into both the hands of him, the said Levi Weeks, and did then and there feloniously, wilfully, and of his malice aforethought, cast, throw, and push the said Gulielma Sands into a certain well, there situate, wherein there then was a great quantity of water, by means of which said casting, throwing, and pushing of the said Gulielma Sands into the well aforesaid, by the said Levi Weeks, in the form aforesaid, the said Gulielma Sands in the well aforesaid, with the water aforesaid, was then in there choked, suffocated, and drowned, of which said choking, suffocating, and drowning, the said Gulielma Sands then and there instantly died. And so the jurors aforesaid upon their oath aforesaid do say that the said Levi Weeks heard the said Gulielma Sands in the manner and form aforesaid, feloniously, wilfully, and of his malice aforethought, did then and there kill and murder against the peace of the said people and their dignity. And the jurors aforesaid, on their oath aforesaid, do further present that the said Levi Weeks, not having the fear of God before his eyes, but being moved and seduced by the instigation of the devil, on the same 22nd day of December in the year of our Lord, 1799, with force and arms at the same 7th Ward of the city of New York, in the county of New York aforesaid, in and upon Gulielma Sands in the peace of God and of the said people, then in their being feloniously, wilfully, and of his malice aforethought, did make an assault, and heard the said Gulielma Sands, then and there feloniously, wilfully, and of his malice aforethought, did strike, beat, and kick, with his hands and feet, in and upon the head, breast, back, belly, sides, and other parts of the body of her, the said Gulielma Sands, and did then and there feloniously, wilfully, and of his malice aforethought, cast and throw the said Gulielma Sands down unto and upon the ground, giving unto the said Gulielma Sands, then and there by the beating, striking, and kicking her, the said Gulielma Sands, in the manner aforesaid, several mortal strokes, wounds, and bruises, in and upon the head, breast, back, belly, sides, and other parts of the body of her, the said Gulielma Sands, of which said mortal wounds, strokes, and bruises, the said Gulielma Sands then and there instantly died. And so the jurors aforesaid, upon their oath aforesaid, do say that the said Levi Weeks, her, the said Gulielma Sands, in manner and form aforesaid, then and there feloniously, wilfully, and of his malice aforethought, did kill and murder against the peace of the said people and their dignity. End of footnote. He has been arraigned, pleaded not guilty, and is now to be tried by his country, which country you are, so that your charge is, gentlemen, to inquire whether the prisoner at the bar is guilty of the felony whereof he stands indicted, or is not guilty. So sit together and hear your evidence. Assistant Attorney General Colden. In a cause which appears so greatly to have excited the public mind, in which the prisoner has thought it necessary for his defense to employ so many advocates distinguished for their eloquence and abilities, so vastly my superiors in learning, experience, and professional rank, it is not wonderful that I should rise to address you under the weight of embarrassments which such circumstances actually excite. But, gentlemen, although the abilities enlisted on the respective sides of this cause are very unequal, I find consolation in the reflection that our tasks are so also, while to my opponents it belongs as their duty to exert all their powerful talents in favor of the prisoner as a public prosecutor. I think I ought to do no more than offer you, in its proper order, all the testimony the case affords, draw from the witnesses which may be produced on either side, all that they know, the truth, the whole truth, and nothing but the truth. If I had the power of enlisting the passions and biasing their judgment, which those opposed to me possess, I should think it unjustifiable to exert it on such an occasion. Levi Weeks, the prisoner at the bar, is indicted for the murder of Gulielma Sands. He is a young man of reputable connections, and for aught we know, till he was charged with this crime, of irreproachable character, nay, of amiable and engaging manners, insomuch that he had gained the affections of those who are now to appear against him as witnesses on this trial for his life. These are circumstances greatly in his favor, and there is no reason to fear that they will not be urged with all their force. We are aware that you will not convict such a one of the horrid crime of which he is accused, upon less than the utmost evidence that the nature of the case admits, and that you will not readily be convinced that one so young has already imbrued his hands in blood of the innocent. The deceased was a young girl, who till her acquaintance with the prisoner was virtuous and modest, and it will be material for you to remark always of a cheerful disposition and lively manners, though of a delicate constitution. We expect to prove to you that the prisoner won her affections, and that her virtue fell a sacrifice to his assiduity, that after a long period of criminal intercourse between them, he deluded her from the house of her protector under a pretense of marrying her, and carried her away to a well in the suburbs of this city, and there murdered her. Footnote: here the speaker suddenly stopped a few seconds as if overpowered with his emotions. End of footnote. No wonder, gentlemen, that my mind shudders at the picture here drawn, and requires a moment to recollect myself. I will not say, gentlemen, what may be your verdict as to the prisoner, but I will venture to assert that not one of you, or any man who hears this cause, shall doubt that the unfortunate young creature was found dead in the Manhattan well, was most barbarously murdered. Elias Ring and Catherine his wife keep a boarding house in the upper part of Greenwich Street. The deceased was a distant relation of theirs who lived with them. Hope Sands, a sister of Mrs. Ring, and Margaret Clark lived in the same house. In July last, the prisoner was received into the house as a boarder. Upon his first coming for about a month, he showed some attention to Margaret Clark, but soon after was observed to attach himself in a very particular manner to the deceased. Their conduct soon led to suspicions in the family that there was an improper intercourse between them. In the month of September, Mrs. Ring fled from the fever, leaving the care of her house to her husband and the deceased, and leaving in it also the prisoner and some other boarders. Mrs. Ring remained out of town about 6 weeks, and in that time it is certain that the prisoner and the deceased lived together in the most intimate manner. On the 1st of December last, the deceased disclosed to Hope Sands that on the next Sunday she was to be married to the prisoner, but at this time, and whenever afterward she spoke on the subject, enjoined on Hope the strictest secrecy, forbidding her to tell even Mrs. Ring, saying that Levi hoped to keep their marriage a secret, even from her, Hope, and therefore that no one should go with them to see the ceremony performed. Between this time and the time of her departure from the house, it will be seen she frequently spoke of her approaching marriage, and always with cheerfulness and a lively pleasure. On Saturday, the 21st of December, the day before the fatal accident, Hope disclosed the secret to Mrs. Ring, informing her that Elma was to be married the next evening. On the Sunday about dinner time, Mrs. Ring discovered to the deceased that she knew her intentions. The deceased, you will find, then confessed that she was to be married, and that the prisoner was to come for her that night at 8 o'clock. Mrs. Ring pressed the deceased to be of the party, but she said Levi would not consent, as he meant to keep his marriage a perfect secret from all. In the evening the deceased began to dress herself, in which Mrs. Ring assisted her. The deceased appeared perfectly cheerful all this time. She put on her hat and shawl, and went to a neighbor's and borrowed a muff, which she promised to return in a little time. She also took up a pocket handkerchief belonging to one of the boarders, saying she should not make use of it and would return it before it was missed. You will have evidence that the prisoner had left the house of Mrs. Ring about 5 o'clock in the afternoon, and that about 8 o'clock in the evening the deceased stood leaning over the front door, looking out, that Mrs. Ring desired her to come in, saying she did not believe that Levi would come, to which she answered she did not fear, it was not yet 8. But she left the door and went in with Mrs. Ring, and in a little time the prisoner returned, and came into the room where Elias Ring, Mrs. Ring, the deceased, and 2 boarders by the names of Lacey and Russell. Mrs. Ring sat with them about 5 minutes, when she got up and went to the street door, and leaned over it till Lacey and Russell went upstairs to bed. She then left the street door, shut it after her, went into the room again, and was hardly seated when the deceased went upstairs. Mrs. Ring immediately followed her, found her in the room above, pinned on the shawl for her, and after being with her not more than 2 minutes, left her in the room opposite the stairs, just on the point of coming down. Mrs. Ring returned to the room below where the prisoner was. In about a minute he took up his hat, and as he opened the room door to go out, Mrs. Ring heard somebody come lightly down the stairs, and, as she supposes, meet him at the bottom. She then heard 2 voices whispering at the foot of the stairs for about a minute. She then heard the street door open and immediately shut. She took a candle and went to the door to look after them, but it was dark, and so many people passing, that she could not distinguish anyone. The street door, you will find, opens with a great and remarkable noise, in consequence of its being out of order. Gentlemen, it will be necessary for you to pay particular attention to this part of the evidence, for if you believe that the prisoner, at this time, went out of the house with the deceased, I do not see how he can be acquitted. After Mrs. Ring shut the door, it was not again opened till the time when she supposes the prisoner and the deceased went out. We shall show you that there were no other persons in the house till 10 or 11 o'clock, but Elias Ring, who remained in the common sitting room, and the 2 lodgers, Lacey and Russell, who we shall prove to you lodged together, and were not out of their lodging room from the time they went upstairs. From this time the deceased was never after seen till her corpse was found in the Manhattan well. She had the marks of great violence upon her, and a great part of her clothes were torn off. We shall produce a number of witnesses who, between the hours of 8 and 9 of the evening of the 22nd of December, heard from about the place of the well the voice of a female crying murder and entreating for mercy. It will be shown to you, gentlemen, that there was the track of a single-horse sleigh, which we shall prove that at some time between the Saturday night before and Monday morning succeeding must have come out of Greenwich Street, and passed in a very extraordinary manner near the brink of the well, that the snow round the edge of the well was much trodden, and that the sleigh, after having made a curious turn or stop near the well, must have passed on to the Broadway road, and in coming into that, turned towards town. We shall show you that on the evening of the 22nd of December, soon after the deceased left her house, she was met a few hundred yards from her house in the way towards the road that leads to the well, in company with two men, that a few hundred yards further on, and about the same time, a single-horse sleigh was seen with two men and a woman in it, the horse of a dark color and without bells, passing on towards the road or street which leads from Greenwich Street to the well. Our next testimony will be to prove to you that a number of young gentlemen riding for pleasure on the same evening, as they were coming into town, between 8 and 9 o'clock on the Broadway road, when they were some distance nearer to the town than the place where the track of the one-horse sleigh was discovered to have turned into Broadway road, were overtaken by a single-horse sleigh, which passed them with the horse on a full gallop and without bells. There were two men in it, and the horse was dark-colored. We shall then show you that Mr. Ezra Weeks, the brother of the prisoner, was the owner of a single sleigh and a dark horse, and that the prisoner had access to it when he chose, and we shall produce to you such testimony as we suppose will satisfy you that this horse and sleigh was taken out of the yard of Ezra Weeks about 8 o'clock in the evening of the 22nd of December, and was returned again into the yard in less than half an hour. You will see, gentlemen of the jury, that we have only circumstantial evidence to offer you in this case, and you must also perceive that from its nature it admits of no other. I shall, however, reserve my remarks upon this subject for a future stage in the cause, and shall, without delaying you longer, proceed to call the witnesses. Counsel for the prisoner moved that the testimony of Elizabeth Watkins be taken in an adjoining house, where, by an affidavit of her husband which they presented, she was sick in bed too ill to attend. Granted, and Mr. Justice Lansing, Mr. Calden, and General Hamilton went to her house and took her deposition. When they returned, it was moved that the husband of Catherine Ring be ordered to withdraw from the court during her testimony. Granted. End of section 2. Section 3 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1, by John D. Lawson. Trial of Levi Weeks for the murder of Gulielma Sands, New York City, 1800, Part 2. Witnesses for the prosecution. Catherine Ring. In July last, Levi Weeks came to board in our family and soon after began to pay attention to Margaret Clark until about the 28th of the 8th month, when she went into the country. About 2 days later, Gulielma Sands asked me. Mr. Livingston objected to these declarations as inadmissible, as they were hearsay. The declarations of a murdered person are sometimes received as evidence against a prisoner, but only when they were made after a fatal blow or in his last moments, and are therefore supposed to be made under an equal solemnity with an oath. Calden insisted that such testimony was proper to show the disposition of mind in the deceased when she left the house on the night of the fatal accident, that this was the only way to discover whether she was sound in her intellects, or whether she was not under the impressions of melancholy, and that, in reality, This was one of those cases where evidence was to be admitted upon the necessity of the thing. The court. The evidence is not admissible. Go on, witness, but say nothing as to what Elma said to you. Catherine Ring. Elma lived in our house about 3 years as our child. Soon after Margaret Clark went away, Levi became very attentive to Elma. They were left in the house with my husband about the 10th of the 9th month when I was in the country. Elma slept in the front room, second story. After I had been absent about 4 weeks, I received a letter from my husband, desiring me to come home as he was very lonesome, and I came home 6 weeks to a day. After my return, I paid strict attention to their conduct, and saw an appearance of mutual attachment, but nothing improper. He was frequently in the room when she was sick. Shortly after my return, she concluded to pay a visit to her friends in the country, though she did not seem very anxious to go, as it was so late in the season. However, after she had got ready to go, Levi accompanied her to the vessel, and she stayed about 2 weeks. During her indisposition, he paid her the strictest attention, and spent several nights in the room, saying he did not like to leave her with Hope, my sister, fearing she might get to sleep and neglect her, and in the night he wanted to go for a physician, but I discouraged him, thinking she would get better by the morning. One night after she went to bed, the counsel for the prisoner stopped the witness to inform the court that Elias Ring, although ordered out, had returned and was standing behind his wife, the witness. The court ordered the constable to take him out and reprimanded him for his behavior. I thought I would step up into her room and see how she did. I slipped off my shoes, and going quick without making much noise, I partly opened the door, and saw Levi sitting by the side of her bed, and the door was shut against me. I took it to be by him, because she was in bed and could not reach the door. The next morning he said he had made a fire just before the day in his own room, and he discovered more to concern than I expected. Not a day passed but convinced me more and more that he was paying his attentions to her. I often found them sitting and standing together, once sitting together on her bed. On the 22nd of December, my sister Hope went to meeting, and Levi went to his brother's. In a short time he returned, having fallen and hurt his knee, which circumstance struck my mind would prevent their intentions for that time. Sylvanus Ruffle said, "Levi, you won't be able to go out today." He answered, "I am determined to, tonight." Elma then dressed his knee for him. It was not much of a hurt. I saw it. She got a plaster. After she had dressed it, he went upstairs a short time. She also followed him, and was gone, I should suppose, considerably more than an hour. This was about noon. His apprentice came down to do something, and in a little time went up, but soon returned again. The thought struck me that they had sent him down to get him out of the way. Between 12 and 1 o'clock she came down into the room where I was preparing dinner, with a smiling countenance, and seemed much pleased. I spent the afternoon with her. Her countenance and behavior was calm and composed, and fully happy, as likewise her appetite remarkably good. I left her a short time and went into another room. When I returned, I found Levi sitting by the fire with her, appearing fully composed and happy, but he soon left us and went upstairs. Shortly after, Elma went also. In about 20 minutes she returned not quite dressed, with her handkerchief in her hand, saying to me, "Which looks best?" Then Levi came down, nearly dressed also, with his coat upon his arm, at which time Elma stepped behind the curtain of the bed. He said, "Where's Elma?" I said, "She is hid behind the bed." He said, "Don't mind me. I want you to tie my hair." Elma came out and did so. Elias came in from meeting, and she went upstairs, and Levi after her. This was about sunset, and she did not come down till after dark, and Levi, I believe, stayed as long, for one of the family went up and found them together. After tea, I proposed borrowing a muff for her at one of the neighbors. She said she would go herself, and she went and got it. A while after, she went to the front door and leaned over it. I told her I was afraid she would take cold. She followed me in, where was 2 young men of the family, Russell and Lacey, with my husband. We all sat together till Levi came in. I then went to the front door and leaned over it. Soon after, the young man came out and went upstairs to bed, at which time I heard the clock strike 8. After they had gone upstairs, I shut the door and came in saying, "The clock has just struck 8. I sat down, and in the course of a minute or 2 afterward, Alma got up and went out, and I observed Levi's eyes fixed upon her, and I thought he looked at her for to go. In the course of a minute, I believe not more, I took the candle and went upstairs. She had her hat and shawl on and her muff in her hand. I observed she looked rather paler than usual, but I thought it a natural consequence, and told her not to be frightened. I went down, and left her just ready to follow. Levi took his hat. Colden: "Pray, Mrs. Ring, in what situation did you leave Alma upstairs?" "I left her just ready to come down, just coming down. She came down almost instantly. I came down and left her in the room and came in where Elias and Levi were sitting. No other person was up in the house but we 4. I set the candle down over the fireplace. Levi instantly took his hat and went out into the entry. The moment the door opened, I heard a walking on the stairs, and directly I heard a whispering near the door, at the bottom of the stairs for nearly a minute. But so near the door, I thought I might understand what was said, and I listened for that purpose. Soon I heard them step along, and the front door opened and the latch fell. I took up the candle and ran to the door to see which way they went. It was moonlight, but having a candle made it darker. Prisoner's counsel: "Mrs. Ring, are you sure you shut the door before?" "I am positive. It stuck much, and it was difficult to shut it. I then ran upstairs to see if they might not be there. But why I did it, I don't know. I can't say. But somehow I felt agitated on the occasion. But she was not there. I heard the steps of but one person." The court: "Did Levi return to his lodgings the same evening?" "About 10 o'clock he returned, and his apprentice was there waiting for him, as he had the key of the room, and the boy could not go to bed. The moment he opened the door, I cast my eyes upon him. His countenance was pale and much agitated. His apprentice was standing waiting for him. He came to the fire, took the key out of his pocket, and gave it to him, saying in a short tone, 'Go to bed.' He sat down and said, 'Is Hope got home?' I answered, 'No.' 'Is Alma gone to bed?' I said, 'No. She has gone out, at least I saw her ready to go, and have good reason to think she went.' He said, 'I am surprised she should go out so late at night and alone.' I replied, 'I have no reason to think she went alone,' to which he made no reply, but looked earnest and thoughtful and leaned down his head on his hand in this manner, putting her hand over her left eye and leaning her head upon it. Mr. Colden: Had anything passed to lead him to believe that she went out alone? No, there had not. The court: Did you express any alarm to him? No. Feeling very uneasy and agitated, I thought I would speak to Levi more particularly than I had done, and I told Elias to go to bed, and I would fix the child and bring it to him. And he got up to go, upon which Levi instantly rose and went upstairs. I thought she had gone to one of the neighbors to leave the muff. I was then determined to sit up until she should come in. I accordingly put out the candle and covered up the fire, supposing that perhaps he would come down after he thought us a bed and let her in. After waiting till about 12 o'clock and nothing appearing, I lit the candle and searched the house, thinking perhaps that she had come in, and went to every room excepting that where the 2 lodgers were abed, and to Levi's room. I went to his door twice, but seemed as if I had not power to enter. The court. Was anything said about Elma at breakfast by anybody? No, nobody mentioned her. After he had been out a while, I heard some person enter the house and run softly upstairs, and expected it was her, and intended to go and see. Soon afterwards Levi came in, saying, "Is Elma got home?" I answered, "I have not seen her." I felt provoked that he should ask me where she was, and thought that at least he might be silent. He then said, "I am surprised where she should be." I answered, "I expect she is upstairs. I heard someone go up." He replied, "It was me you heard." I observed, "Thee went more softly than ever before, and I'm sure I thought at her step." He immediately ran upstairs and instantly returned, saying, "She is not in the second story." I did not believe him and went up myself. When I returned, he was standing at the front door, but don't recollect his saying anything. When I said, "I'm surprised where she should be," but went away. Sometimes after he came in again and said, "Is Elma returned?" I answered, "No." "Have you sent anywhere for her?" I answered, "No." He said, "Why have you not?" I answered, "I did not think of sending, expecting her in every minute." He said, "I am surprised at her going out so late and alone." I said, "Indeed, Levi, to tell the truth, I believe she went with thee. She told me she was to, and I have good reason to think she did." He looked surprised and said, "If she had gone with me, she would have come with me, and I never saw her after she left the room." He then went out. The court. Was there anything uncommon in his manner? There was, to be sure, more than I can express. Prisoner's counsel. Do you mean that this was after you expressed your surprise? I had observed his look fixed upon me before. The court. Did you tell him of this? Did you observe to him that there was a difference in his look? I did not then. In a short time after, the owner of the muff called for it, as Elma had promised to return it the night it was borrowed, or early the next morning. I told her I would send for it, and the girl would fetch it home, as I expected Elma was at Henry Clement's. She answered she would sit with me, and sat down, during which time Levi came in and sat until the girl returned, saying Elma had not been there. I was struck with astonishment. Although my uneasiness had been great, yet I fully expected she was there. The person immediately said, "I guess she has gone to be married, and that made her borrow my muff." I answered, "Married or not, I think it is very ungenerous not to return it, and likewise to keep me in suspense and uneasiness," at which conversation Levi gave no answer, but sat with his head down, and then he went out. Soon after this my sister returned. In a short time after Levi came in. She immediately attacked him, saying, "Where is Elma? I know thee knows. Tell me ingenuously, for Katie is very uneasy, and says Elma told her she was going with thee, and she is sure she did." He looked surprised and said, "She told Katie so? Why, if she had went with me, she would have returned with me. I never saw her after she left the room, and am surprised you would think of my keeping you in suspense." The day passed without much more being said, except my saying I had been to the door 50 times to look for her. He answered he had looked more than 50 times. He could not keep his eyes from the street. The next morning, being Tuesday the 24th, after the boarders had breakfasted, none of the family up but them and myself, they all went out excepting Levi, who, seeing me much distressed, walked the room several times, appearing much agitated, came to me, and taking hold of my arm, said, "Mrs. Ring, don't grieve so. I am in hope things will turn out better than you expect," to which I gave no answer. As I expected, he was then going to tell me the whole matter. He soon, however, took his hat and went away. Nothing more was said till afternoon, when myself and sister, being so distressed, we determined to stand it no longer, and we were about to send for him when he again came in, laid down his hat, but on seeing our agitation he turned round and was going out. I said, "Stop, Levi. This matter has become so serious. I can stand it no longer." I then said, "It certainly lays upon thee. Therefore thee must make the best of thy way to get clear of it." He said he was willing to give what satisfaction he could, being sorry to see us so distressed. I said, if it had been many a person that I should even have been willing for her to have, I would not have waited 1 hour before they should have given an account of her. But my confidence in thee was so great, and fearing, too, to make her trouble, as she was bound not to disclose it, is the reasons why I did not immediately mention it. I then proceeded. On first day after 12 o'clock she came downstairs after being with thee, and told me that night at 8 o'clock you were going to be married, that you did not go till 8 o'clock on account of it being froze. I had not proceeded much further, if any, before he turned pale. He trembled to a great degree, was much agitated, and began to cry. Clasping his hands together, cried out, "I'm ruined. I'm done forever. Unless she appears to clear me, my existence will be only a burden. I had rather die than live under it." Then he proceeded to clear himself, saying he never would attempt to marry without his brother's approbation. I replied, she told me. They had talked to him twice on the subject. He said my brother can answer for himself. Thus he proceeded until we were hardly able to support it, as our dependence as to her was entirely upon him, not having a thought short of his knowing where she was. On Thursday, the 26th of December, about 10 o'clock, Margaret Clark and her sister Deborah Clark, being in the room with me, Levi came in, seeing us much distressed. He sat down and endeavored to comfort and console us, saying, "Give her up. She is gone, no doubt, and all our grieving would do no good." With an earnest look, I turned to him, saying, "Levi, give me thy firm opinion from the bottom of thy heart, for I don't doubt thee has one. Tell me the truth, what thee thinks has become of her." He replied, "Mrs. Ring, it's my firm belief she's now in eternity. It certainly is, therefore make yourself easy, for your mourning will never bring her back." I answered, "Why does thee say so? What reason has thee to think it?" "Why, from things I've heard her drop." "What were they?" I asked. "Why, I heard her say she wished she never had an existence." Prisoner's counsel. "Pray, Mrs. Ring, did you say you had wished that you had never had an existence?" "Yes, I dare say I have. In this very case, I might say, I wish I had never had an existence to witness such a scene. I acknowledge it's wrong, but still I don't believe I have often said so." I asked Levi, "What other reason has thee?" "Why, I have heard her threaten. If she had laudanum, she would swallow it." "Why, Levi, how can thee say so?" "As it was always easy for her to get that, it don't bear the weight of a single straw with me. And the circumstance thee alludes to, I believe I was present as well as several others, which he did not deny, nor mention any other time. The circumstance was this. My sister was unwell. The doctor had left a small phial with her, and she had it in her hand, clapped it up to her mouth. He said, "Elma, don't do so." She replied, "I should not be afraid to drink it if full." My husband answered, "Why, the foolish creature, it would kill thee." She answered, "I should not be afraid." I thought she spoke not thinking, though she was used to taking large quantities when sick, and this made her think light of it, but I suppose she did it only to tease him. I frequently conversed with him on the subject, always pointing out the impossibility of any other person knowing it, all which he never resented. On the day of the procession, he came to me saying, "Mrs. Ring, What objection have you to Hope's going with me to the alderman to say what she can in my favor? I answered, yes, very great objections, if I even believed thee innocent, which I have no reason to think, and it's publicly reported of thee, if she was even willing, which I am sure she is not. Well then, let her go with my brother. Indeed, I've no choice in thee or thy brother. If the authority calls for her, she will answer, I dare say, to what's proper. He then said, Mrs. Ring, you are not so much my friend as you have been. Indeed, Levi, I shudder to think I ever indulged a favorable thought of you. Mr. Colden, pray, Mrs. Ring, I wish you would be particular as to her temper and disposition on the 22nd. Pray, inform the court and jury. Was it composed that afternoon? Very much so. I never saw her pleasanter in my life. She was more so than usual. I always thought her disposition rather too gay for a friend, and she altered her dress and behavior to please me. Pray, madam, has she not always borne a good character? I mean that of a modest, discreet girl. Very much so. I have known her from an infant, but there are others that can speak of her, who had not that partiality for her that I had. Let me ask you, would not the conduct between the prisoner and her have been esteemed improper, if it was not supposed they were soon to have been connected in marriage? Yes. How old was she? About 5 years younger than myself. She was about 22 at the time of her death. Was Elma one of the friends? She was not, though we wished her to be. Pray, what relation was she to you? She is my father's sister's daughter. Had she parents living? Her mother is alive at New Cornwall. Her mother never was married. She took her mother's name of Sands. Her father is in Charleston, South Carolina. When was the body found? The 12th day after she left our house, or the 2nd day of January. Cross-examined by prisoner's counsel. Levi's character while he boarded in our house was such as to gain the esteem of everyone. His moral conduct was good. After this affair of the 22nd, he ate his meals as usual. I regarded Elma as a sister. Hope and Elma walked out together. They were associates. Levi did not walk out with her, as I know of. He went once to a charity sermon with Hope, and Elma was to have gone too, but the going was wet and she was not very well, and I would not suffer her to go. The day Elma went out, the 22nd of December, she looked rather paler than usual when I pinned on her handkerchief. It was her natural color. For about a year past she was at times rather unwell. She was much troubled with the cramp in her stomach. She had first slept in the 3rd story before I went into the country, but for 3 weeks before her death, she slept in the back room in the 2nd story next to Mr. Watkins' bedroom. There was no other female in the house when I went to the country. I never asked Levi whether he was engaged to Elma till Tuesday, after her death, nor said a word about it to him. I had no reason to suspect that any other person but Levi had an improper intimacy with her. Hope Sands. The first time I knew Levi and Elma to be together in private was about 2 weeks after I and Elma came to town. I then found Levi and Elma together in her bedroom. I was there with Elma when Levi came in, on which Elma gave me a hint. I immediately went out. He followed me to the door and shut it after me, and locked it. I went downstairs, left my shoes at the bottom of them, and went softly up to listen if I could hear their conversation, but could not understand anything, although I heard a whispering and stayed at the door a long time, more than an hour. Hearing some person come in below, I ran down, where I found Dr. Snedeker. On my coming into the room, Peggy Clark took the candle and went up to the room where Levi and Elma were. On finding the door locked, she returned, much surprised at finding it fast, and asked me if I knew who was there. I answered, I will go and see. She followed me up to the door. Finding it locked, we went into the next room. When the door was unlocked and Levi came out, I observed to Levi that he had intended being very safe, having secured the door that Peggy could not gain admittance. He then said, "Where is Peggy?" and looked into the room, but she stepped behind the door so that he did not see her. He then left us and went upstairs. There was no light in the room when I left them, neither when he came out. Therefore, I am positive they had not any. I then went in and found Elma sitting on the bed. I told Mrs. Ring of this the same evening. On Monday, the next day after Elma went missing, about 10 or 11 o'clock in the forenoon, I met Levi upstairs alone. I attacked him about her. He denied knowing anything of her, though from his looks I was confident he did. He soon began to use all possible means to convince me of his innocence. I replied it was hard to judge one I had so good an opinion of, but he was certainly the person who could give information of her if he chose. He said, "Do you think if I knew where she was, I would not tell you?" The Sabbath evening, after she was missing, he came to me saying, "Hope, if you can say anything in my favor, do it, for you can do me more good than any friend I have in the world to clear me. Therefore, if you can say anything, do it before the body is found, as after it will do me no good. But if the body is found a good way off, that will clear me, as I was not a sufficient time for my brothers to go far." He then pressed me very hard to go to the alderman's and see him. I refused, upon which he gave me a paper he had drawn, wishing me to sign it. The purport of the paper was that he had paid no more particular attention to Elma than to any other female in the house, that nothing had passed between them like courtship or looking like marriage. I took it from him, saying I supposed I might read it, and left him without saying any more on the subject till the day of the procession. He then came to me saying, "Hope, will you accompany me to see the procession?" I replied, "No, I have seen processions enough." He then said, "Hope, don't you intend to sign that paper for me?" I answered, "No," and drew it from my pocket. I then pointed out to him the inconsistency of my doing it, saying, "Levi, if I was to do it, thee knows it would be positive lies." He said it would be of no service to me, and reached out and took it from my hand, saying, "Will you go to the police with me?" I answered, "No." He said, "Will you go with my brother?" I replied, "No, what better would it be to go and say it than to sign the paper?" He then asked me if I would consult my sister upon it. I still answered no, but I was sure she would not consent to any such thing, if I ever so inclined myself, which I am very far from. Cross-examined by prisoner's counsel. Levi and Elma were locked up together at the time about an hour. He was liked very much. All spoke well of him. He went once to the museum with me and Elma. He went once to church with me of an evening. Elma was to have gone, but she was sick. I never knew him to walk out with her but that time. I heard him say one evening that he believed she despised him, for she would never go in the street with him. He once asked me to go to his brother's, but I would not conveniently. Alma was present. She said, "Why don't you ask me?" He replied, "I know you would not go if I did." Elias Ring. Levi Weeks was a lodger in my house, and in the 9th month. Prisoner's counsel. What month is that called? I don't know it by any other name. Thee can tell. At this time, when my wife was gone into the country, Levi and Elma were constantly together in private. I was alone and very lonesome, and was induced to believe from their conduct that they were shortly to be married. Elma's bed was in the back room, on the 2nd floor. The front room had a bed in it, in which Isaac Hatfield slept about 3 weeks. Hatfield during this time was occasionally out of town. I slept in the front room below, and one night when Hatfield was out of town, I heard a talking and noise in his room. In the morning I went up into the room and found the bed tumbled, and Elma's clothes which she wore in the afternoon lying on the bed. I never saw anything improper in the behavior of Elma until she was acquainted with the prisoner. Cross-examined by prisoner's counsel. I have seen familiarities between Levi and Margaret Clark. I never heard any noise when Hatfield slept in the room over me. I never knew that the prisoner and Elma were in bed together. The partition between Watkins' house and ours is a plank partition, lathed and plastered. Mr. Watkins is a good neighbor. On December 22nd, Elma was as cheerful and gay as I ever saw her. On that day I had been to a meeting in the afternoon. I returned and found Elma dressing, and my wife helping her in dressing, and assisting her in putting on her gloves, long white ones. About 8 o'clock Elma went out. I saw her go out of the room and heard the front door open and shut about 3 or 4 minutes thereafter. And my wife took the candle and went out and was gone about 2 minutes. The two boarders, Lacey and Russell, came in, and one of them pulled out his watch and observed that it was 8 o'clock. I am not certain that I heard anybody go upstairs. When my wife returned, I asked her who went out. She said, Elma and Levi. I answered that it was wrong. She would get sick. She replied, he would be more careful of her than I would be. About 10 o'clock, Levi came in. He asked if Hope had got home. My wife answered, no. He asked, is Elma gone to bed? She answered, no, she has gone out. He observed it was strange she should go out so late and alone. I never threatened Levi that I know of. I had a conversation with him in which he asked me if I had not said certain things about him, respecting Elma being missing, and he said if I told such things of him, he would tell of me and Croucher. I told him I believed him guilty, and he appeared as white as ashes and trembled all over like a leaf. His character was always good for anything I know, and his behavior was such that he was generally esteemed. I never spoke to Elma about her improper intimacy with Levi. I heard no whispering in the entry, or anybody come downstairs. I sat in the corner, was not attentive to these things. Margaret Clark. I lived at Mr. Ring's about 6 months before Levi Weeks came to board there, and Gulielma Sands lived there. I can't say I thought there was anything that looked like courting Elma, but they appeared intimate. I knew once of their being locked up together in the bedroom. Afterwards he told me they were in the bedroom together. This was the Monday evening before she was missing. Another time I saw him standing in her room when she was sick, but I thought nothing of this because he was always attentive to anyone that was sick. Prisoner's counsel. Did not Levi pay as much attention to Hope Sands as he did to Elma? Yes, I think he did, and more too. She corroborated the testimony of the other witnesses with regard to the cheerfulness of temper of the deceased. Isaac Hatfield. I lodged at Mr. Ring's from the 14th to 15th of September, 4 or 5 weeks. I lodged in the front room on the second floor. I observed a great intimacy between the prisoner and the deceased, such as to induce me to suppose he was paying his addresses to her, with a view to marry. The deceased was of a lively and cheerful temper. Richard David Croucher. May it please the court and gentlemen of the jury, I was a lodger but not a boarder in Mr. Ring's house. I remained at the house all the time of Mrs. Ring's absence, and paid particular attention to the behavior of the prisoner and the deceased, and I was satisfied from what I saw there was a warm courtship going on. I have known the prisoner at the bar to be with the deceased Elma Sands, in private frequently at all times of night. I knew him to pass 2 whole nights in her bedroom, once lying in my bed, which stood in the middle of the room and in a posture which was favorable to see who passed the door, and which I assumed on purpose. I had some curiosity. I saw the prisoner at the bar come out of her room and pass the door in his shirt only, to his own room. Once 2 at a time, when they were less cautious than usual, I saw them in a very intimate situation. I did not tell anyone of it. Prisoner's counsel. Pray, what countryman are you? An Englishman. I have been in this country since January 1799. Where, sir? Were you on the night of the 22nd of December, 1799? I supped that night at Mrs. Ashmore's, 884 Bowery Lane. It was the birthday of her son. In the course of the evening when the deceased was missing, I crossed twice or three times from Greenwich Street to Broadway and was once at the coffee house. I went out to the bar and returned to Mrs. Ring's. It was my agreement with Mrs. Ring to be home at 10 o'clock a night. But on this occasion I stayed out till 11 or half past 11. Do you know where the Manhattan Well is? I do. Did you pass by it that evening? I did not. I wish I had. I might perhaps have saved the life of the deceased. Have you not said you did? No, I might have said I wished I had. Have you ever had a quarrel with the prisoner at the bar? I bear him no malice. But have you never had any words with him? Once I had. The reason was this, if you wish me to tell it. Going hastily upstairs, I suddenly came upon Elma, who stood at the door. She cried out, "Ah!" and fainted away. On hearing this, the prisoner came down from his room and said it was not the first time I had insulted her. I told him it was an impertinent puppy. Afterwards, being sensible of his error, he begged my pardon. And you say you bear him no ill will? I bear him no malice, but I despise every man who does not behave in character. How near the Manhattan Well do you think you passed that night? I do not know what route I took. I go sometimes by the road, sometimes across the field. I believe there was a little moonlight. The going was very bad. Mr. Colden. Mr. Croucher, have you ever heard any noise in the room of the prisoner at an uncommon time of night since this affair happened? Yes, sir, I have. The night the deceased was missing and the next night, and every succeeding night while he stayed in the house. I heard him up whenever I waked at all hours from 11 o'clock at night till 4 in the morning, and a continual noise almost. I thought then his brother had some great work on hand, and that he was drawing plans, but since I have accounted for it in a different way. Prisoner's counsel. What kind of noises were these? The noise of moving about chairs, throwing down the tongs, and such kind of noises. Were you ever upon any other than friendly terms with Elma? After I offended the prisoner at the bar, who she thought was an Adonis, I never spoke to her again. Henry Reynolds and John Benson testified the deceased was modest and discreet and of a cheerful disposition. William Anderson. I am the prisoner's apprentice. Did not think he was any more attentive to Alma than to Margaret and Hope. He said to me one day that he kept Elma's company not for courtship or dishonor, but for conversation. He always slept with me, but one night he went downstairs in his shirt and did not return until morning. He slept as usual the night Elma was missing, and the next too, but on the fourth he signed out in his sleep. Oh, poor Elma. Susanna Broad. I lived opposite Ezra Weeks' lumber yard, and on the night the deceased was lost, I heard the gate open and a sleigh or carriage come out of the yard about 8 o'clock. It rumbled, had no bells on it, and returned again before long. I am sure as to the hour and month. Catherine Lyon. On Sunday night, a little after 8, before Christmas, I saw Elma Sands in Greenwich Street at the pump near the door of the new furnace. There were a good many people passing, and I could not say if anyone was with her. She spoke to me, and I heard someone say, "Let's go," and she bid me good night and went on. About 1/2 hour later, I heard a woman's cry from behind the hill at Lispenard's. "Murder! Oh, save me!" I did not see Alma's face, but I saw her form and shape. Did not see any sleigh. Margaret Freeman. On Sunday night before Christmas, a sleigh overtook me on the upper part of Greenwich Street. 2 men and a woman were in it. They were laughing very loudly. When I reached home, my watch was 7:45. Cross-examined. Have you never seen Ezra Weeks' sleigh? It was not dark, but there was no moon. William Lewis. On Monday morning before Christmas, I discovered the track of a one-horse sleigh about 300 feet from the Manhattan well. I passed the Sunday before and there was no track there. There was a board off the wall, which left it open, and there were tracks of people around it. Cross-examined. The road is a bad one, but I could not have found the well in the dark. Buthrung Anderson. On Sunday night before Christmas, I was driving on Broadway Street about 8:30 in the evening, and I saw a one-horse sleigh at full gallop with 2 or 3 men and a woman in it. The horse was dark-colored. I have seen Ezra Weeks drive a horse of the same size and color. Joseph Stringham and Joseph Cornwell, who were with Anderson in his sleigh, corroborated him, but they thought the Sunday was December 10th, just after Thanksgiving. Arnetta Van Norden. Lived near the well. About 8 or 9 o'clock in the evening, my husband heard a noise and said it was from the well. I looked through my window and we heard a woman cry out from towards the well, "Lord, have mercy on me. Lord, help me." Lawrence Van Norden. Am the husband of last witness. Heard the cry. I got up and looked out of the window. It was a clear night. I saw a man walking near the well. In a little time the cry stopped and I went to bed again. Cross-examined. I lived 100 yards from the well. There was snow on the ground. Did not see a sleigh. There is a red house a few yards from mine. I did not go to the well the next morning to examine it, nor did I mention what I heard and saw to anybody the next day. Thomas Gray and Samuel Smith, 2 lads of 11 and 13 years, were called, but on being questioned by the court, they were found not to know what an oath meant and were rejected. Also, William Blank was rejected on account of his age and because he was not able to tell the meaning of an oath. Andrew Blank. I am the father to William. He is 13 years old and cannot read. One day my son brought home a muff which he said he got in the well. Next day I went to the well but saw nothing when I looked in. I saw a good many tracks around it and one track from the well to the road. Cross-examined. He found the muff on the Tuesday before Christmas and I went to the well on Christmas Day. Counsel asked the court to adjourn until the next day as it was now 1:30 in the morning. The court seemed to be disposed to sit on, but some of the jurors saying they could not keep awake, adjournment was ordered until next day. End of section 3. Section 4 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1, by John D. Lawson. Trial of Levi Weeks for the murder of Gulielma Sands, New York City, 1800, Part 3. April 1st. The court assembled today, all the judges and counsel present. Richard C. Skinner. Am a surgeon and saw the body after it was taken from the well. There were several bruises on it, but the neck was not broken. The marks on the neck might have been made by the hand. Do not know Mr. and Mrs. Ring. There were spots on the neck and a chain. Cross-examined. I am not capable of judging what caused the spots. James W. Lent. On the 2nd of January last, I, together with Mr. Page, had some business to do in breaking a horse, and we went up to Andrew Blank's and we dined there. While we were dining, 2 persons, Mr. Watkins and Mr. Elias Ring, came there to get hooks and poles to sound the Manhattan well for the body of a young woman who was supposed to be drowned. We got the poles and nails and went all together to the well, which we uncovered. Page took the pole first and said he thought he felt her. I took hold then and thought I felt her too. Watkins drove in the nails. I took the pole and hooked the nails in her clothes and drew her up carefully to the top of the water. As soon as Mr. Ring saw her calico gown, he said it was she. He knew the gown. She was so heavy now, we could not draw her out by the nail, and the little boy went for a rope to the next house, while I held her still. I put the rope under her and drew her up gently. She slewed round, but there was not a thread of her clothes which touched either side of the well. When she was drawn up, we laid her on a plank, and she appeared in such a situation as if she had been murdered. Counsel for the prisoner: you are to tell what you saw, not what conclusion you made. That is for the jury. Her hat was off, her gown torn open just above the waist. Her shawl was off, and her handkerchief and shoes were gone. Her hair hung over her head. In lifting her up, I found her head fell forward, and when we lifted her a little back, her head fell back again, and again it fell to the right, which caused me to suppose her neck was broke. She had a white dimity petticoat on. I discovered on her right hand something like a kick. There was the scratches of sand upon her skin, some of which was knocked off and seemed to have been drove forward. Her stockings were torn at the toes. The right foot was bare and somewhat scratched. The scratches were on the upper part of the foot, as if she had been dragged on the ground. Did not see any bruises upon her face. The pole could not have injured her head. It did not touch her head. I was particularly tender with it. I hooked her in the skirt of her gown. Her arms were stiff, her legs were straight, but her neck was remarkably limber. She looked like a person who had been walking against the wind. Flush, but not so much so as she appeared a few days later. Her appearance was horrid enough. Her cap and hat off, her hair hanging all over her head. Her comb was yet hanging in her hair, tied with a white ribbon. Her shawl was off. Her gown was torn open with great violence, and her shoes were off. I went to the police, and then with the officer to find the prisoner. We stayed a little back till we saw the officer tap him on the shoulder. I then went up to him. He stood in the door. I says, "Is this the young man?" He replied, "Yes." I told him I was very sorry for his situation. I felt affected. I expressed it to him. He turned about and said, "It is too hard." And he dropped his head and said, "Is it the Manhattan well she was found in?" I said I knew not what well she was found in. I did not then know the Manhattan well. This was about 3:30 in the afternoon. However, I don't know exactly the time, but by calculation, I suppose the body was found about 15 minutes after we had left Blank's house. A juryman: was there any mention made of the Manhattan well in the presence of the prisoner before he asked the question? I did not hear any. I don't believe there was. Mr. Colden: were you present when he first saw the body? What did he say? Prisoner's counsel objected to this kind of evidence, but was overruled by the court. In proceeding to the well, he asked for his brother as counsel for him. When we came there, we found a great number of people collected. I stepped before him and said, "Weeks, do you know that young woman that lies there a corpse?" He said, "I think I know the gown." "My young friend," said I, "that is not the question I ask you. Is there no marks in that countenance you know?" He turned himself and said, "I think there is." Dr. James Snedeker: am a physician and examined the body the second day after it was taken from the well. Thought the left collarbone was broken. The neck was not injured. Dr. David Hosack: curiosity led me in common with others to visit the body. It was exposed in a coffin. Footnote: to exhibit the body of a murdered person in the street seemed strange to us, especially as there was no question of identification, and as an instance of the contrast between the manners of a century ago and the present day. Whether this was a common occurrence, it is not possible to say with complete assurance, but it is certain that neither the witnesses nor anybody else spoke of it as strange or shocking. Dr. Hossack, who was a leading physician of New York, seems to have gone to look at the body out of mere curiosity, and quite as a matter of course. Such an exposure now in a public street is unimaginable. An American myth, Henry Cabot Lodge, The Outlook, 26 August 1911, page 953. See also the evidence of Joseph Watkins. End of footnote. I thought the spots on the body were the result of violence committed by a third person. Elizabeth Osborne. I had a slight acquaintance with Elma Sands. On the 22nd of December, I lent her my muff. She came to borrow it herself, and I observed that she was very neatly dressed, and she seemed to be very lively and very happy. The muff was brought home the day that she was found, and it appeared as if it had been wet. The Attorney General admitted that the muff was found some days before the body was discovered. Mr. Williams. At the request of the Attorney General, I had made an experiment what time a man might drive a horse the most usual route from Rings to the Manhattan Well, and from there back again to Ezra Weeks down Barley Street. Although the roads were bad, it was done once in 15 minutes and once in 16, without going out of trot. Sylvester Buskirk was with the last witness at the time he spoke of, and corroborate what he said. Ezra Weeks' horse had stood in his stable for sale, and was a good horse in appearance. Mr. Cross. Am acquainted with Ezra Weeks' horse. He is a very good one. Will go a mile in 5 minutes. Mr. Colden addressed the jury on the nature of circumstantial evidence, and read the following passage from Morgan's essay, page 208. Circumstantial evidence is all that can be expected, and indeed all that is necessary to substantiate such a charge. The prejudice entertained against receiving circumstantial evidence is carried to a pitch wholly inexcusable. In such a case as this it must be received, because the nature of the inquiry, for the most part, does not admit of any other, and consequently it is the best evidence that could possibly be given. But taking it in a more general sense, a concurrence of circumstances, which we must always suppose to be properly authenticated, otherwise they weigh nothing, forms a stronger ground of belief than positive and direct testimony generally affords, especially when unconfirmed by circumstances. The reason of this is obvious. A positive allegation may be founded in mistake, or, what is too common, in the perjury of the witness. But circumstances cannot lie, and a long chain of well-connected fabricated circumstances requires an ingenuity and skill rarely to be met with, and such consistency in the persons who come to support those circumstances by their oaths as the annals of our courts of justice can seldom produce. Besides, circumstantial evidence is much more easily discussed, and much more easily contradicted by testimony if false, than the positive and direct allegation of a fact, which, being confined to the knowledge of an individual, cannot possibly be the subject of contradiction founded merely on presumption and probability. The defense. Mr. Burr. Gentlemen of the jury, the patience with which you have listened to this lengthy and tedious detail of testimony is honorable to your characters. It evinces your solicitude to discharge the awful duties which are imposed upon you, and it affords a happy presage that your minds are not infected by that blind and undiscriminating prejudice which had already marked the prisoner for its victim. You have relieved me from my greatest anxiety, for I know the unexampled industry that has been exerted to destroy the reputation of the accused, and to immolate him at the shrine of persecution without the solemnity of a candid and impartial trial. I know that hatred, revenge, and cruelty, all the vindictive and ferocious passions, have assembled in terrible array and exerted every engine to gratify their malice. The 1,000 tongues of rumor have been steadily employed in the fabrication and dissemination of falsehoods, and every method has been taken to render their slanders universal. We have witnessed the extraordinary means which have been adopted to inflame the public passions and to direct the fury of popular resentment against the prisoner. Why has the body been exposed for days in the public streets in a manner the most indecent and shocking? To attract the curiosity and arouse the feelings of numberless spectators. Such dreadful scenes speak powerfully to the passions. They petrify the mind with horror, congeal the blood within our veins, and excite the human bosom with irresistible but undefinable emotions. When such emotions are once created, they are not easily subdued. It has happened in this case that there have been attempts made to call up public sensibility, to excite resentment against this unfortunate man. In this way, gentlemen, the public opinion comes to be formed unfavorably, and long before the prisoner is brought to his trial, he is already condemned. It is not to be supposed that these rumors can have any weight with the court of justice, but no man is altogether above being moved by such reports, and it requires some fortitude to withstand them. But now, having heard the whole which can be said, you are prepared to determine whether the witnesses have always spoken with candor, or whether they have not spoken with temper, hatred, and revenge. We rely on it at first that there is nothing from which a discreet jury can condemn the prisoner. In the very commencement of the business, it is involved in doubt. Notwithstanding, there may be testimony of an intimacy having subsisted between the prisoner and the deceased. We shall show you that there was nothing like a real courtship, or such a course of conduct as ought to induce impartial people to entertain a belief that marriage was intended. For it will be seen that she manifested equal partiality for other persons as for Mr. Weeks. It will be shown that she was in the habit of being frequently out of evenings, and could give no good account of herself, that she had at some time asserted that she had passed the evening at houses, where it afterwards appeared she had not been. We shall show you that if suspicions may attach anywhere, there are those on whom they be fastened with more appearance of truth than on the prisoner at the bar. Certainly you are not in this place to condemn others, yet it will relieve your minds of a burden. There will be 2 modes of giving a solution. First, that the deceased sometimes appeared melancholy, that she was a dependent upon this family, and that a gloomy sense of her situation might have led her to destroy herself. As to the incident of the sleigh, we shall account for his whole time during that evening, except about 15 minutes. Which was employed in walking from one house to another, and we shall show you that the whole of his conduct has been such as totally to repel the idea of guilt. It will appear that at 10 o'clock the same evening he supped at his brother's perfectly tranquil. The story, you will see, is broken, disconnected, and utterly implausible. We shall show you that the sleigh of Ezra Weeks was not out that evening. Indeed, the testimony of the good old woman was such as could not gain the least belief, especially when you see that in matters of date and time she was totally lost. It will be shown you that on this occasion there have been violent attempts to inflame the public mind against the prisoner, and we shall bring these home to some of the witnesses. We hope you will pronounce them altogether unworthy of credit. For a man to forestall the public opinion is to arrest the hand of justice and deserves the severest reprehension. And such conduct we shall fix on the witnesses. We shall show you that the prisoner has been uniformly well spoken of, more highly esteemed than one of his years, not only for his deportment, but for his morals, that a man of such a character should be impelled without motive to the commission of so horrid a crime cannot be believed. Much has been said about the appearance of guilt and terror in the prisoner when charged with the crime. But, gentlemen, no man is armed with so much firmness of nerves that when charged with a crime, he will not discover great emotion. When, therefore, persons of little discernment come forward and say that they saw emotions of alarm and terror, no man, however innocent as an angel, is safe. The emotions of surprise may be construed by the ignorant or the malicious into those of guilt. A man charged with heinous crime may even prevaricate. We shall show you the case of a young man who, being charged with the crime of murder, even brought a young woman dressed to resemble the one he was charged with murdering. This was supposed to be a circumstance so conclusive of his guilt that he was convicted and executed, and afterwards the young woman was found to be alive. Even in this very city a case had occurred not many years ago. A young man had been charged with the crime of rape. It is yet fresh in the minds of everybody. The public mind was there highly incensed, and even after the unfortunate man had been acquitted by a verdict of a jury, so irritated and inflamed were the people that the magistrates were insulted, and they threatened to pull down the house of the prisoner's counsel. After that, a civil suit was commenced for the injury done the girl, a very enormous sum given in damages, and the defendant was ignominiously confined within the walls of a prison. Now it has come out that the accusation was certainly false and malicious. If this doctrine of presumptive evidence is to prevail, and to be sufficient to convict, what remorse of conscience must a juror feel for having convicted a man who afterwards appeared to be innocent? In cases depending upon a chain of circumstance, all the fabric must hang together or the whole will tumble down. We shall, however, not depend altogether on the weakness of proof on the part of the prosecution. We shall bring forward such proof as will not leave to you even to balance in your minds whether the prisoner is guilty or not. From even that burden we shall relieve you. But before we come to the testimony on the part of the prisoner, it may be well to examine a little more into the nature of the evidence on the part of the prosecution. It may be material to discover how much of this testimony which we have heard is the effect of a prejudiced imagination. In cases, people relate first with an honest zeal to relate as an opinion, next as a matter of fact. The only material facts on which I would observe here is the expression ascribed to the prisoner of the Manhattan well, but that circumstance will be satisfactorily accounted for by proving to you that he had previously informed that the muff had been found there, and it was therefore natural to inquire if the body was not found there also. If, gentlemen, we show you all this, you will be able to say before leaving your seats that there is nothing to warrant you in pronouncing the prisoner guilty. End of section 4. Section 5 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of Levi Weeks for the murder of Gulielma Sands, New York City, 1800, Part 4. Witnesses for the defense: Demas Meade, an apprentice of Mr. Ezra Weeks, and live with him. Take care of his horse and sleigh. On the Sunday night I locked the gate as usual, and put the key in my pocket or on the mantel. Did not miss it in the morning, nor was anything mislaid. The 8 harness bells were tied on as usual. Would have known if anyone had taken the horse and sleigh even for half an hour. It would have taken 5 to 6 minutes to have taken the bells off and put them on, and 10 to 15 to harness up. After Mr. McCombs and his wife left a little before 9, I went upstairs and saw Levi Weeks sitting in his room. Lorena Forrest lived next door to Mrs. Ring. About 12 o'clock on the second day of January, Levi Weeks came into our house to buy some tobacco. This was the day Alma was found. I asked him if there was any news of Alma. He answered, no. I told him I thought the Rings family had, but they seemed very much agitated. He went away and came back in about half an hour. I told him then that Mrs. Ring said that the muff and handkerchief had been found in a drain near Bayard's Lane. He did not seem to change countenance. Nothing was said about the Manhattan well. Heard Croucher say that he came near the well the evening she was missing. Joseph Watkins was present at the finding of the body about the middle of September, Mrs. Ring being in the country. I imagined one night I heard a shaking of a bed in the second story where Alma's bed stood. Her bed stood within 4 inches of the partition. I heard a man's voice. I am very positive it was not Levi's voice. I said to my wife, it is Ring's voice, and the girl will be ruined. Didn't mention this to anybody until after Alma was missing. My room is next to Alma's. Cross-examined. The partition between our rooms is plank, lathed and plastered. Made it myself. Was not certain it was Ring's voice, but thought it was. Often heard that voice in Alma's room. Did not hear the voice after Mrs. Ring came from the country. Mrs. Ring came into our house one morning and said Alma was so sick since she was at your house last night. My wife said she was not there. Mrs. Ring often said that Levi was kind and friendly to everybody, not more so to Alma than to any of the rest. I once said to Croucher that I believed Ring had a hand in it. Asked Croucher where he was that night. He did not answer. The day she was laid out in the street, I saw Croucher very busy, attempting to make people believe that the prisoner was guilty. Ring has a high-sounding voice. Weeks has a low, soft voice. Captain A. Rutgers met Ring one Sunday afternoon, and he asked me if I had heard of a muff being found anywhere. He said they were looking for a young woman who was missing, a relation of his wife's, who had been gone for a week. He said they supposed she was drowned and believed it was in a love fit. Had no idea that Mr. Ring thought it was murder. Lorena Forrest. A day or two after Alma was found, Croucher was at our house and said it was a very unfortunate thing that he had not come that way just at that time, as he might have saved her life. He said he had come by that night. Betsy Watkins lived next door to Alma. She had a front bedchamber which was against my mother's. Mrs. Ring came into our house one morning and said her boarders had gone out without breakfast, that Alma had been sick all night, ever since she came from our house, and she thought it arose from her sitting over our stove. My mother replied that she had not been at our house. Have heard Mrs. Ring say that Levi was very kind to the family. She said that on the evening of the 22nd, Alma went upstairs and she followed her up with a candle. She said Alma looked pale, and she told her not to be frightened. She said she afterwards heard a whispering in the entry. Dr. Prince testified to the appearance of the body and the bruises, as did Dr. Hossick and Dr. McIntosh and Dr. Romaine. David Forrest. On the 26th, Croucher came into my store to buy a loaf of bread. He said Ring's family was in great distress. His opinion was that the girl had made way with herself. On Friday, Croucher came running into the store and said, "What do you think of this innocent young man now? There is material evidence against him, and he will be hanged." Ezra Lacey was a lodger in the house of Mrs. Ring, and was there the night Alma was missing. Levi Weeks was there about 8 o'clock when I came away. Left Mr. Ring, Alma and him together. Do not know whether Mrs. Ring was there or not. Noticed no change in his countenance after Alma was missing. Thought he was more attentive to Hope than he was to Alma. One night after the disappearance of Alma, I heard somebody say if Weeks should get clear by law, it would not be safe for him to appear in public, and Ring said he thought so too. I heard Ring say that if he should meet him in the dark, he would not think it wrong to put him aside if he had a loaded pistol. William Dunstan. Last Friday morning, a man, I don't know his name, came into my store. Here one of the prisoner's counsel held a candle close to Crouch's face, who stood among the crowd, and asked the witness if it was he, and he said it was. He said, "Good morning, gentlemen. Levi Weeks is taken up by the High Sheriff, and there is fresh evidence against him from Hackensack." Footnote. This simple incident has given rise to two different tales of a similar kind, both of which have gone into history and have remained there unchallenged for nearly a century, and have only recently been shown to be mere myths. In Parton's Life of Aaron Burr, he says, he used to say that he once saved a man from being hanged by a certain arrangement of candles in a courtroom. As the trial proceeded, suspicions arose against the principal witness, and Colonel Burr became convinced that the guilt lay between the witness and the prisoner. Hamilton had addressed the jury with his usual fluent eloquence, confining his remarks to the vindication of the prisoner, without alluding to the probable guilt of the witness. Colonel Burr, in turn, rose. He set forth the fact which bore against the man, and then seizing two candelabra from the table, he held them up toward the witness and exclaimed, "Behold the murderer, gentlemen!" Every eye was turned upon the wretch's ghastly countenance, which seemed to wear the very expression of a convicted murderer. The man reeled, shrunk away, and rushed from the room. The effect of this incident was decisive. Colonel Burr concluded his speech. The judge charged. The jury gave a verdict of acquittal, and the prisoner was free. In Hamilton's History of the Republic of the United States, which deals largely with the life of Alexander Hamilton, and which was written by his son, it is said, an occurrence had taken place which greatly excited the sympathies of the inhabitants of the city of New York. The body of a young female was found in a public well, and a young mechanic of reputable character, who had been her suitor, was suspected of and indicted for the murder. Hamilton was engaged to defend him. A careful investigation left no doubt in his mind of the innocence of the accused, and his suspicions fell upon a principal witness for the prosecution. But the public feeling had been artfully directed against his client, and to overcome its passionate prejudices was a Herculean task. The office of defending him was rendered invidious, and, fearing that his talents would rescue the destined victim from their grasp, Hamilton, when he appeared in the court of justice, was regarded by the multitude in this, the only time of his life, with a dark and sullen animosity. He resolved not merely to secure the acquittal of his client, but to place his character beyond all suspicion. It would, in this view, be a great victory so to operate on the jury in the progress of the evidence as to supersede the necessity of summing up the case. To this object he bent all his efforts. The evidence was circumstantial, with the exception of that of the witness who Hamilton felt convinced was the criminal. After an exertion of all his logical powers in disentangling the web, which had been wound around the accused, and in showing that the crime must have been perpetrated by another hand, the suspected witness was called to the stand. On his evidence the verdict would turn. The prolonged trial had extended far into the night, and when Croucher was sworn, Hamilton advanced, placed a candle on each side of his face, and fixed on him a piercing eye. This was objected to, but the court declared the extraordinary case warranted this procedure. Hamilton then remarked in the deepest tones of his voice, "I have special reasons, deep reasons, reasons that I dare not express, reasons that, when the real culprit is detected and placed before the court, will then be understood. The audience bent forward in a breathless anxiety, every eye turning from the prisoner to the witness when Hamilton exclaimed, "The jury will mark every muscle of his face, every motion of his eye. I conjure you to look through that man's countenance to his conscience." Having thus fixed the impression, he pressed in a close examination the conscience-stricken culprit, who plunged on from one admission to another, from contradiction to contradiction. The evidence closed. As Croucher withdrew from the stand, the spectators turned away from him with horror, and the jury acquitted the young mechanic without rising from their seats. Doubt still hung over the accused, but the subsequent conviction of this witness of an execrable crime left little question of the justice of Hamilton's suspicions. Morse, in his Life of Hamilton, repeats and accepts the incident as true, as does Lodge in his Life of the Statesman, though the latter author rejected the Burr claim as related by Parton, but in an article published in May 1872 in Harper's Magazine, The Manhattan Well Murder, both stories are shown to be improbable, and in An American Myth, Mr. Lodge acknowledges his mistake and shows both claims to be absolutely without foundation. End of footnote. He then went away, and as he went out he said, "My name is Croucher," and this was all the business he had with me. Hugh McDougall. I have been acquainted with this Mr. Croucher for some time, but never liked his looks. On January 2nd, the day the body was found, he was extremely busy among the crowd to spread improper insinuations and prejudices against the prisoner, who was then taken, and among other things he told a story about his losing a pocketbook. This conduct I thought unfair, and I told him so plainly. "Oh, but," says he, "there's the story of the pocketbook," and stopped there. Last Monday, while I was busy in my garden, he came to my shop. "Now," says he, "the thing has all come out. The thing is settled. There is point-blank proof come from the Jerseys of a new fact." I told him I thought it wrong and highly improper that he should persecute Weeks in such a manner, when he had a difference with him. That, for my own part, I wanted some further evidence before I should condemn the man. Timothy B. Crane. Lodged at Rings before the girl was missing. Alma was very melancholy. Thought Levi paid as much attention to Hope as to Alma. On Wednesday, after she was missing, was told that Levi was implicated. It seemed to make no difference in his behavior. Cross-examined. Saw Alma take laudanum. She was sick about half the time I was there. Mrs. Ring told me she never saw Alma after she went upstairs. John B. McCombs. Between 6 and 7 on the 22nd of December, my wife and I went to Ezra Weeks' house. We found Levi sitting there, and he remained until 8 o'clock. I am sure of the time. Elizabeth H. Weeks, whose disposition was read by consent, swore that on Sunday night, the 22nd of December last, she and her husband were at home. McCombs and his wife came in, and Levi was there and stayed until about 8 o'clock. Saw nothing peculiar about his conduct. Ezra Weeks. On Sunday, the 22nd of December, my brother, Levi, came to my house about 9 o'clock. I went to church and left him there. I dined that day at my father-in-law's, and did not return home till about 5 o'clock in the afternoon. Just as we had drunk tea, and were yet sitting at the table before we lit candles, my brother came in, and I believe in about half an hour afterwards Mr. and Mrs. McCombs came in, and my brother tarried till about 8 o'clock, whether a little before or a little after I cannot say. Mr. McCombs and his wife sat about 20 minutes, as near as I can judge, after my brother went out. I lighted them downstairs, and held the candle to light them all the way to Mr. Rhinelander's corner, it being very slippery and dark. Cautioned them to take care. I came up again, Just as I set down the candle before I had time to sit down myself, Levi, my brother, came in to inquire about the business of the next day, as he had the charge of my shop, understanding the business as well as myself, and very attentive to it. I am seldom in the shop more than once a day. I attended to the business abroad, took dimensions of work on my memorandum, and gave it to my brother in writing. His business was to give directions to the journeyman for execution. It was a general practice of my brother's to call on me of an evening to consult me about business of the next day, and if company happened to interfere, if he did not stay till the company was gone, he seldom failed to come in again before he went to bed. That night he came accordingly. He ate a hearty supper. He was as cheerful as ever I saw him, tarried till about 10 o'clock, and I suppose went home as usual. On January 2nd last, about 2 in the afternoon, Levi came and told me that Mrs. Forrest had told him that the muffin handkerchief was found in a well near Barrett's Lane. I told him that I supposed it must be the Manhattan well. This place came first to my recollection, because I had furnished the wood materials for that well. And as my business often called me that way, I rode past the well almost every day. Levi knew where the well was, but I do not think he was ever there until his arrest. Charles Thurston. I have worked as foreman for Ezra Weeks about 2 years. From the time the girl was missing, I never saw any difference in the conduct of Levi. A number of witnesses testified as to the good character of Levi Weeks. Re-examination for the people. Matthew Musty. I saw a young man the Sunday week before the girl was missing with a pole in his hands. Mr. Colden. Do you know Levi Weeks? Would you know the person you spoke of if you saw him? I don't know as I should. Mr. Colden. Take the candle and look around and see if you can point him out. Witness went near the prisoner and pointed to him and said that it was he. Prisoner's counsel. Will you undertake to swear that is the man you saw at the well? I can't swear to it. The Sunday before the young woman was missing, I saw a young man sounding the Manhattan well with a pole. I went up to him and asked him what he was doing. He said he did the carpenter's work and wanted to know the depth of the water, and found it to be 5 foot 5 inches, 5 foot 8, and 6 foot. He had on a blue coat and a red jacket. Alice Ring, being called and asked if the prisoner wore such a jacket, answered she had never seen him with one of this kind. Mr. Colden. If the court please, we give up this point. Several witnesses testified as to the good character of Alice Ring, and that Alma Sands was of a lively and cheerful disposition. A number of witnesses testified that they supped with Mrs. Brown on the birthday of her son, December 22nd, and that Groucho was of the party, that he came between 4 and 5 and remained until after 10. This closed the evidence, 75 witnesses in all having testified, and the hour being 25 minutes past 2 in the morning. The counsel for the prisoner now proposed to submit the cause to the charge of the court without argument. Mr. Colden wished that the court would adjourn, as they had done the preceding night. He stated that he had not slept since the morning that the cause was opened, and had then been without repose 44 hours, that he found himself sinking under this fatigue, and considering that the prisoner's counsel, who were to precede him, would probably take several hours, it would be morning before he could begin his address to the jury, that really he had not strength to proceed further that night, and should therefore be under the necessity of assenting to the proposition of the other side, unless the court would adjourn. He was anxious that the court should do this, because he thought it important that the jury should hear observations on the testimony. The court, however, said it would be too hard to keep the jury together another night without the conveniences necessary to repose, and they therefore could not think it proper, but would proceed. Chief Justice Lansing to the jury. From the manner in which the trial had been conducted, I suppose that the arguments of the counsel would have afforded the jury sufficient time to adjust and arrange the mass of evidence which, in its progress, has been brought into view. But it has, unexpectedly, become my duty to charge you without the assistance of the argument of counsel, which they have waived on account of the late hour. A minute detail, however, is not essential to enable you to determine on the case according to its justice, as the evidence applying to the points on which it ought to be decided lie in a small compass. The question you have to decide involves considerations of great moment, both to the public and the prisoner. To the public as deeply interested in the detection and punishment of crimes of the atrocious nature of that with which the prisoner was charged. To the prisoner, as on your verdict depends his life and everything dear to the human mind. These observations are only pertinent so far as they may operate to stimulate your attention and prompt you to a dispassionate estimate of the evidence. They ought not to be permitted to influence you from pronouncing the result of your investigations according to the impressions they make on your minds, regardless of the consequences attached to their determination. Your path of duty is clearly and distinctly traced to find the prisoner guilty, if in your consciences you believe him so far from the evidence, to acquit him if you think him innocent. This matter has, in a considerable degree, excited the public attention. It has interested the passions of many, and a variety of reports respecting it have been circulated, some of which must, unavoidably, have been communicated to you. But by whatever motive prompted, they do not deserve attention, and they ought not to have attached to them the least consequence or to mingle with the facts disclosed by the witnesses. For the obligation you incurred when you became jurors limits you to the evidence produced on the trial, and that only can justify the verdict you are called upon to give. It is not pretended that positive proof of the commission of the murder by the prisoner is attainable, but it has been attempted to prove his guilt by circumstantial evidence. And if it can be established by a number of circumstances so connected as to produce a rational conviction that he was the perpetrator of the crime, it will be as much your duty to find him guilty as if it was made out by direct and positive testimony. But there are points in which the circumstances attempted to be combined were not so satisfactorily connected as to enable you to pronounce the prisoner guilty. It is doubtful whether Gulielma Sands left the house of Elias Ring in company with the prisoner so as to impose it on him to account for the manner in which he had disposed of her. The testimony respecting the one-horse sleigh does not appear to be such as to justify a presumption that the prisoner had personally any agency in it, for if the relation of Susanna Broad does not satisfy you, that the sleigh was taken out of the lumber yard of the prisoner's brother at or about the time Gulielma Sands disappeared. It must be evident that the relations of the other witnesses respecting a sleigh and the cries of distress heard near the Manhattan well could have no application to the prisoner. Then Mrs. Broad's testimony is confused as to the time, and indistinct and unsatisfactory as to circumstances. The prisoner appears to be a young man, and if it is fully proved that he had sustained a fair character, and that he was of a mild disposition, it is difficult to discover what inducement could have actuated him in the commission of the crime with which he is charged. The declarations made by the prisoner after he became an object of suspicion do not appear to be inconsistent with innocence. The witnesses produced on the part of the prisoner had accounted for the manner in which he spent the evening, excepting a few minutes, and from the account, the medical gentleman who had been examined had given the state of the corpse of Gulielma soon after it was taken out of the well. It was very doubtful whether she had been exposed to any other violence than that occasioned by the drowning. Some intimation had been given in the course of the trial, tending to question the credibility of some of the witnesses, but it is not necessary to examine this point, for admitting all the circumstances related by the witnesses on the part of the prosecution to be stated without any disposition to discolor them to the prejudice of the prisoner, the court is unanimously of opinion that the proof is insufficient to warrant a verdict against him. With this general charge, we commit the prisoner's case to your consideration. The jury then went out and returned in about 5 minutes with the verdict of not guilty. End of section 5.
Section 6 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of Samuel Tulley and John Dalton for piracy and murder, Boston, Massachusetts, 1812, Part 1. The narrative. On October 17, 1811, the American schooner George Washington, Uriah Levy master, sailed from Philadelphia on a voyage to Tenerife. Her crew consisted of Samuel Tulley, mate, John Dalton, Neal, Hopkins, and Cummings, sailors, and John Owen, cook. She arrived safely at Tenerife on December 13th, landed her cargo, and took on board 14 quarter casks of wine and $2,500 in specie. She sailed from there on December 23rd and reached the Isle of May, one of the Cape Verde Islands, on January 4th, 1812. The vessel came to anchor in the harbor, and at 3 in the afternoon, the captain left to pay a visit to another ship lying in the harbor, directing the mate to send for him there at sundown. Neal and Hopkins came with the boat, but the captain was not ready to leave, and he ordered them to return for him in an hour or so. They did so at 8 o'clock, and when they told him what they had heard the mate say, he looked at once for the George Washington, but saw that she had left the harbor. The next day he found the anchors in the bay and the cables cut. He never saw the vessel again. Before Neal and Hopkins left the ship for the captain, Tulley, the mate, ordered them to hoist the sails, which they refused to do unless he told them what it was for, as they noticed that the cables had been cut. He refused to say, but told them to hoist the sails, and then he would give them the boat to go for the captain. They did so, and then left in the boat. Owen, the cook, wanted to go with them, but Tulley would not let him. The men remaining on board were now only 4. Tulley, the mate, Cummings, Dalton, and Owen, the cook. The ship immediately put to sea, and for the next 2 weeks Tulley and Dalton were at the wheel alternately. Cummings, who was a foreigner, soon showed signs of fright at what was being done, and the day before land was sighted was thrown overboard by Tulley and Dalton after a struggle. The next day they scuttled the vessel, Tulley having distributed to Dalton and Owen a quantity of specie with the injunction not to tell anyone the truth, and all landed in a small boat on what proved to be the island of St. Lucie. At first, Owen told the story that Tulley had instructed him to tell, that the ship had been wrecked, and that the captain had gone off in one boat with the other seamen, and he and the rest in the other, but after a time he became uneasy and finally confessed the whole case to an American captain he met on the island. The 3 were arrested and handed over to the United States officer, who took them to New Bedford and finally to Boston, where they were committed to prison. Captain Levy subsequently learned from the American consul at St. Lucie of their arrest, went there, and about $1,350 in specie and some of his effects, which the prisoners had brought from the ship, were returned to him. Tulley was a native of Pennsylvania, a man of fair education and a good seaman, having for most of his life followed that calling. He was 42 years old. Dalton, or Heathcote, which was his real name, was only 22, of English birth and uneducated. Owen was a Negro. On October 15, 1812, the grand jury for the Circuit Court of the United States for Massachusetts, sitting at Boston, returned indictments against Tulley and Dalton for 1. Piracy, for 2. The murder of Cummings, and for 3. Feloniously scuttling and casting away a vessel on the high seas. The government decided to prosecute them on the first indictment. The trial took place on October 28, 1812, before Mr. Justice Story and Judge Davis. The principal witness for the government was Owen the cook, and the defense was that the ship had blown out to sea before the captain and sailors returned, and that the act was not piracy in law. The jury found both prisoners guilty, and after overruling a motion for a new trial, they were sentenced by Mr. Justice Story to be hanged on December 10th. An extraordinary incident, dramatic and inhumane, occurred on the scaffold. After being taken in a coach to the place of execution, the marshal read the death warrant and a deputy a partial confession which Tulley had written. The rope was then placed around the neck of Tulley and the bolt drawn. The officers then took Dalton, removed his collar, pinioned his arms, and drew the black cap over his head. At this awful moment the marshal stepped to the front, and after a bombastic introduction, read a reprieve which had been sent to him by the President of the United States. A month later, Dalton received a full pardon. The trial. In the United States Circuit Court, Massachusetts District, Boston, October 1812. Honorable Joseph Story and Honorable John Davis, judges, October 28th. The grand jury had previously returned 3 indictments against the prisoners, 1 for piracy, 1 for the murder of George Cummings, and 1 for feloniously scuttling and casting away a vessel on the high seas in violation of a law of the United States. James T. Austin and Peter O. Thatcher, the prisoners having no counsel, were assigned by the court to defend them. George Blake, United States District Attorney for the government. The prisoners were arraigned on the first indictment. The clerk of the court asked them if they were guilty or not guilty, to which they severally answered, not guilty, and it was then demanded of them how they would be tried, to which they said, by God and their country, and the clerk rejoined, God send you a good deliverance. After several challenges by the prisoners, the following were sworn to pass between them and the United States: William Stearns of Salem, foreman; Samuel Harrington, Worcester; John Clark, Cambridge; Jotham Lincoln, Hingham; Abraham Tuckerman, Boston; Hawks Fearing, Jr., Hingham; Samuel Gates, Worcester; Solomon B. Chards; Benjamin Seaver; Josiah Severance, Roxbury; James Lewis; Isaac Enfield, Dorchester. Mr. Blake told the jury that it was his painful duty to lay before them the law on which the indictment was founded, and the evidence which would support the charge against the prisoners, and he gave them a general outline of what the government expected to prove. Witnesses for the United States. James Holmes brought prisoners at the bar together with John Owen, a black man, from the island of St. Lucie to the United States by the authority of the island. The first port we made was Martha's Vineyard. The 3 men were delivered to the civil authority, committed to prison in New Bedford, and afterwards brought to Boston. Uriah Phillips Levy was the master and joint owner of the schooner George Washington. She was a new vessel, American registered, built in the state of Delaware, and had not been to sea till the voyage in question. On October 17, 1811, sailed from the Delaware on a voyage to Tenerife. My crew consisted of Samuel Tulley, the mate; John Dalton, a foremast hand; the prisoners, a sailor called Neal; Daniel Hopkins; George Cummings; and John Owen Cook. On December 13th, we arrived at Tenerife, landed the cargo, and took on board 14 quarter casks of wine and $2,500 in specie. On December 23rd, sailed from Tenerife to the Isle of May, one of the Cape de Verde Islands, and arrived on January 4th. Place for anchorage was pointed out to me by an American captain who lay there, and the schooner was moored in about 10 fathoms of water by 2 cables. On January 9th, at 3:00 p.m., I went on shore and left all hands on board, directing the mate to send the boat on board the brig Lambert, Captain Levi Joy, then laying there at sundown. Joseph Neal and Daniel Hopkins came with the boat at that time. I ordered them to return and come again in an hour or 2. At 8:00, Joseph and Daniel came again. Their first words made me look out for the vessel, but saw she had gone from the place she was moored, and have never seen her since. The next day I caused search to be made for the anchors, which were found and weighed. The cables were fastened to them, but both the cables had been cut with some sharp instrument at the windlass. Cross-examined. The anchorage was in an open road. There is a strong current which is felt immediately on leaving the bay. The schooner was a good sailor, but required some pumping. The last time I saw the vessel, they had been swaying up the foresail. The topsail was in the cabin. The foreyards, gibboom, and foresail were on deck. The vessel might have been got ready for sea in 5 minutes. At the time, there was only a moderate breeze, and all sail could have been set. When I first saw the schooner had gone, it was dark, yet light enough to have discovered her if she had been in the bay. No vessel was there capable of pursuing her. There was generally a heavy sea and swell running into the bay. I often left the schooner in care of the mate before. Dalton complained of being sick on the voyage, but always did his duty. Joseph and Daniel left the Isle of May with my consent for the United States. I have made careful inquiries for them, but have not found where they are. I sent circular letters respecting my loss to the United States and the West Indies, and have never obtained any information respecting the schooner. The American consul gave such intelligence respecting men detained at St. Lucie as induced me to go there, where I received from the commanding officer $1,350 and my clothes, the balance being detained for expenses. Prisoners had left the island before my arrival. John Owen belonged to the George Washington. Whilst lying at the Isle of May one day after dinner, the captain went aboard an American vessel lying there, and desired the mate to send the boat for him at sunset, which was done, but the captain did not return, and desired the boat again to be sent for him at 8 o'clock. Being cook of the vessel, I prepared supper at about 8 in the evening, of which the mate, Samuel Tulley, partook. The captain not being arrived, the provisions were left waiting for him on the table, and I went to sleep. Some time afterwards, I was called by Samuel Tulley to hold a lantern to the pigeonhole through the cabin on deck in order for him to see by the compass how the vessel was lying, it being then still at anchor. I was called up again by the mate, as were all hands, in order to make sail, the mate declaring that she was drifted. Sail was made until one of the sailors, named Neal, said he would not hoist the sail, for both cables were cut. The mate insisted. Neal and a man named Dan refused, unless he would satisfy them as to what he was going to do with the vessel. The mate refused, saying it did not signify, adding, "After the sails are up, I will give you the boat." The sails were accordingly hoisted by all hands, and the mate gave the 2 men, Neal and Dan, the boat, in which, having put their clothes, they departed. I asked to go in the boat, but the mate refused, declaring that no other person should quit the vessel. The mate continued at the helm nearly all night. The men remaining on the vessel were the mate, Samuel Tulley, Jack, who is now here and calls himself John Dalton, George, and myself. About 2 weeks were spent at sea. During the last part, George became uneasy in his mind, fell from his appetite, and used to go and kiss the mate's and Jack's hands or feet. One evening, when land was expected soon, George went to Jack and asked him when the land would be seen. Jack replied, "Tomorrow," and George replied, "Goodbye, you will not see me any more." Jack, who was steering, treated what George said lightly, asked him what was the matter, and said he was foolish, but George repeated the same things. I went below to sleep, leaving George sitting on one side of the deck and the mate sitting opposite on the other side on the hen coops. About 11 or 12 I heard a noise upon the deck and myself called for. Came upon the deck when Jack said that George was killing the mate. The mate and Jack together had George on the gunwale of the vessel, throwing him overboard. Was much confused and did not know what to do. Said it could not be and ran to the helm. The mate and Jack threw George overboard, the mate saying, "Overboard he shall go at the risk of my life." The next evening land was seen and we lay to until morning. The mate then had the longboat hoisted out, put into it the captain's large chest and several other things with the trunks of Jack and myself. Made me get into the boat, which was fastened to a line. The boat was then hauled up alongside the vessel, and the mate and Jack came into it. During the time I was in the boat, the 2 men bored holes in the bottom of the vessel to sink her, but she did not sink so long as I saw her. The mate distributed to Jack and me dollars which belonged to the captain. The mate saying we must keep secret everything that had happened and keep the money for ourselves. That evening the boat came near to the land, but being afraid of the reefs, we stood out to sea again, and next day we found the land to be the island of St. Lucie, West Indies. We went to the first house. It was inhabited by persons who spoke only French and could not make themselves understood. The mate and Dalton repeatedly enjoined me not to tell what had happened, but to say they had run afoul of a wreck and were cast away, that the captain had taken one boat and they another. The mate went to town. Dalton and I stayed till he returned with the harbor master, who took us in a boat and rowed us round to the town. Dalton then went to one place to live, and myself and the mate to another. I continued to repeat the story I had been instructed in, but grew uneasy in mind at being obliged to lie to everybody, and resolved to disclose the affair. I went one evening to Captain Taylor's, an American captain, and told the truth as I now relate it. Thereupon we were all arrested and brought here as prisoners. Cross-examined. When the vessel was drifting, it was candle-light, but the land could be seen from the deck. Dalton assisted in lowering down the boat, cannot say whether he asked for leave to go ashore or not. The night was dark, cannot say what course they steered. During most of the night the mate kept the helm, but when he left Dalton stood at the helm. Do not know if any attempts were made to put it back, but the next morning there was no land in sight. The cables must have been cut with an axe. George, the deceased, was a foreigner. The morning before he died, he gave me his earrings and breastpin and said he should not live to see land. Never heard the mate or Dalton express regret. Never expended the money received of the mate. Did not go into any company or place of amusement in St. Lucie. The money was taken from me by the officers of the government. End of Section 6. Read by Elsie Selwyn. Section 7 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of Samuel Tulley and John Dalton for Piracy and Murder, Boston, Massachusetts, 1812, Part 2. Witnesses for the defense. Captain Benjamin Harris and an experienced seaman have been at Cape de Verde Islands. There is a pretty regular trade wind there which blows off the coast, and very heavy rollers are frequent during the hurricane months, but not usual in the month of January. The anchorage in the Isle of May is very bad. Many anchors have been lost there which are apt to cut off the cables of vessels riding there. My own vessel was driven out in that manner at Bonavista. When a vessel is found to be drifting, an experienced seaman would in the first place make sail and endeavor to beat to the windward, and in moderate weather should not think it difficult to get back or to make the island of Jago where the vessels usually touch. Captain Michael Hopkins. Have heard and corroborate the evidence of Captain Harris. A vessel like the George Washington, situated as it was, and short-manned, might be driven off and find it difficult to return. When the vessel was found to have parted her cables, it was seamanlike to make sail. James T. Austin to the jury. The defendants, gentlemen, are in your hands. If there exists a reasonable doubt as to the law or the evidence, that doubt will save them. Fortunately for our country, a scene like the present rarely presents itself in our courts of justice. I persuade myself the times in which we live have not destroyed the sensibility which such a scene should excite. We hear indeed almost on every gale the dreadful deeds of war and battle, and grow more and more familiar with death. Among the many who are falling around us, 2 lives like those of the unhappy men at the bar may not be thought much addition to the melancholy catalogue. Yet, gentlemen, when the law, which is made for the protection of human life, deems it necessary to put that life in jeopardy, not for any injury to the lives of other members of the community, but for a mere injury to personal property, there is much, very much, for a jury to consider. If by your verdict the defendant should be caused to pass through the dark valley of the shadow of death, they will at least have the consolation of knowing that their fate has been sealed by an impartial and honorable jury. But if the reverse of this should be the case, if your verdict opens their prison doors and restores to them a new existence, chastened by the dangers they have incurred, and bound to honesty by the perils they have passed, the reflection of having returned to them their lives, which the law this day puts into your hands, will be to you a source of the sweetest consolation, at that awful hour when your lives shall be required by the great judge of nature. Gentlemen, the defendants are in your power. I can only repeat for them the humane wish of the law. God send them a good deliverance. Mr. Blake, it is utterly impossible, under the circumstances which have been stated, that the schooner could have drifted by accident from her moorings, and equally so that any other persons than the prisoners could have been instrumental in the perpetration of the crime. I call to your attention the strong and violent presumptions of guilt which the testimony of Captain Levy alone furnishes against the prisoners. From his testimony it is beyond contradiction that the vessel had been at the Isle of May, and that suddenly she departed, and had never since been heard of, that the mate and Dalton were on board, the mate having her in charge. That the captain's chest of clothes and some of his money had been carried by the prisoners to St. Lucie, where they were found by Captain Levy, who received them from the hands of the legal authority. That the vessel was feloniously taken is also apparent from his testimony, because the fact to which he swears positively, that on examination the cables were found to have been cut, is irreconcilable with any other supposition. The testimony of Owen, the cook, is therefore not necessary, although in a case of this kind it is satisfactory to obtain all the information which the nature of the case admits. His statement is in affirmance of Captain Levy's, and is corroborated by it so far as both witnesses were capable of knowing the same facts. It is only an enlarged and more circumstantial story to which he testifies. The captain gave the outline of the horrible picture. Owen filled up the dark particulars of the scene. In law, even an accomplice was admissible as a witness, and by every principle of common sense his evidence would be credited if it was probable, consistent, and corroborated by facts independent of it and known to exist. His statement of the departure from the Isle of May and arrival at St. Lucie was not only probably but certainly true. His story is consistent, clear, and uncontradicted in any of its parts. After an able and most ingenious cross-examination, nothing appears to make his statement in the least degree ambiguous or uncertain. He tells a plain, unvarnished tale of his whole course of life. The great advantage of a trial by jury is that jurors have an opportunity of seeing the witnesses and judging of the credit due to them by the manner in which they testify. In this instance, I leave it to you to determine whether you ever heard a more unembarrassed and intelligent and cautious witness, and whether he was an accomplice or not. It is impossible to resist the force of his testimony. But was he an accomplice? His own statement and the circumstances he has related show that he was not. He had probably no will of his own. In the most mental capacity, a mere drudge, necessary to the new masters of the vessel, but too insignificant to be for a moment consulted, he had no choice but to obey their commands. He was a man more sinned against than sinning, and as soon as he had an opportunity, evinced his regard for the laws of God and man, which he had seen so flagrantly violated, by voluntarily giving evidence to the first American captain whom he was able to meet, by means of which the defendants were arrested and brought to the bar of their country. In answer to the arguments urged by the counsel for the prisoners on the law, the government contends that every felonious running away with a vessel on the high seas is a piratical act within the statute, and if the jury believes the testimony which has been adduced, the crime contemplated by law and charged in the indictment has been perpetrated, and the jury should not hesitate to give a verdict of guilty. Mr. Justice Story and Mr. Justice Davis severely addressed the jury. Each of them recapitulated the testimony and stated the operation and effect of it, as well as in favor as against the prisoners at the bar. On the question of law, which they said had been very properly raised by the counsel for the defendants, they had bestowed as much attention as was possible during the course of the trial, and both stated explicitly their opinion that a felonious running away with the vessel was a piratical act within the meaning of the Act of Congress, and subjected the perpetrators to capital punishment. The prisoners had had a fair and patient hearing, the jury had paid close attention to the evidence, and the arguments which had been addressed to them. It was a question of evidence, and they were the sole and exclusive arbitrators. It was also a question to be settled by the judgment and not by the feelings. The appeal that had been made to their sensibility might cause them to regret the obligations imposed upon them, but as jurors the oath of God was upon them. They had a duty to do, which would be criminal in them to omit. They were bound as well by their allegiance to their country as by their tenderness for the prisoners. This duty might be painful, but it was nevertheless imperious. If in their consciences they believed the defendants were guilty, they were bound to say so and leave the consequences to Providence. Theirs was duty prescribed by justice. The more delightful attribute of mercy was, by the law, placed in other hands, and hands which never failed to exercise it where the circumstances of the case warranted the interposition of executive favor. A reasonable doubt would operate in favor of life, but the doubt must be reasonable, not the mere suggestions of fancy and the airy creations of mere possibility, but a reasonable and conscientious doubt. To such a juror was bound to listen. With such a doubt he never ought to condemn. If such a doubt remained, the prisoners were entitled to an acquittal. At 11:00 p.m. the case was given to the jury and the court adjourned until the next day. October 29th. The prisoners were brought in and the jury came into the box. Clerk: Have you agreed upon a verdict? Foreman: No. The court inquired if the jury required any further explanation of the law. Foreman: The jury does not agree that the facts in the case amounted to piracy. The court repeated the substance of their former charge on this point and ordered the jury to withdraw for further consideration. The jury accordingly retired. In about 3 hours they came again into court. Clerk: Gentlemen of the jury, have you agreed upon a verdict? Foreman: Yes. Clerk: Who shall speak for you? Jury: The foreman. Clerk: Mr. Foreman, rise and look upon the prisoners. Prisoners, look upon the foreman. Mr. Foreman, what say you? Are the prisoners at the bar guilty or not guilty? Foreman: Guilty. The court then adjourned. October 30th, the prisoners' counsel moved for a new trial on the grounds of misdirection by the court and that the verdict was against the weight of evidence. The court reserved judgment. November 9th, the court, Story and Davis justices, both delivering opinions, overruled the motion for a new trial. Mr. Blake addressed the court in a solemn and impressive speech in which he recapitulated the proceedings under the indictment, the verdict of the jury, and the law which denounced capital punishment on such conviction, and concluded by stating it to be his duty to move, and he accordingly did move, the court to proceed to pronounce the sentence of the law. Mr. Justice Story: Samuel Tulley, John Dalton, you have been charged by the Grand Inquest of the United States for the District of Massachusetts with the crime of piratically and feloniously running away with the schooner George Washington, commanded by Uriah Phillips Levy, against the statute of the United States in such cases made and provided. You have been duly furnished with copies of the indictment, and also with a list of the jury, who, upon your trial, were to pass between you and the United States. You have had counsel assigned you by the court, according to the benign provision of the law in capital cases. You have been arraigned on the indictment, and have severally pleaded not guilty. You have been tried by an impartial jury of your country, and at the trial had assistance and argument of able and learned and eloquent counsel in your defense. You have been severally found guilty by the verdict of your peers. You have accepted to the opinions of the court in matters of law at your trial. These exceptions have been fully considered by the court and upon mature deliberation have been overruled. You have now been brought into court to receive the judgment of the law, and the district attorney has now, in your presence, moved the court to proceed to judgment. What reasons have you now to show to the court why they should not pronounce sentence against you? The prisoners remain silent. Before I proceed to the painful duty imposed upon me by the law, a cup of bitterness which I would most willingly put aside, I shall make a few remarks, which I hope will impress your minds with the most solemn conviction of the turpitude of your offense, and with the mercy of God incline your hearts to contrition and repentance. The crime of which you have been convicted is of a most odious nature. It is willful, malicious, deliberate piracy. Among all civilized nations, it is esteemed as an offense which places you in enmity with the whole world, which banishes you from the hospitality and the protection of society, and consigns you to an ignominious death. In the present case, it has been attended with still more aggravated circumstances than usually attend the depredations of unauthorized plunderers of their fellow men. You are a part of a crew of a vessel navigated under the flag of the United States, entrusted by the owners with their confidence and property, and urged by every honorable motive to an honest discharge of your respective duties. The security of the commerce of the country, the maintenance of the good order of society, and the lives of thousands of your fellow citizens are intimately connected with the good faith and honesty of seamen.
How have you repaid the confidence reposed in you by the esteem of your commander? You have been treacherous and deceitful. You have had no adequate temptations, and no apology for your deliberate violations of the law. You sought the darkness of night to cover deeds which would not bear the light. You had time to consider and reflect. The midnight stars shone with disastrous light on your wickedness. The deep silence of the hour, when nature pauses as upon the brink of dissolution, gravely warned you of your fate. The morning rose in its splendor to call you back to repentance, yet you returned not. Yet you sought not the forgiveness of the world by returning to the bosom of society and repenting of your sin. Shall I stop, or shall I proceed? One crime leads on the way to another, and every step in guilt is but a new indictment to urge another. One of your companions, bowed down in spirit, overwhelmed with self-humiliation, approached you in the fullness of his sorrow, and repented and implored your mercy. Did your bowels yearn with mercy towards him? Did you endeavor to soften his woe, or seek with him the path of future peace by a return to virtue? I dread even to remember the hateful tale. His tears and entreaties were of no effect. I would not willingly accuse, much less would I, unheard, condemn you. The hour of his fate drew nigh. In the deep gloom of the night there was a most foul and unnatural murder. You heard his dying groans. You saw his last struggle. You took his lifeless corpse and plunged it amid the sullen waves. The ocean received him to its bosom and returned back its short but awful murmurs. Were you guilty of this atrocious crime? I will not say. Let your own hearts and consciences declare. The morrow saw no tears and no contrition. The deeds of night were but the precursors of a new destruction. The vessel was herself the next object of ruin, and she was wantonly scuttled and left to sink to the bottom of the sea. Foul and deliberate falsehoods close the horrible history of your crime. Yet though these transactions were veiled from human eyes, think not that they escaped the all-seeing eyes of that being who createth and governeth the universe. At that solemn hour when deep sleep falls upon the sons of men, his ever-watchful mind is awake. When darkness surrounds the plunder of the public pirate, he is ever present and marks the wanderings of wickedness. When murder riots in supposed security, he hears the voice of dying innocence, and his own right arm shall avenge the deep damnation of the deed. I would not willingly afflict you in your fallen condition, but I must awake your consciences to an awful sense of your impending fate. You are now soon to be cut off from life, and those cheering beams which now surround you will soon be shut from your sight. The grave will become your cold and solitary residence, and the places that now know you shall know you no more. You are in the bloom and vigor of your days, yet society has found it necessary to arrest them and to send you, with all your imperfections on your heads, to another world. Think, oh think, after what has happened, how can you appear before that dread tribunal and that omnipotent judge who searcheth the hearts and trieth the reins of all men? From his sentence there is no appeal, and before him you must soon appear to render an account of all the deeds done in the body. There can be no concealment or shelter there. The accusing spirit of conscience will rise in judgment against you, and the voice of your poor unfortunate brother will be heard from the very depths of the ocean. Let me entreat you, tenderly and earnestly entreat you, as dying sinners, to turn from your wicked thoughts, to ponder on the errors of your ways, and with penitence and humiliation to seek the altars of our holy religion. Let me entreat you to pray for mercy and forgiveness from that righteous God, whom you have so justly offended. The time perhaps may not be too late. The glory of Christianity may yet brighten your declining days, and the spirit of redeeming grace may drop a tear on your sins and blot them out forever. I now proceed to pronounce the awful sentence of the law upon your crime. Whereupon all in singular the premises being seen, and by the said judges of the said court here fully understood, it is considered by the court here that the said Samuel Tulley, John Dalton be, and they hereby are severally deemed, taken and adjudged to be pirates and felons, and that they, the said Samuel Tulley and John Dalton, in each of them be hanged by the neck until they, in each of them, be dead. And it is further ordered and considered by the court here that the marshal of this district do, on peril of what may fall thereon, cause execution to be done in the premises aforesaid upon them, the said Samuel Tulley and John Dalton, on the 10th of December next ensuing, between the hours of 10 o'clock in the forenoon and 3 in the afternoon of the same day. and that they, the said Samuel Tulley and John Dalton, be now taken from hence to the jail in Boston, in the district of Massachusetts, from whence they came, there or in some other safe and convenient prison within the district aforesaid, to be closely kept until the day of execution, and from thence, on the day appointed for execution as aforesaid, to be taken to the place of execution in Boston aforesaid, there to be hanged as aforesaid. I recommend you to the mercy of Almighty God, before whom we shall all one day appear, and I pray that he may succor and support you in the hour of trial, and I now bid you an eternal farewell. The execution. On December 10th, at 11 o'clock, prayers were offered in the state prison, and the convicts were taken under care of the marshal and his officers, and conducted to the place of execution at South Boston. When the prisoners had ascended the scaffold, the marshal read the death warrant. Tulley then wished to read a paper which he had prepared, but his strength failing him, he desired one of the deputy marshals to read it for him as his dying words, as follows. As a man and criminal now going out of this world, I do think it is my duty to acknowledge that I have been guilty of taking and assisting to take the property which is mentioned in the first indictment, but the murder which was charged in the second indictment I do not see that I am in any ways guilty of, although it was pled so hard against me, and I have reason to believe was the means of my being condemned, but if not, I acknowledge the justice of my sentence. But if otherways, I pray that the Almighty God will forgive those who have done me this wrong, and I freely forgive them from the bottom of my heart, as I hope the Almighty God will forgive me, not only this, but all the sins and wickedness that I have done in the world. This crime for which I now suffer is a horrible crime to think upon, and I beg that it may be a warning to everyone that may hear of it or witness my sad fate. And I do think that it is my duty to express with gratitude my sincere thanks to the marshals and to other gentlemen in whose hands and charge I have been since I first came to Boston, and particularly to the wardens and keepers of the state prison in Charleston, and Colonel Gardner in particular for his kindnesses shown to me. I give my sincere and my hearty thanks to all the ministers and other pious people of different denominations who have assisted me with their repeated visits and their good advice, their prayers, their sermons, and their pious and godly books to bring me to a due sense of myself, to open my blind and wicked heart, and to soothe my sorrows, to bring me to true repentance for all my sins and wickedness, and to prepare me to meet my awful sentence in death, and to meet the Almighty God who gave me my existence, and has been my whole support through this vale of life. And undoubtedly it has been his good will and pleasure that I should suffer this side the grave, to expiate for the sins and wickedness which I have wilfully committed against so good and merciful a Creator, and to bring me to his only Son, Jesus Christ, the Redeemer and Savior of the world, in whom I put my whole trust, hope, and confidence, well knowing there is no other name under heaven whereby I can be saved. Therefore I resign myself to his gracious disposal, with my body to the earth from whence it came, and my spirit to the Lord who gave it. And may the Lord Jesus Christ have mercy on my poor soul. Amen. The rope was first placed round the neck of Tulley, who ascended the platform and continued fervent in prayer, and in the presence of an immense concourse of spectators was launched into the eternal world. Dalton, who was not desirous of saying anything at the place of execution, was then taken and his neckcloth removed, the rope fixed, his arms pinioned, the cap drawn over his eyes. An awful moment of anxiety was felt by the assembled crowd. One instant more, and he would have followed his companion to the world of spirits, when the marshal stepped forward and then addressed the spectators. Friends and fellow citizens, the good people of the United States, when they formed their national compact, wisely ordained among the duties assigned the President that he should execute the laws with judgment and with mercy, while therefore he has left that man, pointing to Tulley, who is now suspended between heaven and earth, a spectacle for men and angels, to suffer the pains adjudged him by the law, he has been disposed in mercy to respite the sentence of this man, pointing to Dalton, for a few days, that he may gain that information which may perhaps incline him to extend further favors. The marshal then read a reprieve by order of the President of the United States till the 10th day of January 1813. Within the time limited, Dalton received his full pardon, signed by the President, and issued under the Great Seal of the United States. End of Section 7. Read by Elsie Selwyn.
Section 8 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Elsie Selwyn. American State Trials, Volume 1 by John D. Lawson. Trial of Francis Mezzars for libel, New York City, 1817. The narrative. A French artist in New York, Monsieur Francis Mezzars, was employed by a prominent lawyer to paint his portrait, but when it was finished it did not please either the subject or his friends, and he refused to take and pay for it. The artist was angry and sued the lawyer for the price, but a jury found that the refusal was quite justified and gave a verdict against him, and he had to pay the costs. In addition, to collect these costs, a deputy sheriff went to his studio with an execution, but the artist told him that the only property he had to satisfy it was the rejected picture, and that he could levy on that if he wished. He did so, but a friend of the artist gave a bond for its production on the day set for its sale under execution. Thereupon the artist published the following notice in a New York paper. Curious Sheriff's Sale. We have been requested to mention that there will be sold this forenoon at public vendue at number 133 Water Street a picture intended for the likeness of a gentleman in this city who ordered it painted. But as the gentleman disclaimed it, it remained the property of the painter and is now seized by execution. In order to enhance its value, the painter, who is an eminent artist from Rome, has decorated it with a pair of long ears, such as are usually worn by a certain stupid animal. The goods can be inspected previous to the sale. This was not very agreeable to the lawyer, who on the day of the sale, which attracted a large crowd, tried to purchase it himself through an agent, but it was knocked down to a friend of Monsieur Mezzars. Then the lawyer had the artist arrested for libel. His defense was that when the lawyer refused it, he told him he could do with it what he liked, and that what he had done was only to transform it from a portrait of the lawyer to a picture of Midas. The jury did not take this view of the case, but found him guilty of criminal libel. The trial. In the Court of General Sessions for the City and County of New York, City Hall, August 1817. Honorable Jacob Radcliffe, Mayor. Reuben Munson, Alderman. James Hobson, Special Justice. August 4th. Francis Mezzars was indicted for a libel published against Aaron H. Palmer. The indictment, which contained several counts, stated that Palmer, at and before the publication of the libel, was a counselor and attorney at law in New York City, and a master in chancery and attorney, that the defendant, contriving him the said Aaron H. Palmer to bring into public hatred, ridicule, and contempt, on the 30th day of July, then last past, at the city of New York, falsely and maliciously did make, utter, and publish a certain picture, portrait, or resemblance of the said Aaron H. Palmer, with the ears of an ass at the head of such picture or resemblance, and also for that the said defendant, further intending him the said Aaron H. Palmer into public hatred, ridicule, and contempt to bring, did cause and procure to be inserted in a certain public paper in the city of New York, called the Republican Chronicle, the following libel of and concerning him the said Aaron H. Palmer. Curious Sheriff's Sale. We have been requested to mention that there will be sold this forenoon at public vendue at number 133 Water Street a picture intended for the likeness of a gentleman in this city who ordered it painted, but as the gentleman disclaimed it, it remained the property of the painter and is now seized by execution. In order to enhance its value, the painter, who is an eminent artist from Rome, has decorated it with a pair of long ears, such as are usually worn by a certain stupid animal. The goods can be inspected previous to the sale. Hugh Maxwell, District Attorney, W. M. Price, and Mr. Wilkin for the people. Mr. Emmett, Mr. Sampson, and Mr. Ogden for the prisoner. Mr. Emmett moved for a special veneer to summon a jury de meditate linguae under the statute, which motion was granted. On the return of the veneer, a number of the jury were called who did not understand the English language. The court directed these to stand aside, and that the sheriff should summon a tales of such as spoke the language, which was done, and the jury selected and sworn. Witnesses for the people. Jonathan L. Brewster. Am a deputy sheriff.
In July last, an execution in favor of Aaron H. Palmer against Francis Mezzara for $24 was put into my hands. I went to Mezzara, who represented that he had no other property to satisfy the execution except the picture, which he pointed out and which I recognized as the likeness of Mr. Palmer. I levied on the picture, and John Chanou, a friend of Mezzara, became surety for its delivery on the day of the sale, and it was retained by him. The sale took place on the 30th of July. On calling for the picture, I found it disfigured by the appendage of ass's ears to the head. I carried it to the Ingram's auction room, where it was exposed for sale in the presence of an unusual collection of people. Mr. Palmer, having discovered just before the sale that the picture was disfigured, instructed me to have it bid as high as $30 for the purpose of having it destroyed, and a young man, a clerk in the auction room, bid to that sum for Palmer. But the picture was struck off to one of Mezzara's friends for $40, and the amount of the execution was paid to the sheriff by Mezzara in person. Samuel Woodworth. I wrote the article in the Republican Chronicle from instructions I received from 2 foreigners who were strangers to me. One of them is the defendant. They had first spoken to Mr. Baldwin, the proprietor, who introduced them to me. They told me the story, and I told it in my own language. Nathaniel G. Ingram. Am an auctioneer and sold the picture in presence of a large collection of people. Mezzara attended and appeared to be much elated. He advised me to take it and exhibit it in a more conspicuous place, that it might be inspected by the people. The crowd became so great that I had to remove it to the back room. Aaron H. Palmer. Became acquainted with Mezzara, who professed himself to be an eminent artist from Rome, and who had been in this city about 6 months at the house of Baron Quinet, a French gentleman residing in this city. He represented Mezzara to me as a man of genius and an eminent connoisseur in the fine arts. In consequence of this, I treated the prisoner with considerable attention and invited him to my house to dine. While at dinner, he proposed to draw my portrait, and was very solicitous that I should sit for it, saying that there was a very striking peculiarity in my forehead, and that my head was a head of study, expressing it in French as en tête d'étude. Later, and after repeated importunity on his part, I reluctantly consented to sit, and the portrait was made. He put it into a frame and carried it to the Academy of Arts without my knowledge or consent. Previous to this, however, I had seen the picture in an unfinished state and expressed no particular disapprobation of the performance. After it had been exhibited in the Academy of Arts, I inspected it more closely and thought it unworthy of an artist of eminence. My friends pronounced it to be a caricature, was much displeased and disappointed, and mentioned my opinion and that of my friends to the prisoner whom I met on Broadway, tendered him the full charge for the painting, $65, and at his request gave him a certificate authorizing him to keep the picture. Mezzara, considering his professional skill decried and his feelings wounded, refused to receive the money and was very vindictive in his remarks, alleging that I had wounded his self-love and that he would have satisfaction. In the afternoon he sent a young man for the money, which I then refused to pay. He then began an action in the mayor's court to recover the price, but failed. The evening the verdict was rendered against him, he obtruded himself upon me on Broadway while I was conversing with Barrett Gardinier and Isaac M. Eli. I told him if he considered himself aggrieved by the verdict, I was disposed to do him justice, and that he should have no cause to complain of my want of generosity. Mezzara then invited us to his room to inspect the picture. He was very abusive on finding that these gentlemen did not concur in his opinion respecting the likeness, and as we were about leaving the room, he took a chalk and sketched an ass's ear on the head, threatening to paint them upon it and expose it on Broadway. John W. Jarvis. Am a portrait painter. Saw the picture before it was disfigured in Mezzara's room. It was an imperfect likeness and a blotch. Saw the picture again in possession of the prisoner, who is exposing it, seemingly in a triumphant manner, in Pine Street, with the appendage of the ass's ears. It was not a representation of Midas. John Chanou, a Frenchman who testified through an interpreter. After the failure of his suit, Mezzars told me he had a lawsuit against a man for whom he made the picture who had a judgment against him. The picture had cost him much time and money. He had paid $15 for a frame, and since it had become his own property, he must do the best he could with it. Did not hear from Mezzars that he was about transforming the picture into a Midas, nor did I know anything of the story of that king. Maria Brunet. Am a French woman. When Brewster came to take away the picture, on the day of the sale, Mezzars asked him if he could be injured by reason of the transformation mentioned, and the sheriff answered in the negative. Maria McDowell. Am a French woman. Mr. Emmett. Did the defendant, at the time he was painting the ass's ear, not say he was painting a Midas? Objected to by Mr. Price. Mr. Ogden contended that the testimony was admissible as a circumstance to show a want of malice. The declaration being made at the precise time of the painting was a part of the res gestae. The court decided in favor of the defense, and the witness answered in the affirmative. Thomas Blanchette called on Palmer with a bill for the painting. He told me he would see Mezzars on the subject, and I replied that it would be of no use unless the money was paid. Baron Gardinier, called by prosecution. Toward the evening of the day of the trial in the mayor's court, concerning the picture, Isaac M. Eli and myself were conversing with Mr. Palmer when the prisoner came up and joined us. He appeared much agitated and invited the three of us to his room in Reed Street, where he showed us the picture for our opinion. I did not express my approbation of the performance very strongly, and the language of the prisoner towards Mr. Palmer was intemperate. Before his visitors had left the shop, the prisoner said to Palmer, "Since this is not your picture, you will not be offended at this." At the same time he took a piece of chalk and sketched a pair of ass's ears on the head of the picture, evidently with the design of wounding Palmer's feelings. Palmer, however, kept his temper and seemed to smile, but I thought it gave him pain. Mr. Price read the law on which the counsel for the prosecution intended to rely from Starkey's law of slander, and adverted to the authorities there cited. Mr. Sampson and Mr. Ogden on behalf of the defendant. 1. That this was either a likeness of Mr. Palmer or it was not a likeness. If a likeness, it was his duty to have paid the painter. If not, the appendage of ass's ears on a picture not a likeness was not a libel on him more than any other individual. 2. The prisoner is not guilty of a publication of the picture. It was taken under an execution in favor of Mr. Palmer and exposed by him for sale. The sheriff, who in the transaction was the agent of Mr. Palmer, ought not to have taken the picture in its disfigured state on the day of sale, but should have resorted to his action on the bond given for its delivery. It was, in truth, not the same picture which had been originally seized, and the bond was therefore forfeited. 3. Palmer had relinquished all rights to the picture, had declared it was not his likeness, and had given the other express authority to dispose of it as he thought proper. 4. After this, the prisoner, having expended much time and money in the performance, had been subjected to an additional loss by the failure of his action, and having the picture thrown on his hands, had a right to make the best use of it he could. He actually intended to metamorphose the picture into a representation of Midas, and was not actuated by any malicious or mischievous intention towards Mr. Palmer. Even if he had such intention, he was a stranger in our country, and unacquainted with the severity of our laws on the subject of libel. Mr. Price. Although this was not a perfect likeness of Mr. Palmer, yet it so far resembled him that all his acquaintances knew he was the person whom the picture designed to represent. The appendage which was superadded was manifestly intended to hold him up to public ridicule. After the prisoner had failed in his action, he determined to revenge himself on Mr. Palmer by affixing ass's ears to the picture. In presence of Messrs. Gardinier and Eli, he manifested this determination by chalking or sketching such ears, which he afterwards finished in oil. In the auction room he endeavored to have the picture exhibited to the view of the people, who had been drawn there by means of an advertisement, of which he was the author, published in a public newspaper. He exhibited the picture in a triumphant manner in the streets, after having bid it off at auction and paid the money. These acts sufficiently fastened on the defendant the charge of publication. Mr. Wilkins. Where is this conduct to stop? What is to deter the defendant from exhibiting this picture in our streets again and again, but the wholesome restraint of a verdict? And yet, gentlemen of the jury, what is to be done with the man? Should you acquit him, he still continues to hold up this respectable citizen, this counselor and master in chancery, to public contempt and ridicule. Should you find him guilty, I am not certain but that to revenge himself, he will draw your pictures with his ass's ears, and I fear their honors on the bench will share the same fate. But still, neither their honors nor you, gentlemen, are to be deterred from the plain path of duty by such considerations. Palmer, by relinquishing all right to the picture and leaving the prisoner at liberty to dispose of it as he thought proper, did not thereby license him to do an unlawful act, an act which could hardly have entered into the contemplation of any man. The manner in which this written certificate was obtained shows a subtle contrivance and artifice on the part of the prisoner to avail himself of the license and justification of a libel, the publication of which he then meditated. The Mayor. Although the libel charged in the indictment is in its nature private, and therefore not important in a public point of view, yet the case, by reason of its peculiar nature, requires your serious attention. Any publication, picture, or sign made with a mischievous or malicious design, which holds up a person to public contempt or ridicule, is denominated a libel. You ought to consider that the reason of that verdict in the mayor's court in favor of Mr. Palmer was that the jury did not consider the picture a proper likeness of Mr. Palmer for which he was bound to pay. On this subject, the verdict of that jury furnishes a guide to this. Now it appears that after the verdict was rendered in the mayor's court, the prisoner, in presence of Mr. Gardenier and others, drew or sketched this appendage to the picture in chalk and used intemperate language to Mr. Palmer. This is urged as a circumstance manifesting the mischievous intention of the prisoner. On the day of the sale, he caused an advertisement to be inserted in a public newspaper, giving an account of the sale of the picture in its disfigured state. This advertisement furnishes perhaps the best evidence of his intention in the transformation of this picture. Afterwards we find, by the testimony of Mr. Ingram, that the prisoner attended at the time of the sale and wanted the picture exposed to the view of the people. From all the facts and circumstances in the case, it will be the duty of the jury to determine whether the prisoner, in altering this picture and thus exposing it, has not been actuated by motives of resentment and revenge. Should this be the opinion of the jury, he ought to be found guilty. A certificate has been produced in evidence on the part of the defendant, bearing date the 20th of May last, by which Mr. Palmer, at the request of the prisoner, gave him liberty to dispose of this picture as he thought proper. This certificate cannot, in the opinion of the court, amount to a license to publish a libel. This was not the object nor intention with which it was given. The prisoner, having originally undertaken to draw a correct likeness of Mr. Palmer, was bound to perform according to the undertaking. In the view of the court, the verdict in the mayor's court may have been rendered on the ground that this was not such a likeness as Palmer had a right to expect. The story of Midas was so distant and had so little application to the case that the court does not think it proper to detain you on the subject. The jury retired at about 11 o'clock in the evening, continued together during the night, and the next morning at about 9 o'clock returned with a verdict of guilty. The court sentenced the prisoner to a fine of $100. End of Section 8.
Section 9 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Jim Dykstra, Farragut, Iowa. American State Trials, Volume 1, by John D. Lawson. Trial of the Reverend Jacob Gruber for inciting slaves to insurrection and rebellion, Frederick County, Maryland, 1819. Part 1. The Narrative. On August 16, 1818, a camp meeting was held in Washington County, Maryland, under the auspices and management of the clergy and laity of the Methodist Episcopal Church. At the first Sunday evening service, a sermon was preached by the Reverend Jacob Gruber, a native of Pennsylvania, presiding elder of his district, from the text, "Righteousness exalteth a nation, but sin is a reproach to any people." Proverbs chapter 24, verse 34. In it, he laid great emphasis upon slavery, which he called a national sin. It is, he said, a reproach to our nation. We boast that we live in a free country and pity other people who are under the rule of emperors and kings. Yet we have slaves around us whose sweat and blood and tears call to heaven for relief. We have Bible and missionary societies to send the Bible to the heathen, but we do not teach it to the heathen in our own kitchens. We sell human beings like cattle. If they escape from us, we offer rewards for their captures. You say we use our slaves well, but are we sure that our successors will, and that someday our children and children's children may not be killed by a slave insurrection? Thus he spoke to the 3,000 or more whites in the congregation. To the 300 or more blacks who were present, he said, "Of all people in the world, you ought to have religion, for that only can give you happiness and peace. Some of you have good masters, some of you have cruel masters, and you are slaves to them, slaves to sin and slaves to the devil. But if you repent, no matter how hard your sufferings are in this world, it will soon be over, and you will have crowns and kingdoms of glory, while your wicked masters will be sent to hell and eternal damnation." One man who heard the sermon declared that he had also stated that he would not be surprised if the slaves of some masters were to cut their throats in their beds. Another that he said he would not be surprised if the blacks should poison their masters' children, for masters had no right to punish Negroes who were born free. At the March term 1819, the preacher was indicted by the grand jury of Washington County, Maryland, for unlawfully, willfully, and maliciously instigating and inciting Negro slaves, the property of citizens of the state, to mutiny and rebellion, to resist the lawful authority of their masters and owners, and to raise insurrection and rebellion in the state. Alleging that the citizens of Washington County were prejudiced against him, he obtained a change of venue to Frederick County. The trial began on March 10th at Fredericktown and ended in his acquittal. The great interest in this trial lies in the personnel of the counsel employed in it, 2 of whom were leaders of the bar of the state and nation, and one reached the highest judicial office in the land. Luther Martin was then 71 years of age, had been Attorney General of Maryland for 30 years, a delegate from Maryland to the Constitutional Convention of 1787, and had been counsel for the defense on the impeachment trial of Judge Samuel Chase and the treason trial of Aaron Burr, and in 1818 he again became Attorney General of Maryland. His last appearance in any case was in McCulloch v. Maryland before the Supreme Court of the United States in 1819. But who was the lawyer who opened and closed the case for the prisoner and threw into his defense all the power of a great advocate and a great jurist? Who was it that declared to the jury that in all that he had said in his sermon, the Reverend Mr. Gruber was right, that he would use the same language here in the temple of justice and in the presence of the ministers of the law that the prisoner did in his sermon to the slave owners and their slaves? Who was it in that county courthouse on that day that denounced slavery as a blot on our national character, an evil imposed upon us by another nation while we were in a state of colonial vassalage, and asserted that every lover of freedom looked hopefully to the day when this stain would be removed? It was no less a person than Roger Brooke Taney, who, 37 years later, was, as Chief Justice of the United States, to bring upon himself the criticism and the abuse of more than half a continent for his decision in the celebrated Dred Scott case, that a Negro was not a citizen within the Constitution of the United States. Today, the heat and passion of the old war days having gone, the correctness of the law as Taney laid it down is being acknowledged even in the court over which he presided. And does not this trial, which has been forgotten for nearly a century, clearly show that in delivering his celebrated judgment, Chief Justice Taney was speaking as a jurist expounding the law, and not as a partisan who sought to fix his views of slavery upon the nation. The trial. In the County Court of Frederick County, Maryland, March 1819. Honorable John Buchanan, Chief Judge. Honorable Abraham Schreiber, Honorable Thomas Buchanan, Associate Judges. The Reverend Jacob Gruber had been indicted by the grand jury of Washington County, Maryland, for inciting Negro slaves to mutiny and rebellion, for instigating them to resist their lawful owners and break the peace of the state, and for endeavoring to stir up insurrection and rebellion in the state. Footnote: State of Maryland, Washington County, to wit. The jurors for the State of Maryland, for the body of Washington County, upon their oath present, that Jacob Gruber, late of the said county, clerk, being a person of an evil, seditious, and turbulent disposition, and maliciously intending and endeavoring to disturb the tranquillity, good order, and government of the State of Maryland, and to endanger the persons and property of a great number of the quiet and peaceable citizens of the said state, on the 16th day of August, in the year of our Lord 1818, at the county aforesaid, unlawfully, wickedly, and maliciously intended to instigate and incite divers Negro slaves, the property of divers citizens of the said state, to mutiny and rebellion, for the disturbance of the peace of the said state, and to the great terror and peril of the peaceable citizens thereof, and that the said Jacob Gruber, in prosecution of his said wicked intention and purpose, and for the effecting and accomplishment thereof, on the said 16th day of August, with force and arms, at the county aforesaid, unlawfully, wickedly, maliciously, and advisedly did endeavor to stir up, provoke, instigate, and incite divers Negro slaves, whose names to the jurors aforesaid are as yet unknown, the property of divers citizens of the said state, and inhabiting in the county aforesaid, with force and arms, unlawfully, seditiously, and wickedly, to commit acts of mutiny and rebellion in the said state, in contempt and in open violation of the laws, good order, and government of this state, to the evil and pernicious example of all others, in like case offending, and against the peace, government, and dignity of the state. And the jurors aforesaid upon their oath do further present that the said Jacob Gruber, being such person as aforesaid, and unlawfully, maliciously, and wickedly designing, intending, and endeavoring again to disturb the peace, tranquillity, good order, and government of the said state, and further to endanger the persons and property of the quiet and peaceable citizens of the said state, and to incite a great number of other Negro slaves, the property of divers citizens of the State of Maryland, to disobedience, insubordination, and rebellion, to and against their masters, and to break the peace of the said state upon their said masters, to the great peril, annoyance, and disturbance of the quiet and peaceable citizens of the said state, afterwards, to wit, on the day and year aforesaid, with force and arms, at Washington County aforesaid, unlawfully, wickedly, maliciously, and advisedly did endeavor to stir up, provoke, instigate, and incite a great number of the said late mentioned Negro slaves, whose names to the jurors aforesaid are as yet unknown, the property of divers citizens of the said state, and inhabiting in the said county aforesaid, with force and arms, unlawfully, seditiously, and wickedly, to resist the lawful authority of their said respective masters and lawful owners, whose names to the jurors aforesaid as yet unknown, and to break the peace of the said state upon their said respective masters and lawful owners, to the great damage of the said masters, in contempt and in open violation of the laws, good order, and government of this state, to the evil and pernicious example of all others, in like case offending, and against the peace, government, and dignity of the state. And the jurors aforesaid, upon their oath aforesaid, do further present, that the said Jacob Gruber, being such person as aforesaid and maliciously and wickedly designing, intending, and endeavoring again to disturb the peace, tranquility, good order, and government of the said state, and further to endanger the persons and property of the quiet and peaceable citizens of the state of Maryland, afterwards, to wit, on the day and year aforesaid, at Washington County aforesaid, unlawfully, wickedly, and maliciously intended and devised to stir up, provoke, instigate, and incite divers other slaves, actually to raise insurrection and rebellion in this state, for the disturbance of the peace of the said state, and to the great terror, peril, and disturbance of the quiet and peaceable citizens thereof, and that the said Jacob Gruber, in prosecution of his said wicked intentions and purpose, and for the effecting and accomplishing thereof, on the said 16th day of August, in the year aforesaid, with force and arms at the county aforesaid, unlawfully, wickedly, and maliciously did endeavor to stir up, provoke, instigate, and incite a great number of the said last mentioned slaves, whose names to the jurors aforesaid are as yet unknown, inhabiting in the county aforesaid, actually to raise insurrection and rebellion in this state, in contempt and in open violation of the laws, good order, and government of the said state, to the evil and pernicious example of all others, in like case offending, and against the peace, government, and dignity of the state. End of footnote. He pleaded not guilty, and on his application, based on the ground that he could not get a fair trial in Washington County, the venue was changed to Frederick County, where the trial took place. Luther Martin, Attorney General, and Franklin Anderson, District Attorney for the state. Roger B. Taney, Mr. Pigman, and Mr. Martin for the prisoner. Mr. Anderson, in opening the case, told the jury that Mr. Gruber's offense was committed in the course of a sermon preached by him. It is well known that slaves are property, according to our laws, and that masters are entitled to protection, and any attempt to incite slaves to insubordination and resistance to the lawful commands of their masters ought to be punished. But in the prosecution of our inquiry on this occasion, gentlemen, we must not forget that liberty of opinion and speech is the privilege of every citizen, and if Mr. Gruber had no criminal intent in his sermon, he has committed no offense. It is your duty and your province to judge of the intent from the facts that will be disclosed. Witnesses for the state. Dr. Frederick Dorsey was at the camp meeting and heard the sermon. Mr. Gruber spoke of the tyranny of masters and gave a dialogue of what was to pass in hell between masters and slaves upon hot gridirons, drew a comparison between Pennsylvania and Maryland, and said that the people in the gospel did not read, believe, or obey it themselves, nor teach their families to read that book, nor allow them to hear the gospel of their salvation preached, and said that the people in the former state were surprised to see in the Maryland newspapers advertisements of Negroes for sale, with stock and lands. Negroes sold for life, without fault. None need apply without cash. The price of a soul. $200 reward. $100 reward. $50 reward for a Negro runaway. A man gone to see his wife, or wife gone to see her husband. Fear of punishment on their return, perhaps, keep them from home. He said he should not be surprised if they were to poison your children, and all go to damnation together. To which there was a general response of Amen, Amen. He said it was true some slaves had good masters, but what security have fathers that children will use them well? May not the slaves you leave as property rise against your children? What security have you that your children will not tyrannize over them, and the slaves poison your children? Masters had no right to punish. Negroes were free. They were born free. He quoted the Declaration of Independence, that all men are equal and entitled to life, liberty, and the pursuit of happiness. He said that the husband had no right to punish his wife, neither has a master any right to punish his slave. I was disgusted and went off. Mr. Pigman, what part of the discourse was addressed to the Negroes? A considerable part of it. What was the number of whites at the meeting? About 3,000 whites, and from 300 to 500 blacks. What was the manner of Mr. Gruber? He preached with energy and zeal. What was the text of Mr. Gruber? I do not recollect the text, but he preached the necessity of repentance to the blacks as well as the whites. David G. Yost was at the meeting and heard the sermon. He said he was opposed to slavery as a man and much more as a Christian. It was a reproach to the people of America to boast of their liberty while they held thousands in bondage. That there was a great inconsistency in holding the Declaration of Independence in one hand and a bloody whip in the other, and the blood streaming from a Negro's back, literally cut to pieces. He spoke of the advertisements in the Maryland papers, mixing Negroes for sale with stock, land, etc., and offering a reward for men who, perhaps from inhuman treatment, had gone to see wife and children. He then addressed the blacks, and exhorted them to emancipate themselves from the services of the devil, and warned them if they and their masters lived and died in sin, they would all go to hell together. Then he addressed the whites. You say you use them well. Granted, but how do you know your children, to whom you leave them, will use them well? They may tyrannize over them, and the slaves may rise up and poison or cut the throats of your children. In his address to the Negroes, he particularly exhorted them to get religion and seek the pardon of God for their sins, and be happy. Dr. Hammond heard the sermon. He spoke in part of it of advertisements in the newspapers in which men were offered for sale with cattle. Negroes were offered for sale without any fault. The cruelty of some masters were such that he should not be surprised if the slaves would enter their bedrooms in the dead of night and poison them or cut their throats. He seemed to speak in a great passion. One could hear him half a mile distinctly. He said Negroes were sometimes whipped for trifling faults, that they could not serve God and man. The part of his sermon addressed to the black occupied 10 or 15 minutes. Mr. Pigman, do you remember that part of Scripture where our Savior told the Jews and others who heard him that they could not serve God and mammon? I do not remember any such Scripture. Mr. Claggett, I was at the meeting. Mr. Gruber said it was very inconsistent for people in this land of boasting liberty to hold the Declaration of Independence in one hand and a whip stained with human blood in the other, that it was a common thing to see human flesh offered for sale in Maryland, with cattle and other stock. Horrid it was, he said, to the people of Pennsylvania to hear of these things. He said he should not be surprised if these Negroes poisoned or cut the throats of the children of their masters, and all go to destruction together. There were about 4,000 or 5,000 persons present, and out of that number about 400 or 500 blacks. Did not hear the address to the blacks. I left the ground before that. Daniel Schnebley. I got displeased with him early in his sermon and left the ground and returned again, and heard him, in addressing the whites, say he should not be surprised if they, the Negroes, rose in the night and killed their masters, and entered their bedrooms and poisoned their children. There was from 5,000 to 6,000 people present, and out of them about 300 to 500 Negroes. He preached with a good deal of warmth. Dr. Finley heard Mr. Gruber preach the sermon. The general scope was to entreat the congregation to obtain religion. he preached with zeal and vehemence, but no more so on that occasion than usual. I have heard him often, and he delivered his sermon in his usual manner. He said under these cruelties slaves might be faithful to one generation, but not to their descendants, that it would not be surprising if the children to whom they were left, treating them with cruelty, should cause rebellion and end in mutual strife. The Negroes should cut their throats or kill them, be hung for it, and all go to destruction together. He said some slaves were treated as if they had no souls. Though they were black, they still had human feelings, and many of them possessed keen sensibility. Those who tyrannized over the Negroes might be in hell, while the Negro thus used, if faithful, might be in happiness. It was degrading to humanity to see human souls mixed with horses, cows, and stock, and offered at a public sale to the highest bidder. That it was inconsistent with the Republican principles of this nation to hold the Declaration of Independence in one hand, while the bloody scourge was brandished over the trembling slave with the other. Mr. Ingram heard the sermon, and remember he said that the slaves of some masters might enter their bedrooms and cut their masters' throats. Did not pay attention to his sermon. Don't remember the text. Mr. Hogmeyer. Mr. Gruber said he should not be surprised if slaves were to cut their masters' throats and poison their children. Mr. Wrench. Do not remember the text. I got so mad with Mr. Gruber for his severity on other sects of Christians that I do not remember much about the sermon. End of section 9. Section 10 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Jddykst, Farragut, Iowa. American State Trials, Volume 1, by John D. Lawson. Trial of the Reverend Jacob Gruber for inciting slaves to insurrection and rebellion, Frederick County, Maryland, 1819. Part 2. The Defense. Mr. Taney. The statement made by the district attorney informs the jury of the interesting principles involved in the trial now pending before you. It is, indeed, an important case in which the community, as well as the accused, has a deep interest. The prosecution is without precedent in the judicial proceedings of Maryland, and as the jury are the judges of the law as well as the fact, it becomes my duty not only to state the evidence we are about to offer, but to show the grounds on which we mean to rest the defense. I need not tell you that by the liberal and happy institutions of this state, the rights of conscience and the freedom of speech are fully protected. No man can be prosecuted for preaching the articles of his religious creed, unless indeed his doctrine is immoral and calculated to disturb the peace and order of society. And subjects of national policy may, at all times, be freely and fully discussed in the pulpit or elsewhere without limitation or restraint. Therefore, the reverend gentleman whose cause I am now advocating cannot be liable to prosecution in any form of proceeding for the sermon mentioned by the district attorney, unless his doctrines were immoral and calculated to disturb the peace and order of society. The sermon in itself could in no other way be an offense against the laws, if his doctrines were not immoral, if the principles he maintained were not contrary to the peace and good order of society. He had an undoubted right to preach them, and to clothe them in such language, and to enforce them by such facts and arguments as to him seemed proper. It would be nothing to the purpose to say that he offended, or that he alarmed some, or all of his hearers. Their feelings or their fears would not alter the character of his doctrine, or take from him a right secured to him by the Constitution and laws of the state. But in this case, He is not accused of preaching immoral or dangerous doctrine. That is not the charge contained in the indictment. The preaching of such a sermon is not laid as the offense. He is accused of an attempt to excite insubordination and insurrection among our slaves, and the intention of the preacher is the essence of the crime. On this indictment, no matter what doctrines he preached, no matter what language he used, yet his doctrines or his language could not amount to the crime now charged against him. They would be evidence, I admit, to show his intention, but they would be nothing more than evidence, and could not constitute the offense itself. The intent of the accused is the great object of your inquiry. The charge is a grave and serious one. It is necessary, in order to support the prosecution, that the wicked intention charged in the indictment should be made out by proof. The guilty design is the crime imputed to him. You must be satisfied, before you can say he is guilty, that such was his intent, such the object he wished to accomplish, and that such were the purposes for which his sermon was preached. For it is upon this sermon alone that this prosecution is founded. It is true that the words used by him are evidence of his intention, but they are not conclusive evidence, nor are they the only evidence from which the intent is to be gathered. His language is a circumstance from which you may infer his design. It is nothing more, and there are a variety of other circumstances equally entitled to weight and equally proper for the consideration of the jury. For when it is alleged on the part of the prosecution that a clergyman of a Christian society, while professing to be engaged in the high and solemn duties of religion, was, in truth, seeking to produce insubordination and insurrection among the slaves, and a detached part of his sermon is relied upon as the proof of his guilt, the party accused has a right to refer you, in proof of his innocence, to the general scope and object of his sermon, to the occasion on which it was preached, to the character of the congregation to whom it was addressed, to the opinions known to be held by the society to which he belongs, and above all, to the history of his own life, which, in this instance, would of itself be abundantly sufficient to repel such a charge, bottomed on such evidence. Upon all these circumstances, Mr. Gruber relies for his defense, and now I proceed more particularly to state them, as you will by and by hear them in proof. You have already been told that Mr. Gruber is a minister of the Methodist Episcopal Church, and it is not necessary to tell you that the religious society to which he belongs is nearly as numerous as any other society of Christians in this state, and the equal of any other in general order and decorum of their behavior, in their moral deportment, and in their habits of obedience to the laws. It was at a very early period of his life that Mr. Gruber became a member of this society, and took upon himself the duties of a minister of the gospel. In this vocation he has faithfully labored for more than 20 years, and he now fills a post of high rank and great confidence in his church, the reward of his fervent piety and unwearied zeal. We shall also prove to you by a most respectable witness, a minister of the same church, whose duty it has often been, according to the discipline of that society, to examine into the conduct and character of the accused, that during the whole course of his ministry, the reverend gentleman who is now on his trial has sustained a character of spotless integrity. It is well known that the gradual and peaceable abolition of slavery in these states is one of the objects which the Methodist Society has steadily in view. No slaveholder is allowed to be a minister of that church. Their preachers are accustomed, in their sermons, to speak of the injustice and oppression of slavery. The opinion of Mr. Gruber on this subject nobody could doubt, and if any slaveholder believed it dangerous to himself, his family, or the community to suffer his slaves to learn that all slavery is unjust and oppressive, and persuade himself that they would not of themselves be able to make the discovery, it was in his power to prevent them from attending the assemblies where such doctrines were likely to be preached. Mr. Gruber did not go to the slaves. They came to him. They could not have come if their masters had chosen to prevent them. In August 1818, a camp meeting of the Methodist Society was held in Washington County. At this meeting, it was the duty of Mr. Gruber to attend. He did attend, and from his official station in the society, the general superintendence and direction of the meeting was in his hands. On one of the days of the meeting, when the usual hour of evening preaching had arrived, the gentleman who had been dependent upon to fill that duty was prevented by indisposition. It was the duty of Mr. Gruber to provide for this unexpected emergency. He applied to several of his brethren and requested them to address the congregation. But it so happened that from different causes, not now material to be stated, he was unsuccessful in all his applications, and as nobody else could be found to supply the place of the sick brother, Mr. Gruber was compelled to do it himself. He undertook the task without preparation, without time for reflection, and upon the sudden and unexpected call of the moment. I state these facts so much in detail because this sermon is the sole foundation of the charge against him. The language used on that occasion is the only fact relied upon to prove him guilty of the wicked intention of raising an insurrection among the slaves and converting this peaceful and flourishing state into a horrible scene of rapine and murder. At the time this sermon was preached, there were present about 3,000 persons, of whom only about 400 were people of color, as they are now generally called. These were separated from the whites, according to the custom on such occasions, and placed together behind the stand from which the preacher addressed the congregation. Many of the most respectable gentlemen of Washington County and many of the principal slaveholders were there when the sermon in question was delivered. Yet it is at this meeting, thus constituted, that he is accused of conspiring against the peace of this state. It is in his public address to this assembly that he is said to have developed his profligate designs. If he did mean to stir up the slaves to insurrection, it must at least be admitted that he at the same time put the masters on their guard. The address of Mr. Gruber occupied rather more than 1 hour. His subject was national sin, and after enumerating and rebuking some offenses which he supposed people of this country to be but too prone to commit, he, in the conclusion of his discourse, spoke about 50 minutes and no more on slavery and the treatment of slaves. It is not alleged that he said anything in the preceding part of his sermon calculated in any degree to support the prosecution. During all that time he made no allusions to the condition of master or slave, and in the latter part of his discourse, when he did speak of them, and used the language on which this prosecution is founded, he addressed himself particularly to the masters. His appeal to his hearers on this subject was directed exclusively to the whites. The impression was intended to be made on them, and when the language used by him shall be detailed to you by the witnesses, you will find that he could not have designed, in that part of his discourse, to influence the conduct of the slaves, but was obviously and clearly seeking to reform the hearts of the masters. There may be, and probably will be, a difference among the witnesses as to the words used on this occasion by the reverend preacher. There will always be this difference where there are a great many hearers, for some will be negligent, while others are attentive. Some hear only detailed parts, others hear the whole. Some are roused to attention only when the angry passions are inflamed by an expected attack on some favorite opinion, and others listen to the whole discourse in the spirit of soberness and humility for the purpose of receiving and profiting by the instruction. And in this case, a difference is more especially to be looked for because the sermon produced a good deal of excitement and much warm conversation among different persons, even on the grounds, so that the remarks of irritated individuals became intimately blended in the mind with the language of the preacher and made it difficult, after the lapse of some months, for those who had listened carelessly to separate the one from the other. But we shall be able to fix, beyond doubt, the language actually used by him, for we shall produce a most respectable witness, who listened attentively to the whole discourse, who was near the preacher during the whole time, and who, on the day afterwards, while it was yet fresh in his mind, wrote down the heads of the discourse, and wrote out in full what may be termed the offensive part of it. His statement, too, will be corroborated by the testimony of a multitude of other witnesses, concurring with him in all the material parts. We shall, therefore, confidently rely on it as containing truly and accurately the words delivered, and from such a sermon as the witnesses will detail, preached by such a man, on such an occasion, and under such circumstances, without any other act of his life to aid the prosecution, I must be allowed to say that no intelligent mind, free from the influence of passion and prejudice, can infer the guilty design charged in this indictment. The learned district attorney has said that the language of Mr. Gruber was injudicious, that it was not calculated to do good, that it would necessarily irritate and offend the masters and make the slaves more dissatisfied with their unhappy condition. And it may, in the progress of this trial, be argued on the part of the prosecution that his principles on the subject of slavery were wrong, that the assertions of his opinions to a congregation mixed like the one to which he was speaking was impolitic and dangerous, and likely to produce insubordination and disturbance among the slaves. Now, if all this could be truly said of this memorable sermon, if the reverend preacher merited all these reproaches, yet, if you should believe that his motives were pure, if you think him innocent of any design to produce this mischief, he would still be entitled to a verdict of acquittal. For he is not now on trial for preaching doctrines calculated to disturb the peace and order of society. That is not the offense charged in this indictment. And you are all well aware that a man indicted for one offense cannot, on his trial, on that indictment, be convicted of another and a different offense. And if the learned attorney for the state shall be able to satisfy you that the opinions of Mr. Gruber on slavery and the treatment of slaves are unsound, that his arguments were injudicious and impolitic, that his language was inflammatory and calculated to produce evil, still he will not have advanced one step toward the accomplishment of his object until he can prove to you that these opinions were uttered, these arguments were used, and this language employed with the criminal intention and for the wicked purpose laid in this indictment. I might therefore safely rest the defense on this ground and yield to the attorney for the state all the advantage he can derive from placing my client in this respect in the wrong. For the circumstances I have before stated will, in my humble judgment, put the integrity of his motives beyond all question. And whatever may be thought or said of the intemperance of his zeal, nobody who listens to the proof will be able to doubt the sincerity of his heart. But the reverend gentleman merits a defense on very different principles. The counsel to whom he has confided his cause cannot content themselves with a cold and reluctant acquittal, and abandon Mr. Gruber without defense to all the obloquy and reproach which his enemies have industriously and most unjustly heaped upon him. We cannot consent to buy his safety by yielding to passion, prejudice, and avarice the control of future discussions on this great and important question. He must not surrender up the civil and religious rights secured to him in common with others by the Constitution of this most favored nation. Mr. Gruber feels that it is due to his own character, to the station he fills, to the respectable society of Christians in which he is a minister of the gospel, not only to defend himself from this prosecution, but also to avow and to vindicate here the principles he maintained in his sermon. There is no law that forbids us to speak of slavery as we think of it. Any man has a right to publish his opinions on that subject whenever he pleases. It is a subject of national concern and may at all times be freely discussed. Mr. Gruber did quote the language of our great act of national independence and insisted on the principles contained in that venerated instrument. He did rebuke those masters who, in the exercise of power, are deaf to the calls of humanity, and he warned them of the evils they might bring upon themselves. He did speak with abhorrence of those reptiles who live by trading in human flesh, and enrich themselves by tearing the husband from the wife, the infant from the bosom of the mother. And this, I am instructed, was the head and front of his offending. Shall I content myself with saying he had a right to say this, that there is no law to punish him? So far is he from being the object of punishment in any form of proceeding that we are prepared to maintain the same principles and to use, if necessary, the same language here in the temple of justice and in the presence of those who are ministers of the law. A hard necessity indeed compels us to endure the evil of slavery for a time. It was imposed upon us by another nation while we were yet in a state of colonial vassalage. It cannot be easily or suddenly removed. Yet while it continues, it is a blot on our national character, and every real lover of freedom confidently hopes that it will be effectually, though it must be gradually, wiped away, and earnestly looks for the means by which this necessary object may be best obtained. And until it shall be accomplished, until the time shall come when we can point without a blush to the language held in the Declaration of Independence, every friend of humanity will seek to lighten the galling chain of slavery and better, to the utmost of his power, the wretched condition of the slave. Such was Mr. Gruber's object in that part of his sermon of which I am now speaking. Those who have complained of him and reproached him will not find it easy to answer him, unless complaints, reproaches, and persecution shall be considered an answer. I have now done with stating the testimony we are about to offer and marking out the grounds on which our defense will be taken. But there is one other topic on which it may be proper to remark before I conclude the opening of the case. The sermon in question was preached in Washington County, and this indictment was found by the grand jury for that county. The cause has been removed to Frederick upon the application of the accused. This circumstance sometimes creates suspicions unfavorable to the character and standing of the party who applies for the removal. If he has long been an inhabitant of the county in which he is indicted, there may be some ground for these suspicions. But even then, they cannot be allowed in the least degree to affect the verdict. In this case, however, Mr. Gruber was as much a stranger in Washington as he is in Frederick. He never resided in that county, and therefore has not shunned the decision of the men who knew him. He has removed his cause from one body of strangers, to be decided, indeed, by another body of men who are equally unacquainted with him. His motive for doing so I will briefly explain to you. Mr. Gruber, as I have already told you, was a stranger in Washington, and consequently incapable of deciding how far a fair and impartial trial could be there expected. He of course submitted himself on this point to the decision of his counsel, and formed his own opinions upon the advice and information derived from them. I am by no means prepared to say that if he had gone to trial in Washington, his cause would not have been patiently heard and impartially decided by a jury of that county. But it was well known that great pains had been taken to inflame the public mind against him. The grand jury of that county had found this indictment to be true, and on that jury were men of high standing and great influence in the county. Many of the members of that body I know personally and respect highly. They are incapable, I am sure, of willfully doing wrong. Yet they are like the rest of us but men, frail men, and liable to be influenced by the impulse of passion or prejudice without being aware of it. Knowing, as I did, all the circumstances of this case, and being firmly convinced that there was no just cause for instituting this prosecution, the finding of this indictment by a body of men so respectable as the grand jury was of itself sufficient evidence to my mind that the liberty and reputation of Mr. Gruber ought not to be hazarded on a trial there. I so advised him in the strongest terms, and if blame is to rest upon anyone for the removal of the cause, I acknowledge that to me, and not to Mr. Gruber, it ought to be imputed. Yet I cannot think that the exercise of a constitutional right can be a matter of censure against the client or his counsel, nor can it be a reproach to anyone that he is willing to abide the verdict of a jury of Frederick County. End of section 10. Section 11 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Jddykst, Farragut, Iowa. American State Trials, Volume 1, by John D. Lawson. Trial of the Reverend Jacob Gruber for inciting slaves to insurrection and rebellion, Frederick County, Maryland, 1819. Part 3. Reverend Mr. Sneathen. I heard Mr. Gruber's sermon. He first prayed for the safety, conversion, and happiness of the whole assembly. Upon the point of slavery, he gave the good and bad masters their meat in due season, kept up the distinction between good and bad masters. He admitted that many masters use their slaves well, but then, he said, what security have they that their children will use them well? It is possible that their children may be tyrants. The slaves may rise and kill their children. When he spoke of killing, it exclusively related to the next generation. He endeavored to convince the good master that slaves were dangerous property to leave to children, that tyranny in the children might produce rebellion in the slaves, and mutual destruction might ensue. Mr. Gruber preached that day by accident. He did not appoint the meeting, and before he began, he labored very much with one of his brethren in the ministry to preach in his place. He possesses a good general character, is very zealous and devout in the ministry. He is next in office to the bishop, and of an unimpeachable moral character. In his address to the blacks, he enforced on them repentance, exhorted them to religion, to obedience, and patience in the service of their masters. He told them without religion they were slaves to their own lusts, slaves to their masters, and if they died in their sins, they would be damned forever. When he adverted to the Declaration of Independence, he spoke of it as a national thing, and not to slaveholders particularly, and said it had been justly thrown upon this nation as a reproach to hold the Declaration of Independence in one hand and the bloody whip in the other. The Court. How did you like the sermon? From prudent considerations, I would not have preached in the same way, because, from his very frank manner, persons might misrepresent him. My taste also differed from his. I should have advised a different manner and composition, but nothing escaped him that could induce me to believe, for a moment, that he had a criminal intent. When Mr. Gruber spoke of the danger of mutual destruction between the children and slaves in the next generation, he offered up a prayer for them all. The Lord have mercy on them. Reverend Jeremiah Mason was at the camp meeting and heard the sermon. Righteousness was the first head of the discourse. Sin as a reproach to any people was the next head. He dwelt considerably on the sin of infidelity, and with great labor on the sin of oppression, under which he considered, he said, the whole of involuntary Negro slavery. He contended that involuntary Negro slavery was a violation of the moral and natural law, and a great abuse of Christianity, that it was in violation of the sentiments expressed by the American sages in the Declaration of Independence, that it was reproachful to this nation to hold that sacred instrument in one hand and a rod stained with blood in the other. He spoke of the cruelty of advertising and selling human beings mixed with cattle. He said it was usual to find in the advertisements on this subject the owners stating to the public that they, the Negroes, were sold without fault. In that part of his address, directed to the Negroes, he was very severe on them and told them unless they repented and obtained conversion, they would be damned forever. He recommended to them obedience and entire and patient resignation to their condition. I, being a justice of the peace, and hearing an accusation was to be stated against Mr. Gruber, I made immediate notes, after the delivery of the sermon, of its principal heads. When he spoke of the danger of killing, he referred to the posterity of the present generation of masters. He said, in the mutual strife that might ensue between the Negroes and the children of the present masters, there might be mutual death, and all be sent to destruction together. Then he made a pause and said, "The Lord have mercy on them." The Court. Have you ever said that you did not approve of the matter and manner of the sermon? I have said, from the temper of the congregation, I was fearful the sermon might give offense to some persons present, but I never intimated or thought there was anything criminal in it. Reverend Jonathan Forrest heard the sermon. He spoke considerably on the beauty of righteousness and the horror of sin in a national point of view. In his prayer, previous to preaching, he offered a fervent petition at a throne of grace for the happiness, conversion, peace, and quiet of the whole congregation. He discussed Negro slavery as a national sin, as being contrary to the natural and moral law, contrary to the Christian religion, and expressly against that command of God which directs us to do to all men as we would they should do to us. He said slaves were dangerous property for fathers to leave to their children. Children might tyrannize over them, mutual destruction might ensue, and all go to destruction together. When he spoke of the danger of killing, it was in reference to the next generation of men. In that part of the address, directed to the Negroes, he exhorted them with great zeal to get religion, to seek pardon of God, to obey their masters and mistresses, to let their light shine before men, and perhaps it might be a means of getting their freedom through some kind turn of providence. He told the slaves if they lived and died in their sins, they would be damned forever. I was near Mr. Gruber the whole time he was preaching, and confident he did not in any part of his sermon say, "The Negroes present were free-born." H.G. O'Neill heard the sermon. In the general scope of his sermon, he preached repentance toward God and faith in a Savior. I do not remember his saying anything about poison. When he spoke of killing, he referred to the next generation of men. He exhorted them to be obedient and submissive to their masters, and begged those who had pious masters to join them in devotion. There was about 5,000 white persons present, and perhaps from 200 to 300 blacks. Mr. Long heard the sermon. Remember, Mr. Gruber said Pennsylvanians thought it strange that human beings were sold in Maryland at auction with cattle and beasts. He said Negroes were dangerous property for fathers to leave to their children, that children might prove to be tyrants, Negroes might rebel, mutual destruction take place, and all go to destruction together. The Court. Did he tell the Negroes they were a degraded people? No, he advised them to be obedient. He preached a mighty good sermon. It was the truth from the Scriptures. Reverend Lawrence Evehart. He said it would be awful to account for holding slaves in the day of judgment. There was then a general response of Amen, Amen, after his address. Reverend Samuel L. Davis heard the sermon. He was particularly severe on those engaged in the slave trade. He made use of a quotation to this effect: "Is there not some chosen curse, some secret thunder in the stores of heaven, red with uncommon wrath, to blast the wretch that makes his fortune from the blood of souls?" The address on this sin was principally directed to cruel masters and traffickers in human flesh. After preaching to the whites, he addressed the blacks, warned them faithfully of their own sins, preached to them the terrors of the law, exhorted them to obedience to their masters, resignation to their state. I considered the address to the slaves a complete antidote for anything that had gone before. The court: "What do you mean by an antidote? Was there poison to be expelled?" I suppose many masters present would be offended at the plain manner in which the preacher delivered the greatest truths, and I thought their wrath would be turned away when the accused warned the slaves so faithfully of their own sins, and exhorted them to obedience to their masters. That is what I mean by antidote. Did not think there was anything criminal in the sermon. Mr. Gruber said many persons would contribute their money to support Bible societies, to carry the Scriptures to heathens in foreign countries who neglected to teach religion to the heathens in their own kitchens. The court: "Remember, you must state the truth." "Sirs, I am on my oath. That is warning enough for me." Mr. Yo heard the sermon. He endeavored to prove that slaves were dangerous property to leave to children. He said slavery was horrid to him as a man and a Christian. It was a violation of the moral law, the law of Christianity, and contrary to the sentiments of the American sages as expressed in the Declaration of Independence. He said it was monstrous to see a people holding a scroll of liberty in one hand and a bloody whip in the other. Jacob Bolus heard the sermon. He preached with great animation and zeal, and endeavored to convince the whole congregation of the great necessity of repentance, of piety and love of God. What he said about the danger of killing or poisoning referred to the next generation. John Bolus heard the sermon. He was very severe upon bad masters and all persons concerned in that sort of commerce called the slave trade. He said there was an awful responsibility resting on them for the day of judgment. He enforced Christian duties on the masters and slaves. He applauded the good master and the good slave. He said, good masters make good slaves, and good slaves make good masters. Mr. Brazier, Mr. Hunt, Mr. Beeler, Mr. Blake, Mr. Middlecoff, Mr. White, and Mr. Reynolds were also examined. All of them gave similar evidence to that of the previous witnesses, and heard Mr. Gruber deliver the sermon in question. Reverend Frederick Steyer. I know Mr. Gruber preached by mere accident. He called on me to preach with very pressing and anxious solicitation several times. I refused. He preached on that occasion with great reluctance. Reverend George Rosel. Have known Mr. Gruber for 9 years. He holds an office second in rank to the bishop. He possesses a character unblemished. He is pious, zealous, and very laborious in the ministry. Have been one of a committee in the annual conference for many years for the annual examination of the characters of our preachers, and Mr. Gruber's has been before me every year in that way for several years past. Nothing that could lead to immorality has ever been imputed to him in his ministerial character. Reverend Abner Neal. Have been acquainted with Mr. Gruber for many years, but was more particularly acquainted with him in the year 1814, when he was stationed by the church in Baltimore, where I reside, and while the British were at North Point, threatening Baltimore. Mr. Gruber had under his charge nearly 2,000 Negroes, and kept them under the very best discipline. Have heard him frequently preach to them, and he warned them faithfully of their duty to their masters and patient submission to their condition. End of section 11. Section 12 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Jddykst, Farragut, Iowa. American State Trials, Volume 1, by John D. Lawson. Trial of the Reverend Jacob Gruber for inciting slaves to insurrection and rebellion. Frederick County, Maryland, 1819. Part 4. Mr. Anderson addressed the jury for a few minutes. He said he felt the peace and good order of the state as much at heart as any man, and would be as willing as any man to see a person guilty of crimes brought to condign punishment. But he said he never could consent, contrary to his conscience and the best light of his own judgment, to use any effort to convict any man of any offense charged against him, when he thought, from the evidence, there was no crime committed. He said he should address the jury no further on the subject, except to state to them that he did not wish his own convictions or opinions to have any weight with them. He should leave them free to pass their own unbiased judgment on the case before them, which he hoped they would do with an eye to the public good. The Attorney General closed the argument on the part of the state. Mr. Martin, I appear before you as one of the counsel for the accused, and if the subject upon which we deliberate involved no other interest than that connected with the right of property, I should be well pleased, after the very just and candid prosecution, to spare the time of the court, and submit the cause of my client, without comment or remark, to the deliberation and decision of the jury. But in a trial which wears an aspect different from, and more alarming than any other known in the history of the court, when a citizen, eminent for piety and Christianity, is arraigned for doing nothing but what benevolence, piety, and Christianity required, when the feelings and principles of a vastly numerous church have been, through the accusation of a member, sensibly wounded, and when the right of sentiment and of speech is doubted and attacked, silence on our part would be criminal. As for myself, though young and unexperienced, shrinking from the gaze of public scrutiny, and trembling under a consciousness of incapacity, I cannot, under those disadvantages, forbear at least the exertion of defending a client so injured, a cause so just, and principles so important to every American as to be the very soul of his national independence. It is, however, a consideration of pleasure to know that much time will be saved and much trouble in this investigation unexpectedly relieved, and I am happy to say relieved by the firm and highly honorable part the state's advocate has acted. Highly honorable. For however meritorious it may be, actively to pursue and strenuously to prosecute the man who would meditate to unhinge the government and inundate with blood the land, it is surely equally meritorious fearlessly to avow him innocent, whose innocence has been proved. The district attorney stands upon the high ground of protecting, not abusing, the law, to shield from violation, not pervert it to oppression, ready to exert his power against the wretch who wilfully profanes it, and ready to shelter under the mantle of authority the prisoner who is wrongfully accused, whether such accusation arises from the zeal of the misguided, the prejudice of the misinformed, or the uncontradicted information a grand jury gleans from the examination of ex parte witnesses. Gentlemen, you are impaneled to determine a case of no ordinary kind. You are called upon to discharge a trust, the highest that can be discharged by enlightened men, endowed with the powers of reason, and empowered with right of decision. Patriots who have suffered for the liberties of our country look to your verdict with an agonizing care. The Methodist Church bleeds at every pore for the fate of a minister transferred from the pulpit to the prison box. Posterity to succeed may have reason either to bless or curse the result of this day. The busy crowd that throngs the court, though disposed to immolate at the shrine of opinion the man who differs and condemn him because they condemn his sentiments, will learn to affirm your acquittal. When that film which now obscures the vision alike of the humane and the wise shall have fallen, when those fumes which float from the heated prejudices of the time shall have passed away, they will learn that the blow leveled at the traverser must fall upon themselves, that the freeman, who condemns a man for uttering the dictates of his heart, commits suicide upon his liberties, and by sacrificing this reverend gentleman, they sacrifice those noble attributes of their Constitution, the right of free sentiment and the right of free discussion. Who is the accused? What has he spoken? How were his sentiments dangerous? And with what intention did he speak those sentiments? These, gentlemen, are matters for your consideration, and while in pursuing them I hope duly to regard the duty to my client, I shall not forget that the court, the jury, and the counsel are already much fatigued with the investigation of this subject. Who is the accused? He is a gentleman of the clerical ministry, and after laboring with zeal and fidelity many years in the cause of religion, has been appointed presiding elder of the district. Nursed in the cradle of the church and confirmed in its tenets, he has grown with its growth and strengthened with its strength. Aloof from those cares which incite the ambition, deprave the passions, and multiply the misfortunes of the temporal world, his life has been devoted to the service of his God, and his time to the instruction of his fellows. Unconfined to any particular situation, he has traveled from circuit to circuit, shedding in his course the light of the gospel, and disseminating the principles of morals, philanthropy, and religion. The duties of his office carried him to the place where the supposed crime was committed, for which supposed crime he has been called from the altar of grace to answer charges preferred by his country. What has he spoken? At a camp meeting held last August in Washington County, the traverser, according to the will of the ministry, and in opposition to his own inclination, preached a sermon from Proverbs. Righteousness exalted a nation, but sin is a reproach to any people. From that text his deductions were many, and after descanting upon the different divisions, addressed the congregation upon the subject of slavery. He spoke of it as a national sin, and condemned the practice as being contrary to natural law, national policy, and the principles of humanity and religion. Thus, gentlemen, a religious discourse embracing the principle of slavery has given rise to this criminal prosecution. The indictment accuses the traverser of an attempt to excite rebellion, and is it necessary to ask whether a minister can be thus criminated for advancing to his own congregation sentiments upon a subject so often the topic of general remark, and so often the theme of public reprobation? The right of slavery is a question of abstract morals, of natural law and human policy, a subject upon which the judgment ponders and the intellect suspends. Discussed in the councils of the nation, it has called forth the efforts of the benevolent and learned, and the matter of that memorable sermon which now arraigns this reverend gentleman has been long since proclaimed by elevated statesmen. We will convince you that sentiments upon slavery, stronger in matter and bolder in expression than any portion of the traverser's discourse, have rolled from the lips and flowed from the pen of the most distinguished Americans. Men high in office, eminent in science, fair in character, and exalted in the confidence of their fellow citizens, have arrayed themselves as champions of emancipation, and condemned a system they conceived unwise and unnatural, dangerous to the morals and strength of the people, poisoning the springs of social felicity, and repugnant to the principles of free constitution. What says Mr. Jefferson? In his notes upon Virginia, he thus writes, "There must doubtless be an unhappy influence on the manners of our people, produced by the existence of slavery among us. The whole commerce between master and slave is a perpetual exercise of the most boisterous passions, the most unremitting despotism on the one part, and degraded submission on the other. Again, with what execration should the statesman be loaded who, permitting one half of the citizens thus to trample on the rights of the other, transforms those into despots and these into enemies, destroys the morals of the one part and the amor patriae of the other. For if a slave can have a country in this world, it must be any other in preference to that in which he is born to live and labor for another, in which he must lock up the faculties of his nature, contribute as far as depends on his individual exertions to the evanishment of the human race, or entail his own miserable condition on the endless generations proceeding from him. Continuing, he asks, can the liberties of a nation be thought secure when we have removed their only firm basis, a conviction in the minds of the people that their liberties are a gift of God, that they are not to be violated but with his wrath? I tremble for the honor of my country when I reflect that God is just, that his justice cannot sleep forever, that considering number, nature, and means only a revolution in the wheel of fortune, an exchange of situation is among possible events, that it may become probable by supernatural influence. The Almighty has no attribute which can take side with us in such a contest. Such, gentlemen, are the remarks of Mr. Jefferson, and I read them for the purpose of proving that the subject has been, before this sermon, examined with great animation, and without any suspicion of crime. That philosopher and statesman called the attention of his state to an evil, corroding, as he thought, every day, the morals, inflaming the passions, weakening the energies, and endangering, perhaps, the liberties of a free and manly people. These sentiments were free and unconcealed, circulated in Virginia, so numerous in slaves, and open to general observation, private discussion, or public scrutiny. Yet is Mr. Jefferson infamous? Has he been branded with the epithet of hypocrite and felon? Has he been subjected to the ceremony of a criminal prosecution and threatened with the chains and calamities of disgraceful imprisonment? No. Since the publication of his notes, he has been elected to the presidential chair, directed for 8 years the affairs of the nation, and now reposes, unaccused and unsuspected of anything like treason, in the lap of literature and science. But, gentlemen, Mr. Jefferson is not the only citizen who has freely spoken upon this subject, and who ranks high in the councils of his country. The remarks of Mr. Talmadge upon the floor of Congress at its last session on the question of the Missouri bill were much in substance as those preached by the traverser. Discussing the policy of admitting slavery into Missouri, he says, "You boast of the freedom of your Constitution and your laws. You have proclaimed in your Declaration of Rights that all men are created equal, that they are endowed with certain unalienable rights, among these life, liberty, and the pursuit of happiness. And yet you have slaves in your country." In another part he continues, "This is a subject," alluding to slavery, "upon which I have great feeling for the honor of my country. In a former debate upon the Illinois territory, I mentioned that our enemies had drawn a picture of our country as holding in one hand our Declaration of Rights, and with the other brandishing a whip over our affrighted slaves. Thus you learn that arguments upon the evils of slavery, not less powerful than those of the traverser, have been rung by a President of the United States and a representative in Congress in the ears of the whole nation. They have been exalted, not disgraced. They have received the benedictions, not the curses, of their country. And I ask, by what principles of fairness can you accord honor to the one and infamy to the other? They are argued from the right of free discussion. The same right is delegated to the traverser. The golden rule of dealing alike to all is just, and the same franchise of speech and of conscience that supported Mr. Jefferson, Mr. Talmadge, and others, when bearing their weapons in the cause of freedom, justifies Mr. Gruber. As an American citizen, he was authorized to discuss the policy of a system interwoven with the well-being of his government. As a man, moved by the feelings of benevolence and glowing with enthusiasm of philanthropy, he was privileged in condemning a practice he thought inconsistent with both. As a minister of the gospel, directed by the laws of his church and instigated by conscience and belief, he was bound to tender his advice. Had he not, the sin of leaving undone those things he ought to do would have recoiled upon him. He would have broken a much more sacred law than he is said to have violated. He would have sinned against a much higher tribunal, however exalted by learning and virtue, than I have the honor to address. He would have sinned against that God before whom you and he and we must appear. Gentlemen, before a man can be subject to the sanction of law, law must be proved to exist. He cannot violate that which is not in being. Has any law been adduced to you today? Have the prosecution exhibited any statute of the state as broken and abused? None has, none can be offered. It has been remarked that the laws of Maryland allow slavery. Granted, but it does not command it. The distinction is evident. Did the law positively command, then any argument in opposition might be criminal. Where it merely permits, it becomes a subject of private opinion, policy, and conscience, and any citizen has the privilege, by all the abilities of his mind, to remove that opinion or alter that belief. Besides, the traverser addressed his own congregation, confined his remarks to the pale of his church, and surely, if any can be authorized, it is the pastor who teaches the doctrines of his church to those who compose it. The Quakers are principled against bearing arms, and it is unnecessary for me to tell this well-informed jury that the right of advocating those principles in their houses of worship never was denied them. There the Quaker opposes what, in fact, is declared by law, and he draws his right from that freedom of opinion and prerogative of speech every man living under the sun of America has exercised since the memorable period of 76. Gentlemen, having endeavored to establish that the traverser thus far has neither violated law nor reason, let us dissect the sermon, and before we proceed to the intention, inquire how his sentiments were dangerous, and whether, upon fair construction, they can be thought calculated to excite either rebellion, disobedience, or insurrection. You learn from the testimony that the sermon consisted of two distinct parts, one addressed to the white congregation and the other to the slaves. And so different from an attempt to create insubordination, we will prove that the clear and ostensive purpose was, first, by discussing the principles of slavery, which we have already considered, to effect universal emancipation. Secondly, by exposing the cruelty of selling and torturing slaves to ameliorate and soften the discipline of masters. And thirdly, by instilling the policy and religion of obeying those entitled to govern to fasten upon the slaves good conduct and obedience. The internal slave trade of this country formed a considerable part of his discourse, and he displayed in the severest terms, as the witnesses deposed, the sin and wickedness of such atrocious commerce. As to the particular expressions, the testimony differs, but in substance is the same. And where is the crime? Is there any man on that jury or in this court who would not respond to such sentiments, who would not raise his voice and power in suppressing a traffic opposite to the laws of God and repugnant to the rights of man? Gentlemen of the jury, interest, policy, necessity may compel us to retain an evil which seems to be entailed. It is not for me to say, until the efforts of philanthropy shall establish for these people a suitable receptacle, how far emancipation would be prudent. But nothing can justify so flagrant and cruel an abuse of it. No motive can authorize a traitor that separates the husband from the wife, the parent from the child, and the relation from the friend, that tears asunder all the ties of social connection and breaks apart all the ligaments of natural union. Steeping yet deeper in misery this unfortunate population, and forcing from their embrace the last relic of human happiness, it would draw iron tears down Pluto's cheek. The African slave trade has engaged the attention and attracted the notice of almost every part of Christendom. Your own government have taken laudable and effective measures to suppress it. So proud is England of her exertions that she contends for the right of example, and Napoleon of France, amidst his mad career of war and carnage, when every call of mercy seemed drowned in the din of battle, and every fiber of humanity eradicated by the power of ambition, forbade the slave trade. And is that more to be deprecated than this? The same cruelties are practiced, the same ties are broken, the same agents employed. Traffickers in blood and panders of avarice are engaged in both, and the vultures who hover over the coast of Africa, and the vultures that crowd from the sugar farms of America, are equally destructive. Alike, they feed upon the vitals and fatten upon the miseries of an unfortunate and degraded people. Gentlemen, I forbear to press or continue the subject. We have proved, I hope, that the traverser has not in this violated the law. In this country, enlightened as we are by rays of Christianity and illumined with the light of liberty, no law can be produced to credit a practice unwise, inhuman, and unjust. I will next call your attention to a passage in which he exhibits the inconsistency of our theory and practice. Is it not a reproach to a man to hold in one hand the Declaration of Independence, and with the other brandish a whip over the bleeding slave? This description, though hideous, is true. The same was drawn by Mr. Talmage, and with the same foreigners have reproached us. The picture of American independence, though glowing with the tints of liberty and virtue, cannot but be darkened and discolored by such cruelty and oppression. The traverser did not apply the remark generally, but made it conditional. He did not say that such practices existed, yet if they did exist, they were inconsistent. He threw his sentiments to the congregation, qui capit il facit, and the man who so far misuses power which chance has given well merits the lash of invective. Does any attempt appear to cause rebellion or insurrection? The object was to do no more than expose those cruelties which, when practiced, degrade the man and stigmatize the nation. This concluded his address to the whites, and as the alleged attempt was to infect the slaves with rebellious principles, observations to them become more interesting because more important. Several witnesses on the part of the prosecution, and all for the accused, testified that the whole tenor of that discourse went to impress upon their minds the value of religion. Of all the people in the world, you ought to have religion, he says, for when converted you will disregard the hardships of your life. It is said he spoke of poison, and thereby impliedly recommended the use of it to the slave. In that sentence, where he remarks that although you, addressing the whites, use them well, there is no security but what your children will tyrannize over them. The slaves abused rise up and kill or poison your children, and all be hung and go to destruction together. Admitting this, can any man, without perverting common sense and common language, see and attempt to induce the use of poison? Does he not stamp such conduct with the dreadful doom of death and destruction? With equal propriety, you might say, to encourage was to describe futurity, and to instigate murder it would only be necessary to relate the appalling ceremony of criminal prosecutions. In another passage, Some of you, addressing the slaves, have good masters. You ought to attend to religion and discharge your duty to your masters, that it may make your time better here and hereafter. Some of you have cruel masters. You are slaves to them, slaves to sin, and if you die without religion, you will be slaves to the devil. What then does he declare that religion to consist in? Rebellion? No, for that he has affirmed is repugnant to religion. Disobedience? Mr. Sneathen tells you upon oath that he fully discharged the doctrines of his church, and those doctrines command the slave to obedience. Insurrection? Certainly not, for then he threatens them with the dreadful reversion of future woe. A witness thinks that he said, "If you die slaves to your masters, you will be damned." The witness from ineligible situation must be mistaken. It is too absurd to be believed. Could the traverser say that a man should be punished for an evil he could not avert, and suffer for that which was his misfortune, not his fault? It is contradicted by every witness on the part of the accused, who, we may suppose, from situation and attention, better understood and more correctly remembered the expressions of the sermon. We have now, gentlemen, examined each passage of the sermon, and contend that it has been viewed through a false and mistaken medium, that the observations of the traverser were not in themselves calculated to inspire rebellion or disobedience, and therefore hope that the intelligent jury to whom he appeals will wipe that charge from the indictment. But if I should be too sanguine in this hope, should we fail to convince you that his sentiments were useful, not dangerous, much more is necessary to be established. The intention is the life and essence of every crime, and before you can convict the accused upon the charge of high misdemeanor, an intention to commit the different offenses in the indictment must be proved wicked, designed, and felonious. Here let us reflect upon the testimony. In all cases of high capital nature, every man is presumed innocent until proved guilty. Such is the benignity of our laws, such the language of Justice Buller, and such is the voice of all English authorities. The case at bar is an accusation of high criminal character, and it is much stronger to prove by conduct than presume from inference. Where, then, is the evidence to establish such guilt? Can it be found in the testimony of any witness? Can a single fact or circumstance be adduced which even savors of such intention? All the gentlemen of the Methodist clergy state that the traverser strongly objected to preaching on the day named in the indictment, that he expressed every wish to decline, and used every means to avoid the service, and did not consent until his duty as presiding elder compelled him to perform what others refused. The congregation of whites he addressed was 4 times more numerous than the slaves. The witness from Baltimore, Mr. Neal, informs you what his conduct was in the year 1814. Stationed by his church in Baltimore, he presided over his congregation during the memorable battle of North Point, and at that anxious moment, when every eye watched the destiny and every heart beat for the danger of our gallant troops, the traverser held in harmless subjection a body of 1,500 men. And does this look like an attempt to bring ruin upon the country, to whet the sword of civil war, or light the fires of desperate rebellion? Can you suppose premeditation to preach on that day, when he so often refused the invitation of the ministry? Would he have, by declaiming before the masters, strong in number and power, provoked the very sword of justice? And would he have failed at a former period in the commotion of Baltimore, when all its nerves were braced against foreign attack, to strike a dreadful and perhaps a fatal blow? No. It is inconsistent with common sense to think it, and however the policy of his doctrines may be questioned, none, unless they have drank to the dregs the cup of prejudice or folly, can doubt the purity of his heart. His object was to effect universal emancipation. His intention to teach the law of religion and to pour into the afflictions of an ill-fated people the comforts and consolations of the gospel. Gentlemen of the jury, this trial is new in America. It is novel in the jurisprudence of our country. You must, for example, unfold the blood-stained page of the 15th century. Go back to that season of religious fury. Recur to that black and disgraceful period of intemperate opinion, when bigoted belief was supported by the gibbet and the stake, and the very temples of justice smoked with bloody execution. I pretend not to say that this prosecution has originated from such influence. The fair characters of the gentlemen who composed the grand jury, though personally unknown to me, defy this suspicion. But it matters not from whom or from what. You view the case with all its lights and solemnly decide upon the principles. Shall this nation, so long gloried in as the home of the oppressed, the retreat of the persecuted, the asylum of those who, in the dreadful massacre of individual privilege, have flown from their altars and their gods, be at this day reduced to the disgraceful level of infuriated despotism? I trust not. The streams of jurisprudence drawn from the foundations of liberty and virtue will continue to play through the land, free and unpolluted. But it is unnecessary to invoke such sentiments in the bosom of this impartial tribunal. The firmness, the intelligence, and integrity of juries must ever prove a safeguard and barrier against the encroachments of prejudice. The traverser has been introduced to you with the imposing name of a grand jury. A host of testimony has rallied round and ventured to support it. Yet, gentlemen, you have seen, not the ingenious examination of the learned district attorney, not all the exertions of professional ability, have been enabled to extract one fact or elicit one circumstance to uphold an indictment baseless and unfounded. Sir, I have done. Not, however, without offering my thanks to the Honorable Court for the indulgent attention they have pleased to extend, on my part undeserved, and accept in my gratitude unrequited. I have trespassed perhaps too long upon your time. If so, my apology must be sought in the deep interest and importance of the case. In defending the honor and liberty of a gentleman whose life through a series of 20 years has passed unspotted and unreproached, correct, I am justified in saying, not merely beyond censure, but irreproachable until this day, beyond suspicion, dedicated to the holiest offices of religion, and employed in relieving those miseries and softening those sorrows which should have awakened the sympathies of a colder heart. Confiding in your virtue, the traverser awaits the verdict with calmness and security. If acquitted, glorying in the principles of his country, he will return to his duties with zeal and faithfulness. If convicted, supported by the consciousness of innocence, he will bear whatever punishment the law may inflict with the resignation of a Christian and the firmness of a man. The verdict. There was no charge given to the jury by the court. The jury immediately retired and returned in a few minutes with a verdict of not guilty. End of section 12.
Section 13 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information to volunteer, please visit LibriVox.org. American State Trials, Volume 1, by John D. Lawson. The Trial of George Bowen for the murder of Jonathan Jewett, Massachusetts, 1816. The narrative. A Negro named Jonathan Jewett had been convicted and sentenced to be hanged for the murder of his father. While awaiting execution in a Massachusetts jail, Bowen, a fellow prisoner, was constantly advising him to cheat the gallows by killing himself. Once he was overheard saying to the Negro that he was a fool to let the sheriff do it, that he could die but one death. Other witnesses heard him urging the same thing. saying that he would rather hang himself twice than be hanged once. Jewett did not seem to take to the idea at first, but on the morning set for his legal hanging he was found dead in his cell, hanging by a rope to the gratings of the window. When he heard the news Bowen showed his pleasure, exclaiming that he was as glad as if he had $100, that the sheriff and his assistant had lost their fees, and he had saved the county a slick $200. The state, however, charged him with murdering Jewett, and at the trial the Chief Justice told the jury that if they found that he had advised Jewett to commit suicide, and Jewett had followed his advice, they should convict him, as he would be guilty of murder. The jury did not do so, for they doubted whether the advice given by Bowen was the procuring cause of Jewett's suicide. The Trial. In the Supreme Judicial Court of Massachusetts, Northampton, September, 1816. Honorable Isaac Parker, Chief Justice. Honorable Charles Jackson. Honorable Samuel Putnam, Associates. September 21st. The prisoner was arraigned for the murder of Jonathan Jewett by counselling and aiding him to hang himself in prison to avoid the ignominy of a public execution, to which he had been sentenced for the murder of his father. The indictment contained 2 counts. The first alleged that one Jonathan Jewett, in the night time on the 8th of November, 1815, at Northampton, murdered himself by hanging himself, and that the prisoner Bowen, before the said self-murder on, etc., feloniously, etc., did counsel, hire, persuade, and procure the said Jewett the said felony and murder of himself, to do and commit, etc. The second count alleged that the prisoner murdered the said Jewett by hanging himself against the form of the statute, etc. Morton, Attorney General for Commonwealth, Mr. Bates, and Mr. Lyman for the prisoner. The evidence for the Commonwealth. Cephas Clapp. Am keeper of the jail in Northampton, where Jewett was confined. Frequently heard Bowen and Jewett conversing. Bowen would say, "If you are sentenced, you will be hung, and you will then go there," alluding to the place of execution. "If you let them hang you, you are a damned fool. I'd rather hang myself twice than be hung once." They used to talk mysteriously together. Bowen would say, "Will you do it?" Jewett would reply, "It can't be done." Bowen would answer, "It can. I would make a string of my bed ticking and hang myself to these grates in 5 minutes." Bowen was not in the same room with Jewett, but in the next, and they talked through the walls. Heard the advice frequently repeated. Bowen told him not to mind what the clergyman said, for "it was all damned nonsense," for there was no hell, he could not die but once, and then it was all over. Cross-examined. Talked often with Jewett about his hanging himself, told him it was as bad to take away his own life as that of another man's, and that he would then have 2 murders to answer for. Jewett thought it was worse. This was after Bowen's advice. Jewett would ridicule the visiting ministers behind their backs. He had no more religion than a brute. When the warrant for his death was read to him, he was rather serious, but I afterwards heard him sing a very indecent song. Bowen never saw Jewett to my knowledge. Whitehall and Upham were in Bowen's room when Jewett hung himself. All of the prisoners talked with him, and were all noisy. The windows of the lower story were 13 feet 4 inches apart. The partition walls were about 3 feet in thickness. Jewett was dull in conversation, in learning, and in natural capacity. Never heard Jewett say he intended to destroy himself, but he told me that one man advised him to push his head against the wall, running from one side of the cell to the other. He was found dead on November 9th, hanging by a rope to the gratings of the windows, his knees resting on the floor, his head sunk about half a foot below the bottom of the windows, the rope tied in a fast knot. The rope could not have come from his bedstead, which was made entirely of boards. Don't know whence it came. It might have been given him from Bowen's apartment. He used to put his hand out of the grate and swing a string with a weight attached to it. Jewett had a stick to catch the string, did not see such a stick after his death, and never saw a rope in Bowen's room. Suspected the rope might have come from the room over Jewett's. Jewett might have concealed a cord in his bed. He always manifested such hardness of heart. He spoke lightly about his coffin and his cap, in which it was intended he should be executed. He hung himself in the night, heard no noise, though I went round the prison at about 3 o'clock. Isaac Whitehall was a prisoner in the room with Bowen, who was nicknamed Speaker of the House. Heard Jewett say that the Honourable Mr. Bowen told him that as he had never been at war with God, he had no peace to make with them. The sheriff came and told Bowen he would chain him in the dungeon if he did not desist from advising Jewett to hang himself. which made him quiet for a short time, but he soon became as bad as ever. Witness asked Bowen how Jewett could murder himself. He said there was a cord aloft, and he could get it well enough. Bowen would continually remind him how long he had to live, from weeks down to his days and hours. Was awake during the night Jewett hung himself, and heard him come across his cell to the wall, and ask Bowen, "What o'clock?" Bowen told him, "3, and you have just 13 hours to live." "Well," said Jewett, "I will go to pray." "That's you," replied Bowen, an expression common to him to denote pleasure. In about 15 minutes afterwards I heard a noise, as if one had moved a stone in the room above, and presently a sound like that of someone choking. Ran to the window to call the jailer, but Bowen told me to hold my tongue, saying, "What in hell do you care for a damn negro?" I soon heard something like a person thumping his toes on the floor, then heard the jailer come to Jewett's door and call to him, but received no answer. Clapp said, "Well, I believe Jonathan has made away with himself," upon which Bowen, raising himself, said, "I am as glad as if I had $100. Now Clapp and old Mattoon have lost their fees, and I have saved the county $200 slick." Frequently heard Bowen tell Jewett he never would go upon the hill, meaning the place of execution, to have the boys make fun of him. Cross-examined. There was no cord, to my knowledge, conveyed from my room to Jewett's. Bowen could not have given him a rope without assistance. There was a rope in our room, which Bowen used to hide when the jailer came in, but it was larger than that which Jewett had. Bowen's legs were in irons the night on which the crime was committed. Saw Jewett once through the wicket of his door, and afterwards saw his ghost. I used to tell Bowen that he did wrong to tell Jewett to hang himself. Never heard Jewett say he intended to do so. John L. Partridge. Mr. Clapp asked me to listen to the conversation of prisoner with Jewett. Every day heard conversation between them. Bowen advising him to hang himself where he was, and telling him he was a damn fool to let Mattoon come and hang him, for he could die but one death. Jewett said he would think of it, but said he had nothing to do with it. Bowen said, "I will help you all I can." Jewett said, "I'd rather die honourable than kill myself here." Was working in that part of the jail where I could hear them as distinctly as if I had been under their window. Ebenezer Mattoon. I am High Sheriff. I threatened to confine Bowen if he did not cease to advise Jewett to destroy himself. Told Jewett, if he wanted to hang himself, he'd better do it in my presence. Bowen did not deny having advised Jewett, but said his tongue was his own. Jewett said he had no idea of killing himself, even on the evening previous to his death. He sometimes was mute when questioned on the subject. A cod line was found on Jewett, not sufficient to support his whole weight. Jewett appeared rather penitent on the last evening, though when his cap was tied, he treated it very lightly. Witness for the prisoner. N. Turner, worked in the jail. Had heard Jewett say he would disappoint the people who should come on the plane. He would invite people to come and see him hung, and when they were gone, he would say to me, "Those people will be disappointed." He once said he should do like the man in Vermont, who destroyed himself in prison, but afterwards said it would be impossible to hang himself where he was. Never heard Bowen, except in an indirect way, advise Jewett to commit suicide. Shabale Wilder, worked in the jail. Heard Jewett say he would not go to the place of execution. He said there were many ways to avoid it. He could get up in the window and throw himself headlong on the floor. I told him I thought he might do it if his courage held out. He replied, "You'll see what my courage will do." Never heard Bowen advise him to hang himself. The counsel for the prisoner. To invalidate Whitehall's testimony, offer to prove the badness of his character and offer to read a mittimus upon his arrest with 1 Upham for passing counterfeit money. The court held that such evidence was inadmissible. Elihu Sanford. Used frequently to see Jewett in confinement. I employed him to get tobacco from his friends, but they never sent him any. He told me last August that General Mattoon should never hang him. Mr. Bates and Mr. Lyman contended before the jury that murder was the taking of the life of another, and that a suicide is never a murder. No punishment is provided by any statute of the state for him who counsels the commission of suicide. Then it is not sufficient for the Commonwealth to prove that Jewett killed himself, and that Bowen advised and urged him to commit the act. It must be proved that the advice was the procuring cause of the death, and this the evidence wholly fails to show. And lastly, if indicted at all, the prisoner should have been charged as an accessory, not as a principal. The Attorney General insisted that the adviser of one who commits a felony of himself is a murderer, and that is the law as laid down by Blackstone. The proof is abundant that the prisoner's advice was at least one of the procuring cases of Jewett's death. Parker, C.J., to the jury. Considering the similarity between the nature of suicide and the murder of another, and the consistency and uniformity of writers and principles on this particular species of murder, if you find the facts as alleged in the indictment, you may safely pronounce the prisoner guilty. The important fact to be inquired into is whether the prisoner was instrumental in the death of Jewett, by advice or otherwise. The question is, did this advice procure the death of Jewett? The government is not bound to prove that Jewett would not have hung himself had Bowen's counsel never reached his ear. The very act of advising to the commission of a crime is of itself unlawful. The presumption of law is that advice has the influence and effect intended by the adviser, unless it is shown to have been otherwise, as that the counsel was received with scoff, or was manifestly rejected and ridiculed at the time it was given. It was said in the argument that Jewett's abandoned and depraved character furnishes grounds to believe that he would have committed the crime without such advice from Bowen. Without doubt he was a hardened and depraved wretch, but it is in man's nature to revolt at the idea of self-destruction. Where a person is predetermined upon the commission of this crime, the seasonable admonitions of a discreet and respectful friend would probably tend to overthrow his determination. On the other hand, the counsel of an unprincipled wretch, stating the heroism and courage the self-murderer displays, might induce, encourage, and fix the attention, and ultimately procure the perpetration of the dreadful deed. And if other men would be influenced by such advice, the presumption is that Jewett was so influenced. He might have been influenced by many powerful motives to destroy himself. Still, the inducements might have been insufficient to procure the actual commission of the act, and one word of additional advice might have turned the scale. If he was satisfied that Jewett, previously to any acquaintance or conversation with the prisoner, had determined within himself that his own hand should terminate his existence, and that he esteemed the conversation with the prisoner so far as it affected himself as mere idle talk, let your verdict say so. But if you find the prisoner encouraged and kept alive motives previously existing in Jewett's mind, and suggested others to augment their influence, you will decide accordingly. It may be thought singular and unjust that the life of a man should be forfeited merely because he has been instrumental in procuring the murder of a culprit within a few hours of death by the sentence of the law. But the community has an interest in the public execution of criminals, and to take such an one out of the reach of the law is no trivial offence. Further, there is no period of human life which is not precious as a season of repentance. The culprit, though under sentence of death, is cheered by hope to the last moment of his existence, and you are not to consider the atrocity of the offence in the least degree diminished by the consideration that justice was thirsting for its sacrifice, and that but a small portion of Jewett's earthly existence could in any event remain to him. The jury found the prisoner not guilty. End of section 13, read by Inkell.
Section 14 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1, by John D. Lawson. Trial of John Ury for inciting Negroes to crime and for being a Romish priest, New York City, 1741. Part 1. The narrative. The year 1741 saw the city of New York excited and alarmed over a supposed plot by the Negro slaves to burn the city and murder the inhabitants. There had been a Negro insurrection in the city 30 years before, and the history of those days had not been forgotten, so that when in the spring of 1741 the cry was raised of a Negro plot, there ensued a scene of confusion and alarm, of folly, frenzy, and injustice, which scarcely has a parallel in this country, or has a parallel alone in the witch prosecutions in Massachusetts in 1692. In February, the house of a merchant named Hogg was robbed, and John Hewson, the keeper of a low tavern to which Negroes were in the habit of resorting, was charged with the crime by his servant, Mary Burton, a girl of 16. He confessed to receiving a part of the stolen goods, and one Peggy Carey, a prostitute, was implicated. A few days later, the governor's house, the king's chapel, the barracks and stables were burned, but the cause was discovered. But several other fires occurring very soon after were clearly the work of incendiaries, and the cry of a Negro rising was heard on all sides. The military was called out and a reward offered by the governor of money and a full pardon to any person, white or black, who should discover the culprits. Mary Burton thereupon informed the magistrate that 3 Negroes, Caesar, Prince, and Cuffy, had met at her master's house and made a plan to burn the city and massacre the inhabitants. Hewson, his wife, and Peggy Carey were the only white people in the plot, but Hewson was to be king and Caesar governor. Promised pardon if she would confess. Peggy Carey did so, and in May the Negroes, Prince and Cuffy, were convicted mainly by the evidence of Burton and burned at the stake. Then Peggy Carey retracted her confession, only to be hanged along with Hewson and his wife. In the next month, more than a dozen Negroes were convicted and burned. Amidst it all, the cry of "No Popery" was raised, in that it was the plot of the Pope and the Spanish and John Ury, a son of a former secretary of the South Sea Company, an English non-juring clergyman who had come to New York for the purpose of teaching school, was arrested and indicted for aiding and abetting the Negro quack in setting fire to the king's house in the fort, and for coming into the city and province of New York, being a priest of Rome. Footnote: by a statute of 11 William IV, any priest of the Church of Rome who should come into the province after November 1700 should be imprisoned for life, and if he should break prison and be recaptured, should suffer death. End of footnote. He had no counsel, as was the practice of that day, but against him was the Attorney General and all the lawyers of the city, who had from the beginning been active leaders in the prosecution of the Negroes. He denied all knowledge of any plot or even of the witnesses who testified against him. Mary Burton, who had been the chief witness in the other cases, and William Kane, a soldier who had himself been accused, but had escaped by making a confession. Ury was convicted and hanged. He maintained his innocence throughout the trial and on the scaffold, with dignity and composure, and it is certain that it was the anti-popery feeling that led to the sacrifice of an amicable and interesting clergyman, of whose innocence there can scarcely remain a doubt. So absurd was the charge against him, and so feebly was it supported. The trial. Footnote: Bibliography. American Criminal Trials by Peleg W. Chandler, Boston; Charles C. Little and James Brown, London; A. Maxwell, 32 Bell Yard, Lincoln's Inn, 1841. This was an effort to present to the American public the notable criminal trials up to that time in the United States in a form acceptable to the general reader, viz., an abridged narrative without the technicality of legal procedure. Had the plan been successful from a publisher's standpoint, it was intended to make it permanent, but probably because it did not appeal to the legal profession, on account of its being only an abridged narrative, its publication was discontinued after only 2 volumes had been issued. Yet there are several cases, notably the trial of the Quakers, the Massachusetts witchcraft persecutions, and the New York Negro plot craze, which are well reported and which should satisfy the lawyer as well as the general reader. Mr. Chandler's report is taken from a journal of the proceedings in the detection of the conspiracy formed by some white people in conjunction with Negro and other slaves for burning the city of New York and murdering the inhabitants, published in 1741 by Daniel Horsemanton, the Chief Justice of the colony who presided at the trial. He was a firm believer in the reality of the conspiracy, and takes great pains to vindicate the proceedings of the magistrates. His work appears to have been prepared with much care and labor, but it possesses little to interest the general reader, being for the most part a collection of evidence and abstracts of court records, thrown together without much system or proper arrangement. The plot is not referred to in much detail by modern historical writers, although Mr. Dunlap, in the 2nd volume of his History of New York, gives a somewhat extended account of it, abridged from Horsemanton's journal. Mr. Bancroft disposes of it in a few words. Once he says, in speaking of the slaves, an excitement against them raged in New York through fear of pretended plot, but the frenzy grew out of a delusion. In History of the Bench and Bar of New York, 1877, there is a facsimile title page of Horsemanden's report. End of footnote. In the Supreme Court of the Province of New York, New York City, 1741, Chief Justice Horsemanden presiding, July 29th. John Ury was charged on 2 indictments. 1, having counseled, abetted, and procured a Negro slave named Quack to set fire to the king's house in the fort. 2, being a priest by the authority of the pretended see of Rome, he came into the province and city of New York after the time limited by a law against Jesuits and popish priests. He pleaded not guilty, prayed copies of the indictments, but a copy of the second only was given him. Bradley, Attorney General, and Chambers for the king. The prisoner had no counsel. Attorney General Bradley. Gentlemen of the jury, in order to maintain the charge against the prisoner upon this indictment, we shall prove to you that the prisoner was actually concerned in the plot to burn the king's house in this city and murder the inhabitants, that he has frequently been at Hewson's house in company with Hewson, his wife and daughter in Kerry, and with divers Negroes, talking with them about the plot, counseling and encouraging them to burn the king's house and the town, and to kill the inhabitants, that he advised them what would be the fittest time to set the English church on fire, and that the prisoner, as a popish priest, baptized Hewson, his wife and daughter in Kerry, and also divers Negroes, and told them he could forgive sins, and that he forgave their sins relating to the plot. When he was with the Negroes at Hewson's house, he used to make a round ring on the floor with chalk, or something, and stand in the middle of it with a cross in his hand, and swear the Negroes into the plot, and that they should not discover either the plot or him, or any other person concerned in it, though they were to die for it. We shall likewise produce to you a letter from General Oglethorpe to His Honor our Governor, whereby it appears that some time before the plot broke out here, the Spaniards had employed emissaries to burn all the magazines in considerable towns in the English North America, and that many priests were employed under pretended appellations of physicians, dancing masters, and such like occupations, and under such pretenses to get admittance into, and confidence in, families. What I have alleged, and much more, you will hear fully proved against the prisoner by the witnesses for the king on this trial. But before we enter upon their examination, give me leave to say a few words concerning the heinousness of this prisoner's offenses, and of the popish religion in general, which I shall speak but very briefly to, as there are several other gentlemen of counsel for the king on this trial, and as I have not had either health or leisure to prepare to say much on this occasion. The late dreadful conspiracy to burn the king's house and this whole town, and to kill the inhabitants, which the prisoner advised and encouraged, and swore many of the conspirators to join and bear their parts in, are crimes of too black and inhuman a nature to need any aggravation, and, no doubt, the prisoner's engaging, at the peril of his own life, is so destructive, so bloody, and dangerous an enterprise, proceeded from his being employed in it by other popish priests and emissaries, and his zeal for that murderous religion. For the popish religion is such that they hold it not only lawful, but meritorious to kill and destroy all that differ in opinion from them, if it may any way serve the interest of their detestable religion, the whole scheme of which seems to be a restless endeavor to extirpate all other religions whatsoever, but more especially the Protestant religion, which they maliciously call the Northern heresy. To attain this wicked end, their first trick is, by the subtle arguments, to persuade the laity out of their senses, by showing them a seeming necessity for their believing, as their church believes, if they tender their own salvation, and this, with many more frauds, the Church of Rome has artfully devised to get an absolute dominion over the consciences, that they may the more easily pick the pockets of credulous people. Witness the pretended pardons and indulgences of that crafty and deceitful church, and their masses to pray souls out of purgatory, which they quote, or rather wrest, Scripture for, when no such thing is to be found there, but is a mere invention and cheat of their own, to gull the laity of their money. Then they have their doctrine of transubstantiation, which is so big with absurdities that it is shocking to the common sense and reason of mankind. For were that doctrine true, their priest, by a few words of their mouths, can make a god as often as they please. But then they eat him too, and this they have the impudence to call honoring and adoring of him. Blasphemous wretches! For hereby they endeavor to exalt themselves above God himself, inasmuch as the Creator must necessarily be greater than his creature. These and many other juggling tricks they have in their hocus-pocus, bloody religion, which have been stripped of all their wretched disguise and fully exposed in their own colors by many eminent divines, but more particularly by the great Dr. Tillotson, whose extraordinary endowments of mind, his inimitable works, and exemplary piety and charity have gained him such universal esteem and applause throughout all the Protestant world, as, no doubt, will endure as long as the Protestant name and religion last, which I hope will be to the end of time. Gentlemen, when you have heard the witnesses prove what I have alleged against the prisoner, I make no doubt you will, for your oath's sake, and for your own country's peace and future safety, find him guilty. Witnesses for the prosecution: Mary Burton. Have seen Ury very often at Houston's about Christmas and New Year, and then he stayed away about a fortnight or 3 weeks, and returned again about the time that Hogg's goods came to our house. Have often seen him in company with Houston, his wife and daughter Peggy, and several Negroes, talking about the plot, burning the fort first, then the fly, and then the dog. Upon some of the Negroes saying they were afraid of being damned for being concerned in the plot, heard Ury tell them they need not fear doing it, but that he could forgive them. They were to burn the whole town and kill the people. Ury was to be captain of a company of Negroes, and he was to begin the fire where he lodged. Once when they were together above stairs, Ury, Houston, his wife, and Peggy, they called Mary, and I went up, but when I came upstairs, Ury had a book in his hand, and bade me go away, and asked me what business I had there, and said they did not call me. They called Mary Houston. He was angry, and shut the door to again. I looked under it, and there was a black ring upon the floor and things in it that seemed to look like rats. I don't know what they were. Another time I heard him talking with the Negroes, Quack and others, about the plot, and he turned the Negroes out of the room and asked me to swear. I said I would swear, if they would tell me what I was going to swear. But they would have me swear first. Houston and his wife went and fetched silks and gold rings and offered them to me, in case I would swear. But I would not, and they said I was a fool. Ury then told me he could forgive sins as well as God. I answered I thought that was out of his power. One night, sometime about New Year, I was listening at the door of the room upon the stairs, in which were Ury, Houston, his wife, and daughter Sarah, Caesar, Prince, Cuff, and other Negroes. I looked through the door, and saw upon the table a black thing like a child, when Ury had a book in his hand, and was reading, but I did not understand the language, and having a spoon in my hand, I happened to let it drop upon the floor. Ury came out of the room running after me downstairs. He fell into a tub of water which stood at the foot of the stairs, and I ran away. When they were doing anything extraordinary at nights, they would send me to bed. Prisoner: You say, you have seen me several times at Hewson's. What clothes did I usually wear? I cannot tell what clothes you wore particularly. That is strange, and you know me so well. I have seen you in several clothes, but you chiefly wore a riding coat and often a brown coat, trimmed with black. I never wore any such coat. What time of day did I usually come to Hewson's? You used chiefly to come in the night time, and when I have been going to bed, I have seen you undressing in Peggy's room as if you were to lie there. But I cannot say that you did, for you were always gone before I was up in the morning. What room was I in when I called Mary and you came up as you said you did? In the great room upstairs. What answer did the negroes make when I offered to forgive them their sins, as you said? I don't remember. William Kane. Know the prisoner very well, have seen him at Croker's, at Coffin's, and at Hewson's, and particularly with Daniel Fagan, Jerry Corker, and one plumber, and several negroes, at Hewson's. Jerry Corker was one of the first that brought me into the plot. One day before Christmas last, I was standing sentry at the governor's door, and Jerry Corker coming out, I being dry, asked him for beer. Jerry said he would get some, that he had rum in his pocket, and would make flip. He went in and made it in a copper pot and told me it was with loaf sugar. I drank a draught of it, and when I was relieved at night, Corker came into the guard room and asked me if I would go to Corker's at the Fighting Cocks, where there was to be a christening by a Romish priest. We went thither, and stayed till past 10 o'clock, but the people did not come that night. The next night, Corker and I went there again, but the people were not there. The third night we went to New Street, to the house of one Coffin, a peddler. There had been a child, and Ury christened it and read Latin. 3 acted as priests and handed the book about. Ury put salt in the child's mouth, sprinkled it thrice, and crossed it. Ury and Corker there endeavored to persuade me to be a Roman Catholic. Ury said it was best to be a Roman. They could forgive sins for anything ever so bad. I told him I did not believe him, and Corker told me that Ury and all priests could forgive sins. Ury was present at Hewson's when John Hewson swore me and his father and brothers into the plot. There was Quack and 40 or 50 Negroes there at the same time. We were to burn the town and destroy the people. David Johnson was there, and Ury tipped him on the shoulder, and they went into a room together and stayed a quarter of an hour. And when they came back, Johnson said, "We will burn the Dutch and get their money." But Ury's persuasions that he could forgive sins, many were brought in to be concerned. Ury was near me when I was sworn, and the Hewsons and I took him to be one of the head. Ury wanted to christen me, but I would not suffer him, and he would not speak to me, nor before me for a long time. For he could not abide me because I refused to become a Roman, till after he knew that I was concerned in the plot, and even then he did not care much for me. Ury was by when Hewson swore 8 Negroes into the plot in a ring, and it was then talked among them of burning the fort, and Quack, who was present, was at that time pitched upon to do it, in the presence of Ury, who might and probably did hear it. Jerry Corker told me that the English church was intended to be burnt on Christmas Day last, but Ury put it off, and said that when the weather was better, then there would be a fuller congregation. Prisoner: You say you have seen me very often. You saw me at Coffin's. You saw me several times at Hewson's. Pray, what clothes did you see me in? I have seen you in black. I have seen you in a yellowish greatcoat, and sometimes in a straight-bodied coat of much the same color. What time of the day have you seen me at Hewson's, and what did I say to you? I have seen you there chiefly at night, and you told me you could forgive my sins, and there would be no fear of damnation, and you wanted to christen me. You say you saw me christen a child in New Street. How was the child dressed, and what ceremony did I use, and who was present there then? The child was not naked, it was dressed as usual, and you put it on your left arm, and sprinkled it with water 3 times, and put salt in its mouth, and crossed it, as I said before. There were about 9 persons present. Did I use anything besides salt and water? Not that I saw. Who was present at the christening? 8 or 9 persons, I think. There was Jerry Corker, Daniel Fagan, Coffin, you, the mother of the child, myself, and 2 or 3 more. You say you saw me at Houston several times. What room was I usually in? Sometimes in one room, and sometimes in another. At what times was I there? At nights. What habit have you seen me wear? A black coat, a yellowish surtout, and sometimes a light-colored, close-bodied cape coat. What did I offer in order to induce you to become a Roman Catholic? Forgiveness of all my sins past. And what should I do in this case? And I said to you, what a fine thing it is to be of such a religion, when a priest can forgive sins and send one to heaven. Sarah Hewson. Know the prisoner, and have often seen him at my father's late in last fall chiefly. Have seen him there at night, in company with Negroes, when they have been talking of burning the town and killing the white people. Have seen him make a ring with chalk on the floor, which he made the Negroes stand around, and put their left foot in, and he swore them with the cross in his hand, to burn and destroy the town, and to cut their masters' and mistresses' throats. He swore Bastion, Caesar, Prince, and Quack. He swore them to keep secret, and not to discover him or anybody else, if they were to die for it. Have heard Ury and the Negroes talk of burning the fort. He said, if that did not do, they were to begin at the east end of the town, with a strong easterly wind, and that would go through the whole town. He asked me to swear to the plot, and said that I should have all my sins forgiven if I kept all secret, and he swore me on an English book, and my parents and Peggy were by. He swore Peggy, too. I heard him tell her that all her sins which she had committed should be forgiven her. And he told her that priests could forgive sins as well as God, if they would follow their directions. He used to christen Negroes there. He christened Caesar, Quack, and other Negroes, crossed them on the face, had water and other things, and he told them he would absolve them from all their sins. Prisoner, how did I swear you? On a book. I believe it was an English book. Who was present when I swore you? My parents, Peggy, Cain, and others. You say I baptized several people. Pray, what ceremony did I use at baptizing? When you baptized the Negroes, you made a cross upon their faces and sprinkled water, and you used something else, but I cannot tell what, and you talked in a language which I did not understand. Whom did I baptize? Caesar, Prince, Bastion, Quack, Cuffy, and several other Negroes. Chambers introduced a letter from General Oglethorpe of Georgia to the Lieutenant Governor of New York to show a probability that the prisoner was an emissary of Spain. The statement in the letter was that a Spanish prisoner taken in an engagement near Augustine had given intelligence that the Spaniards had employed emissaries to burn all the magazines in considerable towns in North America, thereby to prevent the subsistence of the English fleet in the West Indies, and that for this purpose many priests were employed who pretended to be physicians, dancing masters, and instructors, and under these pretenses were to endeavor to gain admittance and confidence in private families. Chambers, this is all the evidence. The prisoner, who was obliged to conduct his own defense, being asked if he had any witnesses, requested that Mr. Croker might be called and sworn. Prisoner, as I have lodged at your house for some time, you can best give an account of my manner of life and conversation, and pray first inform the king's judges and the jury if you ever saw any Negroes come after me. Croker, no, I never saw any Negroes come after you. Prisoner, pray, give an account of what you know of me. Mr. Ury came to my house last summer before last, and stayed a week. He then returned to Burlington and came back last November, and said he was going further, but I prevailed upon him to stay to teach my son Latin, for which I was to give him his lodging and diet. Some time ago he went to Staten Island and preached there, and said he was paid for it. He lodged at my house from November till a little before Campbell took Hewson's house. And while he was with me, he kept pretty good hours. Sometimes he came home by 8 or 9 or 10 o'clock, and sometimes stayed out till 11 or 12 at night. He once went to Brunswick this spring, before the fort was burned, as I heard, or else I do not know that he lay out of my house. Once talking of Negroes, I heard him say he did not think them proper subjects of salvation. He used to go upstairs sometimes, light a candle in the daytime, and lock himself up in the room alone. The Attorney General. Pray, Mr. Croker, were you in town all the time he lodged at your house? No, I have been out for a day or so. Pray, Mr. Croker, what hours did the prisoner usually come home at? Sometimes sooner and sometimes later. I have known him to stay out sometimes till 11 or 12 o'clock, once or twice later. I asked him why he stayed so late, and where had he been. He commonly told me he had been at Mr. Webb's, and sometimes at some other private houses. When did Ury come to lodge at your house, and when did he leave it? He came to my house in November last, and left it a little before Campbell went to live at Hewson's house. Have you ever heard him preach? Yes, once, and he then said he was to preach again next Sunday, and in his prayer before the sermon, he prayed for His Majesty King George and all the royal family. Joseph Webb. Have known Mr. Ury since November last. Was then at work at John Croker's at the English Clocks, and hearing him reading Latin and English, and thinking he read well, I inquired of Croker who he was. He told me he was a schoolmaster lately come from Philadelphia, and from this I became acquainted with him, and asked him if he would teach a child of mine. And he said he would, if Croker would give him the liberty of coming to his house, which Croker agreed to, and I sent my child to him, and he taught him Latin. After this I recommended him to Colonel Beekman to teach his daughter to write and cipher, and growing more intimate with him, I observed the poor and mean appearance in his habit, and I thought his pocket might be answerable to it. I gave him an invitation to my house, and told him he should be welcome at my table noon and night, at any time when he saw proper. He frequently came to my house accordingly, all the winter after. He used often to stay at my house late in discoursing, sometimes on one subject, sometimes on another, and has stayed there, now and then, till 11 or 12 at night, and I have often gone home with him to his lodging at those hours. Mr. Ury told me he was a non-juring minister. Having asked him who ordained him, he answered me, the senior non-juror in England. I have heard him preach, and have heard him say, such a day was his sacrament day, and he must be at sacrament. The Attorney General. Did he say he must take the sacrament, or be at the sacrament, or administer the sacrament? I cannot be sure, but I remember he said it was his sacrament day. Was it Sundays or working days he said were his sacrament days? I cannot be sure, but I think I have heard him name both. Do you know anything of his buying of wafers or going to a confectioner's? He asked me for a confectioner's shop, and I showed him Mr. de Brossie's, where he went along with me, and after he asked for several sorts of sweetmeats, he asked for wafers, which were being shown to him. He asked Mr. de Brossie if he made wafers for the Lutheran minister, and he was told he did, but I do not remember that he bought any of them. I've heard him pray and preach several times, but don't remember that ever I heard him pray for King George, but in general terms for the king. I am by trade a carpenter, and Ury applied to me to make him up something in Houston's house, which I have heard since called an altar. Ury gave me directions for making it, and said it was a place to lay books on to read, or to put a candle or a bottle and a glass on, or other some like common uses. It was 2 pieces of board, which formed a triangle, and was raised against the wall at the bottom of which was a shelf. On each side there was a place to hold a candle. The Attorney General: Do you think if a man wanted a shelf or other place to lay a book on to read, or set a bottle or glass on, he would make it in that form? I can't say. People may have odd humors, but I should not. When you made it, what did you take it for? I can't say. I followed his direction. Do you know anything of Ury's being imprisoned in England? Ury did tell me that he was imprisoned in England. He said he wrote a book there, and that the critics laid hold of it, picked a hole in it, and construed it treason. But if it was, he said it was contrary to his intentions. Mr. Webb, in your conversations together, what have you heard him say about Negroes? We were one day talking about Negroes, and I said I thought they had souls to be saved or lost as well as other people. Ury said he thought they were not proper objects of salvation. I replied, what would you do with them? Would you damn them all? No, says he. Leave them to that great being that has made them. He knows best what to do with them. Says he, they are of a slavish nature. It is the nature of them to be slaves. Give them learning, do them all the good you can, and put them beyond the condition of slaves, and in return they will cut your throats. John Campbell: Never saw a prisoner at Houston's house till I went to take possession of it at May Day last, and then, as we were going there together, he said he did not know the way thither. And when we came down, he took Garroder's Comfort's house for it. I know nothing more of him, but I took him for a grave, sober, honest man. Anne Campbell: Went with my husband and Mr. Ury on May Day last to Houston's to take possession of the house, and when we came there, Sarah Houston, the daughter, was in possession. We told her she must go out of the house, but that my husband had taken it, whereupon Sarah Houston swore and cursed at me, and Mr. Ury said to her, How dare you talk so impertinently and saucily to an old woman, you impudent hussy? Go out of the house or I'll turn you out. Sarah then swore miserably and said, You have a house now, but shall not have one long. I have often heard him pray and sing psalms, and he prayed by a sick woman. I never saw any harm by him. My husband and he were to keep school together. The Attorney General: If your honors please, as the prisoner has been now endeavoring to prove he is not a Romish priest, and has already insisted on it as part of his defense, I shall beg leave to examine a witness to that point. The court: Call him then, Mr. Attorney. Joseph Hildreth: The way I came to hear of Mr. Ury was that last winter I happened to be with a friend at Mr. Croker's, and Mr. Webb, joiner, asked me what school I had, and if I would decline to take a partner, one very well versed in the English, Latin, and Greek tongues. I answered him what school I had I could very well manage myself. I had no inclination for a partner at all. He said he was a good, sober sort of man, and understood his business very well, and if we could agree, he did not doubt but it would do very well. I answered him I inclined to be master of my own school alone, though it was not so large as if I had a partner. He, seeing I had no inclination for him, did not tell me who he was. Some time after I had a little business with Captain Griffith, where I met with prisoner and Webb in company, which was the first time I ever spoke to him. After our salutation he asked me concerning my school and method of teaching. We stopped in at Baker's and took a serious glass together, at which time he took a small book out of his pocket, English and Latin, and construed the 117th Psalms. Then, laying the book on the table, I took it up and was going to look on the title page, but he seized it out of my hands and told me I must not look into it, and put it in his pocket. Another time at my school, I had some discourse with him concerning Mr. Whitefield's letter in answer to Mr. Weasley's sermon on free grace, which letter he did not approve of at all, and told me he believed it was through the great encouragement the Negroes had received from Mr. Whitefield we had all this disturbance, and that he believed Mr. Whitefield was more of a Roman than anything else, and he believed he came abroad with no good design. I asked him what was the signification of a non-juror, as I understood he pretended to be. He answered, those that would not take the oaths of allegiance as he did not. I asked him why. Says he, can you swear one to be a bastard? No. No more can they say King James was one. And the difference between us non-jurors and others is this. We, in the prayer for the king and royal family, mention no names as they do. I asked him if they prayed for the king and royal family. He said, let him who will, that was the king. He mentioned no names. Another time he said, you talk so much against popery. I believe you speak so much against it. You will find you have, or I think you will have, a pope in your belly. For, says he, the absolution of the Church of Rome is not half so bad as that of the Church of England at the visitation of the sick. But, says I don't approve of their confessing to priests. Says I, there is a deal of wickedness and deceit in it. Says he, no, for when any person makes confessions, the priest does not know who they be, for he does not so much as see them, but only hears and absolves them. Then, says I was mistaken. Oh, says he, they speak against the Church of Rome, but don't know them. Their priests are the most learned of men. The articles of the Church of England were made in distracted times. And I observed several times he said, we priests. Says he, your Roman priests will make you believe and prove by the plain rules of grammar that black is white and white black, and that the wafer and wine is the real body and blood of Christ. We were often in company, but the best part of our discourse was upon salvation by faith alone, which he would not allow, nor predestination, and he told me he really believed the moon to be an inhabited planet, and all the stars were inhabited, or else, says he, I would not repeat that part of the Nicene Creed, begotten of his Father before all worlds. And says he, many texts of Scripture confirm it to be so. About 2 days before I heard him preach, being in his room, seeing the altar placed in the corner, I asked him what use that was for. First, he said, only to lay books on, or for a candle to sit and read by. But I told him I could not think it, for I supposed it for the sacrament by its form and odd color. I begged him to let me know what it was. After some time he told me it was for the sacrament, and every saint's day was exposed, only covered with a piece of white linen, and that he administered on some proper days, and they received the wafer instead of bread, and white instead of red wine. I asked, why the wafer? Because, says he, the wafer is more pure, and no bread he thought pure enough to represent the body of our Lord. Going to his small box, says he, I'll get a piece and you shall taste it if you will. And he brought me a piece, and I took and ate it. He told me that sometime before he had baptized a child in the house, but they used more ceremonies than we. They anointed and washed one another's feet. He told me that at the time of the celebration, or at what time the sacrament was exposed, they had lighted candles burning to represent our Savior as the light of the world. When I came in to hear him preach, I accordingly saw it as he told me. The sacrament was on the altar covered with a white linen cloth, and there were 3 candles burning. Not a minute after I came in, he put out the candles and put his sacrament in his box, and locked them up. End of section 14. Section 15 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1 by John D. Lawson. Trial of John Ury for inciting Negroes to crime and for being a Romish priest. New York City, 1741, Part 2. The prisoner, addressing the court and jury, did not deny that there had been a conspiracy, but pointed out the absurdity of supposing that he was concerned in it. Could anyone believe that he would have remained in the city so long after the discovery of the plot if he were guilty? Especially as he had been warned many days previous to his arrest that he was regarded with jealousy, there being suspicions that he was a priest. He averred that the suspicion of his being a priest was the cause of his being accused, but was it probable that the principal actors in this plot would entrust it to men of learning like priests, or that the latter would become associates of slaves in such a nefarious design as that of which he was accused? In regard to the positive testimony of the witnesses, he contended that they were not entitled to belief. If he was at the bottom of this plot, or the chief actor in it, why had they not before proclaimed it? Why had they maintained silence for several months until a large number had actually been hanged? His name had never been whispered by the informers until very recently. Their evidence was evidently made up to suit the popular cry against popery. Besides all this, he formerly had a difficulty with Sarah Hewson, one of the witnesses, in consequence of his reproving her for bad language, and she had threatened his life. Was her evidence under these circumstances to be used against him? In regard to the second indictment, that he was a Romish priest, he insisted that there was no evidence of it whatever, and concluded, "Gentlemen, the mistake the major part of the world lies under is their apprehending that a non-juring priest must be a popish priest, whereas there are no truer Protestants, for they are far from having any regard to a pretender, or for setting on the throne a popish prince to be the head of a Protestant church. The doctrine they assert and stand by is non-resistance and passive obedience, which is now as vigorously maintained as ever it was in any reign, and I believe there is no non-juror, either clergy or laity, but would show themselves such true subjects to the present King George as to take the oaths of allegiance and supremacy. I have now no more to say, but hope and pray that what has been offered will be considered with minds unprejudiced, minds prepossessed with no opinions, with minds in a diligent search after truth. You being gentlemen, I hope, fearing God, reverencing conscience, hating partiality, lovers of truth and innocency, and having a tender regard to life." Chambers, for the king, made a long and excited speech against the prisoner, much of which consisted of invectives against the Roman Catholic religion in general. The monstrous wickedness of this plot would probably among strangers impeach its credit, but if it be considered as the contrivance of the public enemy, and the inhuman dictate of a bloody religion, the wonder ceases. What more cruel and unnatural can be conceived than what Rome has contrived? Yea, what more savage and barbarous than what popery has attempted, and sometimes executed, for the extirpation of that which the papists call heresy? We need not go so far from home as the valleys of Piedmont, nor rake into the ashes of the Waldenses and Albigenses for tragical instances of popish cruelty. We need not remind you of the massacre at Paris, nor the later desolations in France, nor mention the horrible slaughters of the Duc d'Alva in the Low Countries. We need not recount the many millions of lives that in remote countries and different ages have been sacrificed to the Roman idol. nor measure out to you that ocean of foreign blood with which the scarlet whore hath made herself perpetually drunk. No, gentlemen, the histories of our native country will give us a formidable idea of popery, and inform us of the detestable principles of that religion. Witness the blood of our own martyrs, who perished in prisons and at the stake, without beginning higher than my Lord Cobham, and recounting their number down to the end of Queen Mary's reign. Witness that execrable design to blow up kings, lords, and commons in the gunpowder treason contrived by the papists, that intestine fire that broke out in the last unnatural war, the coals whereof were blown up by them, that bloody massacre of many thousands of Protestants by the Irish papists about the same time, the restless spirit of that party, which has broken out in plots in almost every reign since the Reformation, the arbitrary and illegal measures that preceded the glorious Revolution, and the unnatural rebellion within our memory. These are all evidences of the destructive tendency of that bloody religion, which, in order to promote its interests, never boggles at the vilest means, can sanctify the most execrable villainies, and, to encourage its votaries, will canonize for saints a Guy Fawkes and others, some of the greatest monsters of iniquity that ever trod upon the face of the earth. The jury went out and in 15 minutes returned a verdict of guilty. The court asked whether he had anything to say in arrest of judgment, or why the sentence of death should not be passed upon him. The prisoner answered he had nothing to say, but requested as much time as could be allowed him to settle his private affairs. The execution. Ury was executed on Saturday, August 29th, 1741. Arrived at the place of execution, he addressed the crowd from the gallows, immediately before he suffered in these words: "Fellow Christians, I am now about to suffer a death, attended with ignominy and pain, but it is the cup that my heavenly Father has put into my hand, and I drink it with pleasure. It is the cross of my dear Redeemer. I bear it with alacrity, knowing that all that live godly in Christ Jesus must suffer persecution, and we must be made in some degree partakers of his sufferings before we can share in the glories of his resurrection. For he went up to glory after he ascended Mount Calvary. He did not wear the crown of glory before the crown of thorns. I am to appear before an awful and tremendous God, a being of infinite purity and unerring justice, a God who by no means will clear the guilty, that cannot be reconciled either to sin or sinners. In the presence of that God, the possessor of heaven and earth, I lift up my hands and solemnly protest I am innocent of what is laid to my charge. I appeal to the great God for my non-knowledge of Hewson, his wife, or the creature that was hanged with them. I never saw them living, dying, or dead, nor ever had I any knowledge or confederacy with white or black as to any plot. And upon the memorials of the body and blood of my dearest Lord, in the creatures of bread and wine, in which I have commemorated the love of my dying Lord, I protest that the witnesses are perjured. I never knew them but at my trial. But for a removal of all scruples that may arise after my death, I shall give my thoughts on some points. First, I firmly believe and attest that it is not in the power of man to forgive sin, that it is the prerogative only of the great God to dispense pardon for sin, and that those who dare pretend to such a power do in some degree commit that great and unpardonable sin, the sin against the Holy Spirit, because they pretend to that power which their own consciences proclaim to be a lie. Again, I solemnly attest and believe that a person having committed crimes that have or might have proved hurtful or destructive to the peace of society, and does not discover the whole scheme and all the persons concerned with him, cannot obtain pardon from God, and it is not the taking any oath or oaths that ought to hinder him from confessing his guilt and all that he knows about it, for such obligations are not only sinful, but unpardonable if not broken. Now, a person firmly believing this, and knowing that an eternal state of happiness or misery depends upon the performance or non-performance of the above-mentioned things, will not trifle with such important affairs. I have no more to say by way of clearing my innocency, knowing that to a true Christian, unprejudiced mind, I must appear guiltless. But, however, I am not very solicitous about it. I rejoice, and it is now my comfort, and will support me and protect me from the crowd of evil spirits that I must meet in my flight to the region of bliss assigned me, that my conscience speaks peace to me. Indeed, it may be shocking to some serious Christians that the holy God should suffer innocency to be slain by the hands of cruel and bloody persons. I mean the witnesses who swore against me at my trial. Indeed, there may be reasons assigned for it, but as they may be liable to objections, I decline them, and shall only say that this is one of the dark providences of the great God, in his wise, just, good government of the lower world. In fine, I depart this waste, this howling wilderness, with a mind serene, free from all malice, with a forgiving spirit so far as the gospel of my dear and only Redeemer obliges and enjoins me to, hoping and praying that Jesus, who alone is the giver of repentance, will convince, conquer, and enlighten my murderous souls, that they may publicly confess their horrid wickedness before God and the world, so that their souls may be saved in the day of the Lord Jesus. End of section 15.
Section 16 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 1, by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks, Kentucky, 1839, Part 1. The Narrative. Judge Wilkinson of Mississippi was a guest at the Galt House in Louisville on his way to Bardstown, where he was to be married. He had with him his brother Dr. Wilkinson, a physician, and a young friend named Murdaugh, and the three remained in Louisville a few days to attend to their wardrobes. Redding, a local tailor, was employed to make a suit of clothes for the doctor. The coat did not fit. A dispute arose in the shop over the matter, which ended in a scuffle in which the judge struck the tailor a blow on the head with a poker, and both the doctor and Murdaugh drew bowie knives. The tailor went to the mayor's office to get a writ against the three, but was told that he must first have their names, so Redding, accompanied by his brother-in-law Rothwell, went to the Galt House to obtain them, which he did from the barkeeper. Meanwhile, the story of the affray at the tailor's had reached his friends, and several of them, notably a butcher named Johnson and a barkeeper named Meeks, were suggesting to the others that they should go to the Galt House and avenge the attack on the tailor. Hence it was that just before supper a number of persons, friends of Redding, the butcher and the barkeeper, Holmes, Oldham, and others, dropped into the bar-room, and most if not all of them were armed. It was not unusual for strangers to assemble at the hotel at this time, for it was a popular gathering place of the city. But on this occasion the number assembled, and the excitement which prevailed caused several people to believe that a fight would probably take place. Just after Redding had obtained the names of his assailants, Judge Wilkinson came into the bar-room, and was at once asked by Redding if he was not the man who had struck him with the poker, and was denounced as a scoundrel, coward, and poor Mississippi judge, and told that if the Mississippians would lay aside their weapons and go out into the street, he, Redding, would whip all of them. The judge replied that he would have nothing to do with a man of his profession, that if he laid his hand upon him he would kill him, and then retired, accompanied by a friend, Mr. Everett, to his own room on the second floor. A quarter of an hour later the judge, the doctor, and Murdaugh came down into the bar-room for supper, which was nearly ready. When they entered, Redding exclaimed in a high voice, "They are all three here now," and accosted Murdaugh, saying, "You are the gentleman who drew a knife upon me at my shop today." Murdaugh replied, "Whoever says I drew a knife upon you is a damned liar," and displayed in his right hand a white-handled dirk, telling him to stand off, and swearing he would kill the first man that laid hands upon him. Meeks seized his wrist, exclaiming, "You are the damned little rascal," and struck him over the head with the butt end of a whip, when several persons rushed up, and Rothwell struck him over the head with a hickory club. Murdaugh took the knife in his left hand and stabbed at Meeks, who retreated, striking Murdaugh with the whip, when Murdaugh gave a fatal stab to Meeks. During this time, Dr. Wilkinson was knocked down and beaten by one Holmes and others. Judge Wilkinson had also been struck with a sword cane by some one of the friends of Reading. Rothwell joined those who were beating the doctor when the judge stabbed Rothwell in 2 places with a bowie knife, and also with the same knife stabbed Holmes through the arm. The judge then retreated through the passage and upstairs to his room, keeping the crowd away by brandishing his bowie knife. He and Murdaugh were pursued to the stairs and struck with chairs, and as they ascended were shot at by Oldham. Reading disappeared as soon as the affray commenced. But when it was over, Rothwell was found dying and Meeks dead on the barroom floor. The Mississippians were unknown to any of those who assaulted them, had never seen nor conversed with any of them. Judge Wilkinson, his brother, the doctor, and Murdaugh, after preliminary examination, were indicted for the murder of the 2 men by a Louisville grand jury. But on the petition of the friends of the Mississippians, who alleged that they could not get a fair trial in that city, the state legislature passed an act permitting the venue to be changed to the Mercer Circuit Court, and at Harrodsburg in that county the trial came off on the 11th day of March, 1839. There are 2 footnotes from the preface to Brown's report. Rothwell was a hatter in Louisville and well thought of by his neighbors. His death occasioned a great and melancholy gloom throughout the whole city. People talked of it with tears as a circumstance peculiarly to be lamented. The oldest inhabitants of the city could call to mind vividly the day on which his mother had landed on the wharf with him as an infant in her arms just 37 years ago. He had grown up with its growth, almost coeval in years, and he had prospered with its prosperity by keeping pace with its enterprise and industry. As a mechanic, he had reached competency after a life of toil. As a citizen, he had won the affections of all that knew him. By the warmth of his heart, the devotedness of his friendship, and the zeal and promptitude with which he sought the point of danger when fire or pestilence assailed their habitations. We have but little opportunity for collecting any details of interest to the reader respecting Mr. Meeks. His family, it was said, lived at Madison, Indiana. He had been some years known in the city, part of the time as a barkeeper to Mr. Dewey's, who keeps the hotel on Wall Street. Since his death, it has been erroneously asserted in the Eastern papers that he was the noted Robinson, but it is certainly a mistake. Many still assert that he had a great resemblance to Robinson. That, however, may have been accidental. The case had caused intense excitement throughout the state, and the courtroom was crowded to the doors, more than 200 of the spectators being women to whom the presiding judge gave preference in the hearing. The Commonwealth was represented by the prosecuting attorney, and a venerable member of the bar, Benjamin Hardin, was specially retained by the families of Rothwell and Reading. For the defense, no less than 8 lawyers appeared, several of them leaders of the Kentucky bar, and one, Sergeant S. Prentice, the great forensic orator of Mississippi, who came from that state to defend the men who were his clients, his fellow citizens, and his friends. The speeches on both sides attracted marked attention in all parts of the land at the time, and while not at all in accord with our standards of public speaking at this day, are good specimens of the style of oratory so much admired and so effective in the West and South 50 years ago. The opinion has often been expressed that the address of Sergeant S. Prentice is the greatest effort of this remarkable orator, and has rarely been surpassed in this or any other country. The appeals to Kentucky chivalry, to the disgrace of receiving a blow without returning it with a stab, and to the beauty and sentiment of the women of Kentucky were effective. The jury returned a verdict of not guilty after only 15 minutes' absence. Footnote: From Foot, Bench, and Bar, the South and Southwest. Published St. Louis, 1876. Whilst making ready to leave Natchez, I fell into company by accident one morning at the hotel where I was staying, with a young gentleman who at the very first sight impressed me with a deep and peculiar interest. He was apparently in delicate health, and was evidently suffering also from serious depression of spirits. He gave me some account of his personal history, which I found to be not a little tinctured with romance, and marked with several incidents well calculated to awaken feelings of tenderest commiseration. He had a special claim upon my sympathy by reason of the fact that he was, like myself, a native of Virginia, and a friendship at once sprang up between us, which lasted without the least abatement of kindness on either side, up to the period of his lamented decease, some 17 or 18 years later. I refer now to Edward C. Wilkinson, a consummate scholar, an erudite lawyer, and an upright and pious gentleman. After having achieved some success in his profession, and after having surrounded himself with multitudes of friends and admirers, he became involved in a tragic affair in the city of Louisville, Kentucky, of most melancholy import, which resulted in his being tried for murder, amid the raging of a furious local excitement, and in his being, in the end, honorably acquitted. This case is one of marked celebrity, and in defense of Judge Wilkinson, S.S. Prentice made, in association with the celebrated John A. Rowan, one of the ablest speeches of his life, in opposition to Benjamin Harton, whose extraordinary powers were most vehemently exerted in order to bring about a conviction. The trial. In the Mercer County Circuit Court, Harrodsburg, Kentucky, March 1839. Honorable John L. Bridges, Judge. March 11th. Edward C. Wilkinson, John Murdaugh, and Benjamin R. Wilkinson, having previously been indicted in Jefferson County for the murder of John Rothwell and Alexander H. Meeks, the trial came on today. Edward J. Bullock and Benjamin Harden for the Commonwealth. John Rowan, S.S. Prentice, Colonel Robertson, Samuel Davis, John B. Thompson, Charles M. Cunningham, James Taylor, and Charles Wycliffe for the defense. When the jurors were called, 6 were put aside by the court for having formed opinions, and 4 were challenged by the defense. The prosecution made no challenges. The following were selected and sworn: Benjamin Alsop, R. M. Davis, Buckner Miller, Robert Alexander, John Bowman, John Burton, Elijah Gabbett, John Bowen, John Adair, Ebenezer McGoffin, Charles Humphreys, and Jacob Van Arsdell. The clerk having read the indictments, and the prisoners having pleaded not guilty, the judge charged the jury to hear the evidence and give a true verdict according to the same. Witnesses for the prosecution: John W. Redding. Am a tailor in Louisville, Kentucky. My job is on the corner of 3rd and Main Streets, 1 square from the Galt House. In December last, Dr. Wilkinson called at my shop and ordered a suit of clothes to be ready the following Saturday. He also ordered an overcoat to be ready the next week, and a pair of pantaloons. He said he would call on Saturday for them. I finished the clothes, folded them on the counter to send to the Galt House. On Saturday afternoon he came to my store, took off his old coat and tried on the new one, which he seemed to like very well, merely remarking that it was a little loose. But he had been sick and had fallen away, and hoped soon to fill it up. He took the things out of his old coat pockets and put them into the pockets of the new coat, told me to send the pantaloons and vest to the Galt House, and handed me a $100 Mississippi bank bill, which he required me to hold over for a week or 2, as the discount in a few days would be considerably reduced, and in an hour or so returned with his brother, Judge Wilkinson, and Mr. Murdaugh. He said he would have to throw the coat on my hands, as it did not fit, and his friends had told him it was badly made, not fashionable. The judge also said about its not being fashionable. I offered to make any alteration. He said no, that it was no coat at all. I said I would keep it. The doctor then took out some money, and said he would pay for the pantaloons and vest, which had been sent to the Galt House. The judge said, no, do not pay for them. Perhaps they would not fit. They would be like the coat. He and Murdaugh had more to say against the clothes than the doctor, who, I saw, would be pleased enough only for them. He said the law was that if a coat did not fit, it should be taken back. When the judge interfered so much, I said it took more than one to judge a coat, and that I thought he had already said more than he ought. The judge, who had been sitting near the stove, then jumped up and said he did not come there to be insulted. I said I did not intend to insult him. He snatched up the iron poker and struck me on my arm. Hearing something about a bowie knife, I tried to get them to the street, where someone would be passing, and seized the judge and jerked him to the side door near the corner. As I got to the door, I slipped and fell, and the judge fell with me. I thought the whole 3 were on top of me, and struggled till I got the judge under me, and I raised to keep him off the doctor, or to pull him down, when he tried to stab me with his knife, but was prevented by someone. The judge still held on to the poker. When the doctor drew his knife on me, a voice quite near, which I thought was Murdaugh's, cried out, "Kill the damned rascal!" And someone ran up and held the doctor's arm. I threw them off and got on the pavement. Murdaugh was on the pavement with his knife drawn. I picked up a brickbat and told them I would whip the whole three if they would lay aside their weapons. I returned into the shop, and the doctor followed me in with his drawn knife in his hand, demanding his $100 bill. In the scuffle I had lost my pocketbook, in which it was, but someone had picked it up, handed it to me, and I gave the doctor his $100 bill. They went away with the knives drawn, and the doctor carried off the poker. Several persons came into the shop after they had gone, and some advised me to get them taken up. Did not want to do so, but was persuaded to go to the mayor's office with Bill Johnson. Before this, I went to Mr. Fulton's store and got a small dirk knife for Mr. Knoll, which I put into my watch pocket. We called at Vaccaro's and Hyman's coffee houses to inquire for the marshal, Mr. Turner, or one of the police officers. Not meeting them, we went to the mayor's office, told the circumstances to Mr. Pollard, the police clerk, and that I wanted a warrant. He asked me for the names, said I knew one was Wilkinson, but could get the names at the Galt House. Mr. Pollard said he could not give me a warrant without the names, but Mr. Turner could arrest them without a warrant. Told him that I would go to the Galt House for the names. We then searched for Mr. Turner, but could not find him. Bill Johnson went into the jail to inquire for Mr. Turner, and I stayed on the outside. Saw Rothwell, my brother-in-law, standing at Dr. Bernard's office, and told him what had happened. He went along with me. Not being able to find any officers, we proceeded to the Galt House, went into the barroom, and asked for the register and the names of the 3 Mississippi gentlemen. Mr. Everett came in and gave me the names on paper. Got to talking with Mr. McGrath, who was inside the counter, and told how I had been treated at my own store. Judge Wilkinson came into the barroom and up to the counter to take a glass of water. Leaning on the counter, I said to him, "I think you are the gentleman that struck me with the poker in my own house today." He said he was, and then said, "I will not quarrel or fight with a man of your profession, but if you interfere with me or lay a hand on me, I'll kill you." He put his hand behind him, as I thought, for some weapon. I called him a coward for coming to my house with 2 others to assault me, and offered if he and they would lay aside their weapons and come into the street or into a room to whip the whole 3. He walked backwards and forwards across the room, and I kept telling him what I thought of him. He passed out of the barroom, but was gone but a little while when he, the doctor, and Mr. Murdaugh came in. Murdaugh came towards me. I remarked to him that he was the man who had drawn his knife on me in my own shop. He said if I had said that he had drawn a bowie knife on me, I was a damned liar, and he threw up his hand with a drawn knife in it. I think someone remarked that he was the man, for he had seen him. The fight then began, and the crowd rushed so close about Murdaugh and the others that they were hurried past me, and I could not see what was doing. No Meeks was killed, but did not see him killed. Mr. Rothwell came up when he heard the damned lie given, and pushed me back with his arms, which caused me to be outside the scuffle. A little while after that, Judge Wilkinson, with a large bowie knife in his hand, came hurrying past me. The knife he had was like this. I think it is like the same knife. Mr. Harton handed the knife to witnesses. It was from 8 to 10 inches long in the blade, 2 inches wide, heavy, and shaped at the point like other knives of that name. He came rushing by me, stabbing at several persons. By that time Holmes had Dr. Wilkinson down in the left-hand corner of the room. Judge went towards the door, and Meeks was lying in the opposite corner. The crowd was retreating into the passage and making towards the stairs. Seized the chair, but fearing I might hit the wrong person, I did not make a blow. At the foot of the stairs I heard Mr. Oldham say that he'd give the damned rascal a pistol, and a pistol was fired, but I did not then know by whom. Mr. Harton, was the poker large enough to kill a person with a blow? Yes. What did you observe of Rothwell in the passage? He told me that he was very badly stabbed. How long did Mr. Rothwell live? Till next evening. He died at my house. Where did you first see Mr. Rothwell that evening? I met him in Dr. Bernard's office in Market Street. He was my brother-in-law. Did not ask him to accompany me at all. He merely kept on with me when I told him what had happened. What object had you and he in going to the Galt House? No other design than to get the names of the 3 Mississippians. When you went into the bar-room, did you tell Mr. Everett your object? Yes. Did you display the dirk at the Galt House? No, I never drew it from my watch pocket. Mr. Rothwell was not in the room when I first spoke to Judge Wilkinson. Did not see the blow inflicted on Rothwell that caused his death. The crowd shut me out from seeing distinctly what was doing. I found one of the knives on the floor when the fray was over. Where did you next see these 3 knives? I called at the jail and asked Mr. Chenoweth if the knives were there. He said yes, and produced them. There was blood on the 3 knives at the time. Told Mr. Chenoweth at the jail to keep them with the blood on them just as they were. He gave them to me rolled up in paper, and I put them away in my trunk. Here the jury examined the knives. Cross-examined by Colonel Robertson. Neither Meeks nor Rothwell were at my shop. It was half an hour and an hour between the affray there and the one at the Galt House. Johnson went with me to the mayor's. He left me near the jail, and I saw him next to the hotel. I borrowed after the first affray a dirk knife from Mr. Fulton, fearing an attack. Did not ask Rothwell to go with me to the Galt House. I went there simply to get the names. After I got them, I stayed about 15 minutes when Judge Wilkinson came in. I merely remarked that he was the gentleman who struck me with the poker. He said he would not quarrel with a man of my profession. Then I told him what I thought of him, that he was a coward. He walked up and down a bit, and then went out. I waited for the marshal. If Rothwell had a stick, I did not see it. I have employed Mr. Hardin to assist in this case, and am to pay him $1,000. Did not agree with Johnson to meet him at the Galt House. On the street I met Mr. Holmes, Mr. Wallace, Mr. Hulbert, and Mr. Oldham. All other friends of mine were at the Galt House, Mr. Monahan and Mr. Rhea among them. I saw no sword cane at the hotel. Saw the judge stabbing at Rothwell and others. We pursued him into the passage and to the stairs about 20 or 30 feet from the barroom. Don't know why so many of my friends were at the hotel. Holmes nor Johnson did not live near the Galt House. Did not draw the dirk when I was attacked. Mr. Halbert boarded at the hotel. It is usual for people to congregate at the Galt House after supper. Had no intention when I spoke to Judge Wilkinson of reviving the quarrel. Neither Rothwell nor Johnson or Meeks ever suggested to me the propriety of giving them a little throwing over to teach them better manners. I have sued the prisoners for damages. There's a coffee house in the same building as my store. It is kept by my brother. Thomas Craig. Was in Redding's shop on the day of the affray. Dr. Wilkinson tried on part of the suit of clothes made for him, not seeming to make any objection to the coat. He left a $100 bill in his measure for an overcoat, and said that he would redeem the $100 bill and pay for the whole of the clothing. Took away the coat on him, and returned in about an hour, and said he would leave the coat on Mr. Redding's hands. He said he found a deficiency under one arm. The judge made a great many objections to it. He said it was not a fashionable coat, it had not a proper collar, and that it was no coat at all. Went myself up to the mirror with them to look at the fit of the coat. The judge came around to the stove and sat by it. Could not recollect what was said, but the coat was returned. Doctor took out money to pay for the pantaloons and vest, when the judge remarked that he ought not to pay for them till he would know how they might fit, that they might be like the coat. The judge sat on a high stool at the stove. The doctor was near the cutting board. When the judge made the remarks about the pantaloons, Redding retorted that he had more to say about them than he ought, upon which Judge Wilkinson picked up the poker and struck Redding, and Redding jerked him to the side door. Redding, after being out on the street with them, picked up a brickbat and said he would whip the whole 3 if they would lay by their weapons. Saw Mr. Murdaugh standing on the edge of the pavement with his knife drawn. Did not see the doctor have any knife before he left the shop. Cross-examined. Did not hear the damned lie given before Judge Wilkinson picked up the poker, nor did I see Redding walk up to the judge in an offensive manner. The judge was sitting and Redding standing when the judge picked up the poker. The judge said that the law was that when the clothes did not suit, they were to be thrown on his hands. Redding replied that he had rather more to say about it than he ought. The judge said he did not come there to be insulted. Redding appeared to me to be very mild. Did not hear Redding say, "Who are you?" or "You are too officious." It was after dinner about 3 or 4 o'clock. There were not many at the shop until after the affray. After that several were there and advised Redding to take the law of the Mississippi gentleman. Think Holmes was there. Did not notice Meeks, nor did I then know Johnson. When some advised Redding to take the law of them, he said he did not like to sue them. Did not hear anyone recommend him to take redress himself with his friends. When the judge struck at Redding, the doctor tried, I think, to separate them, but he may have intended to assist his brother. It was difficult to tell. Did not see the judge draw a knife. Cannot say that I saw any knife but with Mr. Murdaugh, after Redding had picked up the brickbat. Various persons came into the shop before Mr. Redding went to the mayor's office. I live with Redding and work in his shop. Did not hear Mr. Murdaugh say, "Stop this fight." W. Weaver. was in Redding's shop and saw the gentleman talking about the coat. Mr. Murdaugh said he did not like the coat. The other said he did. One of them, the judge, said he'd be damned if it did not take more than one to judge the coat. Judge Wilkinson called out for his knife. Dr. Wilkinson had a white-handled knife. Redding pulled Judge Wilkinson out of the door, and the doctor followed. I think the knife on the table is the same I saw with the judge when he came in from the street with the knife to get back the $100 bill. Heard someone halloo for the knife. It might be Redding. Cross-examined. When the judge told the other not to take the coat, Redding said he did not insist on him taking it, and then Judge Wilkinson said that Mr. Redding had no right to judge. Redding said he had no right. Redding said he meddled more about the coat than the doctor did, something like the judge making himself damned meddlesome about the matter. Dr. Wilkinson pulled out money to pay for the pantaloons and vest. Colonel Robertson. Is this the doctor or the judge? Pointing to the doctor. The doctor, I think. Is this the judge? It is. No one but the doctor, Judge Wilkinson, Mr. Murdaugh, Redding, and Mr. Craig, except another boy with me, were in the store. One went in and went out before the fight began. The court. It is time to close for the night. What do you propose to do with the jury? The counsel for the defense said they had no objection to the jury being allowed to retire and have proper accommodations. The court. Very well, let the judge take charge of the jury and provide for them at a tavern. You, gentlemen of the jury, will take care not to converse with any person on the subject, or express any opinion concerning this cause, or to allow anyone to address you about it during your absence from the court. End of section 16. Section 17 of American State Trials, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Chris Pyle. American State Trials, Volume 1 by John D. Lawson. Trial of Judge Wilkinson, Dr. Wilkinson, and John Murdaugh for the murder of John Rothwell and Alexander H. Meeks, Kentucky, 1839, Part 2. March 12th. Samuel Redmond. Worked for Redding and went to his store that Saturday afternoon to draw some money. Saw these gentlemen at the store. The first I saw was Redding pulling the judge out of the door. He fell and turned over, the judge being on top, but Redding succeeded in turning the judge under, and the doctor immediately attacked Redding with his knife, and Mr. Murdaugh cried out, "Kill the damn son of a bitch." As the doctor was in the act of stabbing Redding, and the knife was within 3 or 4 inches of his breast, I seized the doctor's arm and said, "Don't do it, if you please." And then Murdaugh said, "Part them." Redding then got out into the street with one shoe off and the other on. At the same time, Murdaugh was on the pavement with his knife drawn. The doctor entered the store with his knife drawn in his hand, demanding his $100 bill. Redding had dropped his pocketbook in the scuffle, and I picked it up and carried it in to him. He then took out the $100 bill and returned it to the doctor, saying, "Here's your $100 bill." They all then went off, 2 with their knives drawn and the judge with the poker. Cross-examined. Am not in Redding's employ now. Did not say at the preliminary examination that I heard Redding give the lie in the shop. Mr. Rowan. The minutes taken at the examining court have been transmitted through Mr. Redding's hands to the prosecuting attorney of this court, and it is only in courtesy and through the politeness of the prosecuting attorney that the counsel for the defense has been allowed to the perusal of them. The prosecuting attorney has withdrawn these minutes. We now demand them as a public document. The court. It is probable the right is regulated by Act of Assembly. Mr. Bullock. The prosecutor does not stand upon that point. The reason I withdrew the minutes was that they were neither minutes of evidence nor even a synopsis of what had taken place at the examining court. They appear to be nothing but a few memoranda made for the use of the grand jury, but so inadequate for any purpose in a final trial that, finding they could not be available to either side, I decided upon not using them in the prosecution nor yielding them to the defense. Mr. Redmond. No one went with me to the store. The doctor would have stabbed Redding had I not held his hand. Redding had the judge down and reached his arm to pull down the doctor, when the doctor raised his knife to stab Redding as he was about to be pulled under by Mr. Redding. Did not see the knife till that time with the doctor. He must have had it drawn and opened before, because he could not, have got his other hand disengaged to assist in opening it when Redding had a hold of him. When these gentlemen were in the shop talking, Mr. Craig was at his board. I saw a boy named Weaver there. I think it was between 3 and 4 o'clock. When Murdaugh called out, "Kill the damned rascal," he stood on the pavement near the street. It was not till I caught the doctor's arm so that he could not make the blow that Murdaugh said, "Part them. Don't let him kill him." There was a little time elapsed between him saying, "Kill the damned rascal," and "Part them. Don't let him kill him." John Paris. Was passing Redding's store when I heard some fuss. I saw Redding fall out of the side door with one of the gentlemen. Another gentleman had a knife and said he would kill him. I said, "Don't kill him," and a young man then caught his arm. After this, Redding picked up a brickbat, and one of the gentlemen said, "Give me my money." He followed Redding into the shop and got the $100 bill. They returned to the street, and as Redding got to the door, he said he would whip the whole 3 of them if they would put away their knives. The doctor had the knife, saw Mr. Redmond catch his arm, saw Mr. Murdaugh there, but he was not taking any part in the affair. Saw him after on the pavement with a drawn knife. Cross-examined. The doctor said, "Damn you, I'll kill you." I said, "Don't kill him." He had not time to make the stab when his arm was caught. All 3 went into the shop, and when they came out, Redding came to the door and said, "Lay down your damn knives, and I'll whip the 3 of you." "No," said Mr. Murdaugh, "I'd rather cut your damn guts out." One of the gentlemen came up and took him away. They went off with their knives drawn. It was between 3 and 4 o'clock. Am a coffee house keeper. Mr. Everett. Mr. Redding applied to me for the names of 3 Mississippi gentlemen, one of which he said was Wilkinson. I gave him the names, asked him the nature of the difficulty. Later I was told by Mr. Sneed there was likely to be some difficulty, upon which I returned and saw Judge Wilkinson walking up and down the bar room very much excited. Redding was addressing the judge. Tried to get the judge away, and asked him to go with me to his room, which he did. We found his brother, Mr. Murdaugh, there. The judge asked me if I had pistols. I said no, and he asked me to get him some. Said I would try, and went down to the bar. In about 10 minutes saw the judge enter the bar room, and I then put on my hat and walked out of the house. His room was on the first story above, room 35. The bell had not been rung for supper when the judge came down to the bar room the second time. It rings for supper at 5:30 or near 6 o'clock. I saw no part of the affray when the judge re-entered the bar room. I picked up my hat and went away. The difficulty was over when I returned. Cross-examined. There was a good deal of excitement. There were many strange faces in the bar room that evening. When I asked the judge to walk up, he immediately consented, and we went up the public steps. I saw the judge was greatly excited, and I thought it my duty to prevent a quarrel. Did not notice whether Mr. Redding was excited. It is usual for those who are boarding to assemble in the bar room a short time before supper. Only 1 bell is rung for supper. The practice of the house is to collect in the bar room before the supper is ready. Sometimes there is delay, sometimes none. It has been the case that if a person did not rush in, he would be late for supper. It was about 5 o'clock when I noticed those strange faces in the bar room. Redding first came to the Galt House to ask for the names about 4 o'clock. The affray took place about 6 o'clock. Mr. Sneed told me there would be a difficulty. On that account I wished to take the judge away. I did not infer danger from any particular person or collection. Did not hear Judge Wilkinson, on reaching his room, exclaim, "Great God, we claim from you the means of our protection." Meeks, Rothwell, Johnson, Holmes, and Oldham were not frequenters of the house. Monahan was often at the house. Mr. Rhea is sometimes there. From what I've heard of the affair at Redding's store, the assembly of persons, and the words between Redding and the judge, my apprehensions were excited. Mr. Marshall Hulbert was boarding at the Galt House at that time. If the affray had not happened at Redding's shop, the assembly of strangers in the bar room of the Galt House that evening would not have attracted my attention. Judge Wilkinson had been at the Galt House many times before, had always been a retiring gentleman of inoffensive manners. A number of boarders who did not lodge in the Galt House assemble in the bar room for supper. Other citizens assemble there to hear the news and look over the book of arrivals. John Lucas. Am one of the city officers that arrested these gentlemen. I did not see any of these knives at the time. Robert Pope. Was in the Galt House that evening, boarded there at that time. There appeared to be a great deal of excitement. Many persons in the bar room not usually there. was behind the counter when Redding came in with a paper in his hand and pronounced Judge Wilkinson a damned rascal, liar, swindler, and murderer. Shortly after the judge entered, he came towards the counter where the glasses and decanters were to take a glass of water. Redding said he was the gentleman who struck him in his shop that evening. The judge said he would not fight him or quarrel with him, but if he touched him or laid a hand on him, he'd kill him. Redding then called him names and abused him. The judge walked up and down the room and then left it. Later, Judge Wilkinson returned into the bar room with Murdaugh and the doctor. Murdaugh came towards Redding, and Redding remarked, "You are one of the damned rascals who attacked me at the shop with a bowie knife this evening." Murdaugh said, "If you say I attacked you with a bowie knife, you are a damned liar, and if you touch me, I will cut your guts out." Someone caught Murdaugh's hand, and the fight commenced. Blows were struck at Murdaugh, and the crowd closed up as they passed round towards the dining room door. Immediately after, I saw Judge Wilkinson standing in the doorway with a bowie knife in his hand. Rothwell was standing a few feet from the door. The judge looked a moment and then stabbed Rothwell under the shoulder. Rothwell was stooped a little, not as if fighting, but leaning over someone down on the floor. Instantly a fight commenced with raised chairs, and the crowd moved out of the room into the passage. I saw the knife enter Rothwell's back. His back was full toward me. I did not think Rothwell was doing anything at the time. He was 5 or 6 feet away from him when the judge stabbed. The fight began with the altercation between Redding and Murdaugh. When Murdaugh came up to Redding, he had his knife open in his hand, a Spanish dirk knife. Did not see Mr. Meeks killed. I saw him afterwards lying on the floor, and perceived that he was stabbed in the belly. There was a short cowhide, or something that I took to be such, lying by his hand. My impression was that he had struck Mr. Murdaugh with that cowhide, which caused him to be stabbed. He was expiring when I looked at him, and in a moment died, almost instantly, as I looked at him. Cross-examined. Was at the hotel for supper. Generally went into the bar room 15 minutes before supper. When Murdaugh's hand was caught, and he went towards the dining room door, I saw some blows given at him, but could not say by whom. The crowd closed them up so. Had an impression that someone was using a stick at Murdaugh. Appeared to me that Rothwell was not interfering, but leaning over something. Murdaugh had his knife drawn in his hand before any blows were struck at him, when he came up to Redding, and Redding said, "You are one of the men who struck me in my house." I saw only 2 weapons, Mr. Murdaugh's and Judge Wilkinson's. William Johnson. On Saturday evening, went into the Pearl Street house, kept by Redding's brother, who told me Jack was irritated at what had occurred at his shop. Saw Mr. Rowland, Captain Rogers, and Mr. Norris there. Someone said the Mississippians were damned rascals and ought to be punished, and somebody else said there was a regular course to be taken. Redding said he had no one to go with him to the mayor's office, and I volunteered to go with him. Mr. Pollard refused to give a warrant without the names. Redding called to Mr. Rothwell's and took him along to hunt for the names. Overtook Mr. Deering, and he went along with me. I went on to Jack Redding's and learned Redding and Rothwell had gone to the Galt House for the names. Went to the bar room and saw Rothwell standing at the fireplace with his back to the fire, and saw Redding at the counter getting the names. Invited Rothwell to come over to the city saloon and have something to drink, but he refused, saying he had taken something at the bar. Went myself and took Oliver and Meeks over, and we met Taylor at the door of the saloon, and we all went in and drank something. Taylor, Meeks, Oliver, and I then went back to the Galt House. It appeared as if some excitement had been going on there. Redding was leaning on the counter, relating some circumstances, and Mr. Murdaugh came in. The damned lie passed between them, and Murdaugh struck at Redding, and made 2 or 3 blows at Meeks, who struck him with a whip or cane. They were then crowded toward the dining room door, and I saw Murdaugh strike at Meeks with his knife. Saw Judge Wilkinson make a thrust at Meeks too, and shortly after observed him fall dead. The judge retreated back to the counter from which he had approached Meeks, and by the time he got back, Meeks fell dead. After Meeks fell, Murdaugh tried to escape out of the door, and the judge passed between the dining room door and Meeks' feet, as if to make his escape after Murdaugh. The doctor was down in the other corner, and Holmes beating him with his fist, and Rothwell leaning over Holmes saying, "Peace, gentlemen, for God's sake," and trying to get Holmes off the doctor. When the judge got to the door, seeing the fight in the corner with his brother, he turned back and made a lunge with his bowie knife at Rothwell, whose back was to him. Murdaugh and the judge made their escape, and the doctor got disengaged and made to the door, when Oldham was entering, and the doctor struck at him with his knife, and Oldham sort of shrunk from the blow, when the door closed and I saw no more. Cross-examined. Did not see Meeks and Redding together at any time. When I proposed to Meeks, Oliver, Taylor, and the others in the saloon to have something to drink, I did not say, "Come, boys, let us take a drink, and then let us go over and give these fellows hell." After these gentlemen were put in jail, I did not go from house to house proclaiming that they ought to be hanged. Many persons asked questions, and I told them what I had seen, but always said, "Let the law take its course." At the barroom, think Meeks struck at Murdaugh first with the whip to keep him from using his knife. I had no weapon myself, did not invite anyone to go to the Galt House. Meeks was a small man. Mr. Trabue. Boarded at the Galt House. Was in the barroom near the fire, when someone observed that had not the Mississippi gentleman gone upstairs, they would have been badly treated. Judge Wilkinson came in and walked backward and forward 2 or 3 times, greatly excited. Redding then entered and crossed the judge's path. When Murdaugh entered, he was the first that spoke, saying, "I understand you say that I drew a bowie knife on you. If you say so, you are a damned liar." Mr. Redding said, "I don't know that you are the man, but one of the 3 did." Mr. Murdaugh replied, "If you or anyone else say it was I, it is a damned lie." A little man, whom I knew afterwards to be Meeks, came up and said, "You are the damned little rascal that did it," and he struck at Murdaugh with the whip. About the same time Rothwell struck Murdaugh, who had his knife open in his hand when he was first struck at. The crowd closed up on them, and they were hurried towards the dining-room door. Shortly after, I saw the judge stabbing about with his bowie knife. Murdaugh, Meeks, and Rothwell were in the middle of the scuffle when the judge made toward them, and I saw him stab Rothwell in the back, or toward the side. Rothwell made a slight shrink on getting the stab, and sort of turned round to see who struck him. As soon as I saw Judge Wilkinson stab Rothwell in the back, Dr. Wilkinson was knocked up against me, and some time after, Holmes had the doctor down, and raised his head with one hand to strike him with the other. Halbert came up and addressed Holmes, saying, "You have beat him enough," helped to separate them, and the doctor made his escape. Saw the judge and saw a bowie knife glistening. They got out into the passage. Heard a pistol fired. The same moment saw Meeks drop dead. Rothwell came in with the blood flowing from his wound. He took off his coat with some assistance. Holmes and Dr. Wilkinson were fighting in the left-hand corner. The judge, Rothwell, and Halbert were fighting in the right-hand corner. My impression is that as Rothwell turned, the judge made another stab at him, but am not certain. Saw him repeatedly stabbing about with his bowie knife. No person was then molesting him. Had not discovered the doctor till I saw Holmes beating him. Would have seen more of the fight between Meeks, Murdaugh, and Rothwell had not Dr. Wilkinson been struck up against me. I did not see Rothwell again until he was walking from where Meeks fell toward the passage through the door. The pistol was fired, and he turned into the room bleeding. At that time the room had been cleared. Cross-examined. Someone besides Meeks struck at Murdaugh. Have an impression it was a large man like Rothwell with a stick or cane. Thought it was a polished steel cane that Meeks struck with. When Mr. Murdaugh was struck, he was warning them not to strike him. His words were, "It is reported that I drew a knife on you, and if anyone says I did, he is a damned liar." Meeks came up and said, "You are the damned little rascal that did it," and with that struck at Murdaugh. Don't think there were 5 men in the house that did not expect a difficulty. It was considerably talked of all the evening. The only weapons I saw were the 2 knives, the whip, or what appeared to me to be a polished steel cane. When Murdaugh was struck with that cane, it wounded his head. I do not think it possible that anyone could see everything that occurred. The terror was so great that people fled from it. Mr. Montgomery. I saw the affair at Redding's shop. Was passing and saw 2 or 3 gentlemen engaged in the doorway. Redding appeared to have turned back on the pavement. Murdaugh was on the pavement too, and he had a drawn knife in his hand. Redding said if they would lay aside their weapons, he would whip the 3 of them. Murdaugh said he could not begin to do it, pointing his knife at him. Judge Wilkinson then came up and took Murdaugh away. It was between 3 and 4 o'clock. At the Galt House, saw Redding getting the names. He was using very rough language. Mr. Halbert said there would be rough work with the Mississippians. Meeks was near Redding, who was addressed by Mr. Murdaugh. Rothwell was next Redding. Murdaugh had his drawn knife in his hand and said if anyone said he drew a bowie knife, it was a damned lie. Meeks said he was the damned little rascal that did it, and struck at him. Murdaugh tried to use his knife, but his hand was seized, and he changed his knife into the other hand and made a stab at Meeks, and cut him in the belly, and his blood shot out upon my pantaloons and vest. I saw the judge thrust his bowie knife into Rothwell's back. The crowd dispersed, and the judge backed out toward the passage. I turned and saw Holmes pounding Dr. Wilkinson heavily. Halbert said to him, "Bill, you have beat him enough," and he and others took hold of him. Saw the judge again appear at the door and make a stroke with the knife at Holmes. I did not see the judge stab Rothwell more than once. The judge was using his knife freely. Did not see any one attempt to strike him till after he had struck Holmes with his knife, when Holmes and Halbert raised chairs against him. I, too, raised a chair. Cross-examined. Heard several say they would beat them well. The Mississippians were not in the room at the time. Thomas Riah. Was drinking at the bar when I saw Redding talking to Rothwell. In a few minutes I saw Holmes. Redding was in conversation with Rothwell, and I think with Halbert. Turned to Mr. Johnson and asked him if anything was the matter. He said yes, and told me about the difficulty at Redding's store. Remarked that if the Mississippians fell into the hands of these men, they would fare rather rough. Yes, replied Johnson, they would skin them quicker than I could skin a sheep. Heard Mr. Miller say to Mr. Redding that if he'd get the names, he'd attend to the matter in the grand jury. Shortly after, a gentleman came in, and Redding turned to him and said, "I believe, sir, you are the gentleman that struck me with the poker." He turned round and said, "Yes, sir, I am." Mr. Redding then used very rough language when the judge said, "Go away or I'll kill you." The judge then walked the room and passed out to meet Mr. Everett in the passage. He returned again and walked across to the dining room door. Think he had his right hand in the left-hand pocket of his coat. A gentleman with a drab overcoat came toward Mr. Redding with a knife in his hand. He addressed himself in this way: "Sir, do you say I drew a bowie knife on you? If you say so, you are a damned liar." Redding said, "I don't say it was you, but one of the three." Meeks came up and said, "You are the damned little rascal," and think he was making the blow with his whip as he said the words. Saw Mr. Meeks stagger to the northwest corner of the room, saw him struck with a dirk and then fall. At the same time, saw a fight in the southwest corner, and Judge Wilkinson at the door striking the first blow at Rothwell, but it did not seem as if the blow could reach him. But as he turned a little, the second blow did, and it appeared as if, at the time, Rothwell was in the act of taking off Holmes from Dr. Wilkinson. Cross-examined. Rothwell took no part in the fight between Meeks and Murdaugh. Meeks seemed considerably excited when I first saw him that evening. Judge Wilkinson struck 2 blows at Rothwell. Mr. Redmond recalled. Passed the Galt House on my way home. I heard pretty loud talk inside, which induced me to enter. Mr. Redding was abusing Judge Wilkinson, who remarked he did not want to have anything to do with a man of his profession, and if he laid hands on him, he'd kill him. Mr. Everett, catching his arm, told him he had better go to his room. He went out, and in 10 or 15 minutes he returned, accompanied by Mr. Murdaugh. Mr. Redding said, "You are one of the gentlemen who drew knife on me." Murdaugh said, "You are a damned liar." Meeks said, "You are, I saw you myself." Murdaugh replied, "You are a liar," and made a pass at him with his knife at the same instant that Meeks struck him with his whip. Someone caught Murdaugh's right hand, and he changed the knife into his left hand, and the second thrust he caught Meeks in the belly. Meeks staggered backward and fell toward the counter. Was then making my way out of the room pretty quick, and as I was going by the crowd, saw Holmes scuffling with the doctor. The doctor had a knife in his hand at the time. Rothwell was leaning over Holmes, begging him to get off. Holmes said, "Let me hit him one more blow." Judge Wilkinson was at the door and made a thrust at Rothwell, and stabbed him over the hip when Rothwell straightened up and exclaimed, "Oh, I am cut," and the judge retreated out of the door. Cross-examined. Did not tell a journeyman tailor who works for Mr. Davis what was to happen at the Galt House. I told him what had happened at Redding's shop. When the doctor lay on the floor, he was pretty well used up. From the way Holmes had him fixed, he had no chance of using his knife. Was in Mr. Redding's employment at the time. James W. Garrison. Was at the Galt House that evening. Heard Redding tell a gentleman that Judge Wilkinson was one of the persons who had attacked him at his own house, and that they were cowardly fellows. Heard the judge say to Redding, "I will not fight with a man of your profession, but if you interfere with me, I will kill you." I said to Redding that if I was in his place, I would not interfere with these fellows. Another person observed, "Yes, I would get their names and put them under city authorities." Redding replied that he had got or would get their names. In 10 minutes the judge returned and walked across the room with his right hand in his coat pocket. Murdaugh then spoke to Mr. Redding, and he turned round and said something very short to him in reply. Directly the damned lie was given to what Redding said. The crowd closed on them, was outside the crowd and did not see the knives, saw blows struck, but could not tell upon whom. Thomas A. McGrath was in the Galt House on the evening of this fight. When Judge Wilkinson came into the room, Mr. Redding addressed the judge in this manner. "Sir," said he, "I believe you are the gentleman who struck me with the poker in my house this evening. And you are a damned rascal. And if you will come into a room or the street and lay aside your weapons, I'll whip the whole three of you." The judge walked up and down the room with his hand in his pocket, came to the counter and took a glass of water. He then said to Redding he would not quarrel or fight with a man of his profession, but if he would interfere with him, he would kill him. Advised Mr. Everett to take the judge to his own room, and the judge left the barroom. Later the judge, Mr. Murdaugh, and Dr. Wilkinson entered the barroom again. Mr. Murdaugh came forward toward Mr. Redding, who said to him, "Sir, I believe you are one of the men who drew a knife on me at my house this evening." Murdaugh said, "Sir, I understand you say I drew a bowie knife on you, and you are a damned liar if you say so," opening his knife. In a moment the crowd got round them, and they moved down the counter. I could not well see what was doing. Redding moved down with them, could see in the crowd that blows were passing, but could not discern who gave or received the blows. Saw a knife with Mr. Murdaugh, and observed him striking with it, and thought he had killed Mr. Redding when I saw a man fall. After that there was a general fight through the room. Saw Meeks fall, but did not see the knife enter him. The first I saw of Judge Wilkinson after the fight began, he was standing near the dining room door with his back to the door, a little stooped and holding his arm above with a bowie knife, 6 or 8 inches in the blade in his hand. He held his arm and the knife in his hand rather above the heads of the crowd, as if to make a passage. He passed through the crowd to the door, and turned and faced into the room. Then I saw him take a jump forward and make a thrust toward where Holmes, or Rothwell, I could not tell which, was engaged in the fight with Dr. Wilkinson. He returned from the blow and jumped forward, making another thrust, and again returned. And as he lunged forward the third time, Marshal Halbert took up a chair and told him to keep back, though I do not think he could have reached him with the chair from where he stood. Cross-examined. Have known Judge Wilkinson for 3 years. Have heard a good many gentlemen speak of him before and since this transaction, and have always heard him spoken of in the highest terms. Have been in the South this winter, and in his neighborhood, and have heard him well spoken of there. Footnote. This question was irregular. It was not a matter of cross-examination. After the Commonwealth closed, the defendants had a right to prove their good character. But as no objection was made, it was properly allowed. What has been his general character is too broad. The law requires, in such a case as this, that the inquiry should be confined to the defendant's general character for peace and humanity, or the reverse. Note by reporter. Have made clothes for Judge Wilkinson, and he has always treated me civilly. When in the South this winter, I heard a letter spoken of there as having been written by Judge Rowan about the judge. There was a great excitement, but cannot say it was caused by that letter. A great many gentlemen spoke to me about this trial. James W. Graham was passing the Galt House about dusk, and saw Mr. Redding and Mr. Rothwell crossing the street alone. Mr. Rothwell, probably ahead of Mr. Redding, slapped Mr. Redding on the shoulder and thought there was something singular about his countenance. He turned round and shook hands with me. Cross-examined. It was something unusual in Mr. Redding's countenance that caused me to take notice. Do not think there was any person in the street within a square of them at the time. Dr. Knight. I did not examine the wound on Mr. Meeks. I saw it, but he was dead. Examined Mr. Rothwell. He had 3 wounds, one between the 11th and 12th ribs, the second through the 7th rib, separating it. Both wounds were through the spleen. There was a 3rd wound in the chest near the collarbone, down to the right lung. Consider the wound in the chest caused his death. The wounds in the spleen contributed to death. The wounds through the spleen were made by a large knife. That in the chest by some small instrument. It was not by a bowie knife. It was a very small puncture, made by a very small instrument, about 6 or 7 inches in length to where it penetrated. The wound was about as broad as the blade of this knife, and to the depth of from 5 to 7 inches. Cross-examined. The wound in the chest caused the death by suffocation. It is hard to tell what might have been the effect of the wounds in the spleen. It is not a vital organ, but wounds leading to inflammation might prove fatal. Dr. McDowell. Am of opinion that all the wounds in Rothwell contributed to death, but the immediate cause was from the puncture on the right side. The other 2 wounds, in conjunction with that, contributed to death, and in fact accelerated it. Cross-examined. The puncture would not have caused death of itself. The lobes on one side afford sufficient respiration to sustain life. Both wounds penetrated the cavity of the abdomen. The puncture on the right side must have been by a very slender instrument, not more than half an inch in width. The lung was not penetrated. The puncture of the skin was very small, as with a dull blade. The perforation was from a third to a half an inch in breadth. As to the wounds in the left side, by process of inflammation, it might cause death. By process of suppuration, the patient might recover. Cross-examined. On attending Judge Wilkinson in jail with my partner Dr. Pyle, his attending physician, I saw his wound, supposed to be 3 or 4 inches, extending from near the shoulder blade towards the spine. It must have been the puncture of a very slender blade. Mr. Murdaugh's head had been dressed, and the adhesive plasters were not removed. Dr. Wilkinson's face and head were greatly bruised, his eye much discolored, and his eyes swollen till nearly closed. Witnesses for the defense. Mr. Jackson. Was passing Mr. Redding's in the evening. I heard some loud talking. Went in and saw Johnson, Redding, and Meeks. Johnson said to Redding and the others that they ought to go to the Galt House and flog them. He asked Redding to do so, but Redding did not say anything. Johnson said, "Jack, just say the word, and I'll go for my friend Bill Holmes, and we'll give them hell," and said he had as much manhood as ever was wrapped up in so much hide. Meeks said, "Let us go anyhow, and we'll have a spree." Redding said, "No, I'll see them another time and get satisfaction." Some time after he met Mr. Johnson in the street, he stopped me and said, "I am going after Holmes, and think you ought to come to the Galt House. That Jack Redding was a fine man and a good citizen, and that we ought to see him righted." I refused. I was not a man of that character, and I would do my own fighting and let others do the same. When he saw I was not a man of that character, Johnson said, "Church, hell, or heaven ought to be laid aside to right a friend." I told him he had better not have anything to do with these men. Meeks was not with Johnson at the time. Cross-examined. From Johnson's talk, I believe that a fight was intended. I heard Johnson talking loud. The hard words brought me into the shop. Redding discouraged the idea of Johnson. I observed Meeks appeared to be excited, and directed his conversation to Mr. Redding. E.R. Deering. Was passing down Market Street about sundown. I saw Johnson, Holmes, and others talking about Mississippi gentlemen who had treated Redding very badly. Asked Johnson what was the matter. He said he wanted officers to assist them, and I said he'd be late to get officers. He said there was enough gone there, and if they came down their hides would not hold shucks. Curiosity afterwards brought me to the Galt House to see what was going on. Found a good many persons in the bar room. Saw a gentleman with a drab coat coming in, and heard Redding say he was the gentleman that drew his knife. He said, "If you say so, you are a damned liar." Meeks came up and said, "You are a damned little rascal," and struck at Murdaugh with the whip 2 or 3 times. I then left. Johnson seemed much excited. He said the Mississippians ought to be taken out and get a genteel flogging. Mr. Holmes is a very large and stout man. Knew him for 5 years when I was captain of the watch. Considered him a very peaceable man, though reputed one of the stoutest men in Louisville. Halbert and Oldham are large men. Alfred Harris. Met Johnson near my own house that evening with Mr. Schoen. He told him about 3 Mississippi gentlemen who had insulted Mr. Redding, whose friends go to the Galt House. He asked me to go. I said I would not. He said, "Are you a friend of Mr. Redding's?" I said yes. There was no man I felt more friendly to, but if he had been assaulted, as he stated, the law was at his side, and that thing was so far past now that it was not worth while to go. He said, "Then you won't go," and I said I would not. Heard no more of it till next morning. Benjamin Oliver. Heard Meeks proposing to go to the Galt House. I thought to stop him. He had his knife out, and I said to him, "Mr. Meeks, give me your knife to cut my nails." He gave it to me. He said he must go to the Galt House, for he was bound to have a fight that night, and by God he'd have it. He went, and in some time came back and asked for the knife, and I gave it to him. Some time after he came over again, and wanting to get the knife, afraid he'd get into some scrape. I said it was strange he would not lend me his knife to pare my nails after so long an acquaintance. He said, "My dear sir, I thought you had done," and he gave me the knife. He then started for the Galt House, saying he was bound for the Galt House that night and would go. He went. When I entered the Galt House, I went into the bar room and saw that he was dead. Saw Mr. Holmes was wounded, and a doctor tying up his arm. Saw some fuss towards the stairs, and a chair moving in the air. Meeks was a small man. He had been keeping bar for Mr. Deweese. Mr. Miller. Heard that an affray had taken place, and being on the city grand jury, thought I would inquire about the matter. Went into the shop and asked for the names of those who had seen the fray, and got those of Craig and Redmond. Halbert came in and said a good deal of what he'd do. Went home and remained for some time, and then went to the Galt House to my supper. Someone said I ought to leave the room, or I'd see beefsteaks served up. Shortly after I heard, there they are, all three of them, and the crowd gathered to the counter. I left the room. While there, I heard a pistol fired. When I returned, the affair was over and Meeks was killed. Think it was Johnson that talked about the steaks. George Wagry was in the bar room of the Galt House talking to Mr. Miller when someone said, "This is one of the men." Someone said to Miller, "We'll have some steak after a while for supper." Another person came along and said, "We'll have a hell of a fight here just now." Miller advised Halbert to take away Mr. Redding. Shortly after, I saw the three men enter, and when the damned lie was given, I saw Meeks strike at the smallest, and saw dirks and knives and canes in the fight. Some time after, I saw Rothwell come round and blood flowing from his wounds. They all were strangers to me on both sides. General Chambers. Going into the bar room of the Galt House, I observed persons that I was not in the habit of seeing there. This created in my mind some suspicions. Shortly after, Redding made use of opprobrious language to Judge Wilkinson, and the judge said, "If you lay your hands on me, I'll kill you." Heard some angry words, and the affray commenced. One of the persons broke off and got towards the supper-room door, followed by Rothwell, beating him with a stick very severely. Rothwell partly lost hold of his stick, and endeavored to catch a fresh grip, and on resuming his hold, struck it at the person again, when the judge stepped up and made a thrust with his bowie knife at him. Part of the language Redding used was, "You're a damned rascal and a coward and a pretty Mississippi judge." Cross-examined. The judge made the first thrust of his bowie knife at Rothwell near the dining-room door, in the opposite corner from where Holmes had the man down, about 24 feet from the passage. Mr. Donahue was in the Galt House the evening of the affray. Saw Mr. Rothwell and other gentlemen at the fire in the bar-room. Heard Mr. Rothwell ask someone, I think it was Redding, if they were there. He answered no. He then said, "Come, let us go upstairs and bring them down and give them hell." Cross-examined. Did not come back till all was over. Rothwell was lying in the bar-room. I go to the Galt House often. I have some acquaintances there. William Sutherland was in the bar-room. Heard a fuss, and on turning saw a crowd. Someone said there would be a shooting, and I got out of the room and tried to see through the window what was doing, but could not see distinctly. Remained at the window until Mr. Burdock came and got on the stair-steps, when someone struck at him, and he fell forward, but recovered and got up the steps, when someone fired a pistol up the stairs, and I very quick got over the banister. Joseph Brown went to the Galt House for supper. Saw General Chambers sitting at the fire. Miller was there also. The first thing that attracted my attention was Redding abusing Judge Wilkinson. Remarked to General Chambers that there would be some difficulty. Before this, Mr. Miller said to Redding, "Hush that stuff. It is not the proper way. Get their names and we'll have them before the grand jury." A man stooped down to Mr. Miller and said, "Hush you, Billy Miller. If it comes to handcuffs, the boys will settle it." I determined to leave the room, and as the gentlemen entered, I passed out and saw the crowd gather round them. Near the stairs I met Mr. Everett going out. I could see into the bar room through the window. The crowd was moving about, as if in a scuffle, in a kind of circle round the room by the dining-room door. The first licks I had seen struck were by a large man with a stick. He laid on Mr. Murdaugh. Saw Dr. Wilkinson falling at the left-hand side of the fireplace. The room began to clear, the rush being made into the passage. Retreated to my room and out on the porch, and as I made a turn I saw Mr. Murdaugh was struck with a chair as he ascended the stairs, and Judge Wilkinson also had a chair thrown at him, as someone hallooed, "Shoot the damned rascal," and immediately a pistol was fired. Saw Dr. Wilkinson when he was knocked down near the fireplace. I thought his head struck the grate. Businessmen congregate in the bar-room about the time the stages arrive to learn the news by them, and see the names entered on the register. Martin Rayleigh was at the Galt House. Heard the conversation between Redding and the judge as the witnesses have described. Saw Oldham with a bowie knife, wiping the blood off it with his handkerchief. The stick the big man used when beating Murdaugh was a sword cane. Saw the cane part fall on the floor and the spear part remain in his hand. P.S. Barber. This is a hat I sold to Mr. Murdaugh the day before this affray took place. It was then a sound hat. It must have been cut by some sharp instrument, in the side of the leaf and also in the side. Footnote. A witness had taken this hat from the bedroom in the Galt house and kept it as evidence. James E. Pearson. Went to the Galt house before supper time. Captain Rogers remarked to me that there would be a fight, from the crowd he saw. He asked where Major Throckmorton was. Thought I saw the Major talking to Captain Rogers when I came back into the bar. Captain Rogers asked me, did I know who the persons in the bar room were. I said I knew Redding. Saw General Chambers and talked with him. Rothwell was there with a stick in his hand, and Riaw, Halbert, and Holmes. Judge Wilkinson was walking up and down the room, and Redding abusing him very much, saying he was a pretty sort of Mississippi judge, that he was a rascal, swindler, and assassin. The judge said, my friend, you may say what you please, but I do not fight men of your profession. The judge left the room, and when he returned, there must have been 50 men in the room, which induced me to go to the judge and ask him to leave the room. He made a step or two with me to retire, when about 20 men were crowding in, and we heard some angry words, and the affray began. The judge, turning and seeing this, said, Sir, I cannot leave the room and my friends till I see how the affair with these men ends. Saw a person strike the man with the drab coat, but I think it was Rothwell struck with the stick. Observed some person catch a chair, and first thought he was taking up the chair to fight with, but soon perceived he was only leaning on it for support. Saw Meeks attempting to stagger toward the counter. When about halfway he fell forward. He was the person that had the cowhide. Saw Judge Wilkinson make a stab from the doorway towards Rothwell. I think the stab was past Rothwell at Holmes, who was engaged with the judge's brother. Holmes had his arm badly cut. The crowd generally goes to the barroom to hear the news and look at the register after supper. The boarders assemble in the barroom generally 20 minutes before supper time, sometimes less. End of section 17.